Court officer.
ಬೇರೆ ಇನ್ನ ಹೋಗ್ತಾ ಇದ್ರು ಅಷ್ಟೇನಾ? ಹಾ
to give effect to any order that he may pass pursuant to the notices which are impugned therein. Senate Council appearing for Bescom submits that the Bescom has no proposal to disconnect existing temporary connections.
Yes, my lord.
Of the petition.
But Bescom will not process the applications which have been filed for grant of permanent power connection
Permanent and fresh connections.
in view of the pendency of the writ petitions and also in view of the fact that the local authorities are contending that the layout is unauthorized.
Not ಏನಾಗಿದೆ?
In the light of the statement of Bescom, the temporary power supply already provided to these structures will not be disturbed. It would be appropriate to refer this, tag this petition along with WP 22050/2023. Petitioners are permitted to make any application that they so desire in the said writ petition.
Yes, please.
Other loan market.
Orders, seal number 9.
Lords, I appear for petitioner in this matter, my lords. My lords, I kindly seek for a pass home. My lords, may I kindly have it at 2:30.
Yesterday's matter, where you lodged,
20.
yes.
Seal number 10. Srimati G.K. Bhavna.
ಏನ್ ಮಾಡ
Charge sheet is not filed against this accused. Your
if the
Worship.
IO makes a statement that they will not go against him, I'll close the proceedings.
Please, Your Worship, but it is better if the complainant also makes a statement that he has withdrawn the complaint as against.
That he
the
has made.
accused.
The problem
IO
is,
is-
except his statement, it will affect the other accused.
As on date, through my details, it is known that none of the witnesses or the other accused have implicated these two accused. Your Worship. So,
But the CGP submits that the investigating officer does not wish to prosecute the petitioners in respect to the complaint that has been lodged with the second respondent. Senate Council appearing for the complainant as well as the council appearing for the petitioners who represents accused number 19 and 20 jointly submit that the dispute amongst themselves have been settled. And therefore, the criminal prosecution as against them will be quashed. The right of the above, the proceedings as against the petitioners shall stand quashed.
Grateful. Seal number 11.
This is for the reporting set, payment of the amount.
They one more time ಕೊಟ್ಟೆ ನಾನು for the
ಅದೇ
application
ಮೊನ್ನೆ
item.
ಕೊಟ್ಟಿದ್ರಿ ಮತ್ತೆ ಅವ್ರು ಇನ್ನ ಕೊಟ್ಟಿಲ್ಲ.
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಒಂದು ಸಣ್ಣ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸ್ವಾಮಿ. ಇದು ಪ್ರೆಸಿಡೆಂಟ್ ಆದ್ರೆ ಸ್ವಲ್ಪ ನಮ್ಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಅದು
I'll make it clear it is not a precedent. You first pay the money, then I'll say it is not a precedent. It's passed in the peculiar facts and in this case.
ಸ್ವಾಮಿ ಇನ್ನೊಂದು ಇದು ಸ್ವಾಮಿ, ದಿಸ್ ಇಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದ ಕಂಪನಿ. ಇದರಲ್ಲಿ ಇಂಡಿವಿಜುವಲ್ ಡಿಪೋ ಮ್ಯಾನೇಜರಿಗೆ ಸ್ವಲ್ಪ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ಆಗತ್ತೆ ಮೇಡಮ್, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಕಾರ್ಡಿಂಗ್ ಟು ಹಿ ಹ್ಯಾಸ್ ಆಕ್ಟೆಡ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಪ್ರೊವಿಷನ್ ಆಫ್ ಎಕ್ಸೈಸ್ ಆಕ್ಟ್ ಸ್ವಾಮಿ. ಇದೇ ಸಿಮಿಲರ್ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ಹುಣಸೂರ್ ಡಿಪೋದ ಮ್ಯಾನೇಜರ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿ ಎಂಟೈರ್ ಸ್ಟಾಕ್ ಅನ್ನ ಇಲೆಕ್ಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಕಾನ್ಫಿಸ್ಕೇಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
I am only concerned with an innocent person getting caught in the fight between the two of you. If you want, you go against anybody else who is responsible for this situation. He had nothing to do with this. He should not be penalized. You could have unloaded this and then taken precautions.
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ
To do with whatever was to happen.
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ MD ಇದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಬಟ್ ದೆನ್ ಡಿಪೋ ಮ್ಯಾನೇಜರ್ ಮೇಲೆ ಇವಾಗ
How do you want me to protect the depot manager?
ಸ್ವಾಮಿ ಒಂದ್ ಸಾರಿ ನೋಡಿ ಸ್ವಾಮಿ, ಸೆಕ್ಷನ್ 14(2) ಆಫ್ ದಿ ಎಕ್ಸೈಸ್ ಆಕ್ಟ್, ಅದು ಇದ್ರಲ್ಲಿ
If you want, I'll exonerate the depot manager saying that he was guided by instructions by the department, which is incorrect.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಅವರು ಸೆಕ್ಷನ್ 14(2) ಮತ್ತೆ ಸೆಕ್ಷನ್ 43(2) ಇದ್ರ ಪ್ರಕಾರ ಇದ್ ಮಾಡಿದ್ದು ಸ್ವಾಮಿ. ಎಕ್ಸೈಸ್ ಆಕ್ಟ್ ಇದ್ದು 2 ಸೆಕ್ಷನ್ ಪ್ರಕಾರ ಇವ್ರು ಮಾಡಿದ್ದಾರೆ.
If you want me to protect the depot manager, I will say that there's no illegality against him. He only acted in accordance with the standing instructions. Therefore, no action be taken against him. But you will continue to pay that 2 lakhs. I'll protect you, but I will not be able to let go of this liability.
ಸ್ವಾಮಿ,
Direction is to the first respondent, managing director.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ MD has given the permission ಸ್ವಾಮಿ
For what?
to release the amount.
So release the amount first.
ಸ್ವಾಮಿ ಇದು ಒಂದು clarification ಸ್ವಾಮಿ. My only apprehension is with respect to this. I'll just ascertain and make submissions.
230.
Till today, he has not even. put
Biಡಿ
the-
ನಿಮ್ಗೆ ಯಾಕೆ ನಿಮ್
the number, they should be concluded on the account, sir.
We are only concerned with the truck
The-
driver, not with you.
The
Sorry.
goods received should be acknowledged there, otherwise there is an offense under section 20, rule 20.
ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ಬಂದಿದೆ ಅವರಿಂದಾಗಿ ಸ್ವಾಮಿ, ಓನರ್ ಇಂದಾಗಿ
And
ನಮಗ್
the-
ಪ್ರಾಬ್ಲಮ್
And there should be one.
I will be
line for the
able to
company.
demonstrate it with the provision of law.
Fast and order.
Only.
Ask me to redo the order.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾನು ಆರ್ಗ್ಯೂನೇ ಮಾಡಿಲ್ಲ. I am just trying to protect the interest of my client.
And I am trying to protect the interest of the person who is aggrieved by this action.
And that has been
You
brought
could
in
also be
place of wholesaler.
cognizant of that fact, that in the fight between the two of you, you squeeze this person unnecessarily.
ಸ್ವಾಮಿ ಅಲ್ಲಿ ಪ್ರೊವಿಷನ್ ಇರ್ಲಿಲ್ಲ.
You are so worried about your employee, about your MD, but none of you have any concern about the truck driver whose truck was stuck there for so many days.
3 months.
ಸ್ವಾಮಿ ಅವ್ರು ಬರ್ಲಿಕ್ಕೆ ಹೇಳಿದಾಗ ಅವ್ರು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
And only when your shoe pinches, you know, but when it pinches others, you are not aware.
ಸ್ವಾಮಿ ಡ್ರೈವರಿಗೆ ಬರ್ಲಿಕ್ಕೆ ಹೇಳಿದಾಗ ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
Very good. But 230.
Please.
Bill number 12, CVR Balraj.
Petitioner, the issue with regard to the supply of a permanent electricity connection. Madam.
My lords, in this matter, my lords, the petitioner has sought for direction on behalf of the respondent to issue for permanent electricity, my lords. However, at the time of construction, my lords, they had taken temporary connection. There's a suit that is pending for declaration and injunction, my lords, where the petitioner herein is the defendant there. And he had also made an application in the court below seeking for the same direction. However, the court below has dismissed the application, my lords, telling that because
Dismissed the application on the ground that, my lord, the efficacious remedy is available to the petitioner. So therefore, the application has been dismissed,
my lords,
not on merits, my lord.
Is the order?
Please, my lord.
order is at page number 33. If I'm
My lord,
not
page
wrong.
number 37, my lord, annexure M.
What is the efficacious remedy that they have?
The relevant portion, my lord, para 12. Further, on perusal of the pleadings on both parties, so many things is transparent between the parties. Therefore, it requires trial to consider this aspect. Moreover, while granting the direction can be given, granted where the parties show very strong probabilities upon the facts that grave damage will accrue to the parties in future. It is jurisdiction to be exercised sparingly and with caution. The court is, the court,
ಇದ್ರ ಮೇಲೆ writ ಹಾಕ್ಲಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ, ಇದ್ರ ಮೇಲೆ
writ ಹಾಕ್ಲಿಲ್ವಾ?
but the observation made with the trial court, the efficacious remedy is available to the petitioner. That is the only reason assigned by the
Made
trial.
that person a party, the plaintiff.
No, my lord.
My lord, the matter is also covered with the decision of this Honorable Court, my lord. If a mere suit pendency between the parties will not affect the rate of the parties while the supplying of electricity
It's not
connections.
for the
concerned.
same relief again in the suit in which the Selvaraj was a party,
Yes, please,
this Nataraj was a party.
please.
If I were to pass an order now,
No, I am seeking only
it
for,
was not granted in the suit filed in Nataraj.
I am seeking only for.
Nataraj will be affected. I am virtually setting aside this order passed in the
My
suit
lord, here-
filed by Nataraj.
He has filed objection stating that, my lord, the mere suit is pending, my lord. Whether he has constructed a house, my lord.
Does Nataraj agree for grant of this permanent power supply? If Nataraj was a party here, I would have said this permanent power supply would be subject to the ultimate result of the suit.
Definitely.
Our party money, I'll consider ಅಷ್ಟೇ.
Make
Without
necessary.
him, I'll be setting aside this order.
I am seeking only, I am not challenging that order, my lord. Not challenging that order.
If I grant you the prayer here, I'm nullifying this order,
Definitely, my lord.
alva?
Yes, please. Make him a, file necessary application to him.
Realist.
Hearing on IEC number 13, CS Balakrishnan.
I have filed the charge sheet.
Complaint.
Complaint charge sheet. On that case, my lord, it is posted for judgment. The entire, the other case, the lordship sought for the complaint. My lord, compilation filed yesterday. My lord, I have produced the entire charge sheet, entire deposition charge, 3 and
Complaint first.
please. My
Page 6.
lord, page number 6 is the complaint.
Then what is the meaning of this?
Lordship may kindly appreciate, in this
This
case,
is a complete deviation from the earlier.
no, my lordship may kindly appreciate. I am a shareholder of the property.
In respect of one offense of this forgery and
But,
impersonation.
my lord,
There are
accused
two-
are not common, my lord. Accused are not common. What is a,
How can you lodge the second complaint then?
blood,
The first complaint.
blood, first complaint is a private complaint. Second complaint, your lordship may kindly appreciate. This is the matter posted for 3 judgment. Blood, both the matters can be clubbed to the magistrate.
Why should we entertain this? You are using the criminal court
No,
for,
I am not using, my lord.
you first file a PCR,
Please, my lord.
you are prosecuting it,
Yes,
then you lodge a police complaint in which.
not
that is
against the
said-
same parties.
The offense is the same.
Please, please, my lord. My lord, what is,
In the offense that is same. You are.
no, I do not know who was the person who you, lordship may kindly appreciate. The petitioner in
ಎರಡು ಕೇಸು ಹಾಳು ಮಾಡ್ಕೊಳ್ತೀರಾ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ.
some, I'll make a detailed submission on that. I'll file a synopsis. Kindly have accommodations. One matter is posted for judgment. Another matter,
ಯಾವ ಮ್ಯಾಟರ್ ಜಜ್ಮೆಂಟ್ ಹೋಗಿದೆ?
either matter, Sami.
Sarojama madam.
Sarojama case, it has gone for judgment. The other matter gone for 313 statement. My submission is,
Then I'll recall this order and keep this petition pending,
please, my lord.
your petition. on 26th of June 2024. This court disposed of this petition, directing the trial court to make every endeavor to dispose of the matter within a period of 6 months from the date of receipt of a copy of the order. The basis for this order was that the proceedings were pending before the criminal court in the year 2016. Notices of this petition was dispensed with, since the only prayer made in the petition was for an early disposal. Subsequently, an application has been filed by respondent ನೀವು?
Second respondent.
The recall application filed by the petitioner, my lord.
Second respondent.
By the second
Top
respondent
petitioner.
ಇಲ್ಲ, ನಿಮ್ಮ application ಅಲ್ಲಿ seven
for recalling of the order. In this
Yes.
application, it is stated that the second respondent had in fact preferred criminal petition number 10736/2023, and in that petition, this court had granted him an interim order. It is obvious that since there was an interim order granted in criminal petition 10736/2023, insofar as the second respondent was concerned in respect to the same criminal case, the magistrate would not be able to dispose of the said petition. Since the order passed in this petition contradicts the order passed in criminal petition 10736/2023, this petition, the order dated 26th of June 2024, is liable to be recalled, and it is accordingly recalled. I'll dispose of saying that I can't do it because of the.
Please,
disputes.
please.
Since it is also forthcoming that there's an interim order granted in petition 10736/2023, the direction sought for the petitioner for an early disposal cannot be granted. The criminal petition number 2995/2021 is therefore disposed.
Deserving the liberty to move once that petition is disposed of. Liberty may be.
Reserved to the petitioner to take such appropriate steps as he may deem fit in the matter for securing an early disposal.
Please.
Number 14.
For the petition in this case.
Lord, Lord, 1962.
My lord, one
I'm-
submission.
My lord, before my learned friend starts, even if we have a semblance of right in this property,
ಮಾಡ್ಕೊಬಿಡ್ರಿ ಫಸ್ಟ್ ನೋಡೋಣ ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ.
please,
ಸೊ
the reason is
ಇಲ್ಲ,
this.
ನಾನೇನು ಹೇಳ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, ರೆಕಾರ್ಡ್ ಬೇಕು, ಗೋರ್ಮೆಂಟ್ ಅವ್ರು ಕೇಳಿದ್ರೆ ರೆಕಾರ್ಡ್ ಇದೆಯಾ ಅಂತ, ನಾನು ಅದನ್ನ ರೆಫರ್ ಮಾಡೋದು, ಅವ್ರ ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಹೇಳಿ.
My lord,
ಅದನ್ನ ಗಮನಕ್ಕೆ ತರ್ತೆ ಅಷ್ಟೇ.
ಅವ್ರ ಪರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ.
it's straight
Sorry.
away covered by your lordship's
Sorry, my lord.
judgment, my lord.
ಚಾಲೆಂಜಿಂಗ್ annexure J.
Please, my lord.
What is annexure J?
My lord, annexure J is the, my lord, order passed by the special deputy commissioner for having taking the position of certain lands. My lord, this matter pertains to Urban Land Ceilings Act, my lord, which is repealed. My lord, 1962, I have purchased certain extent of property, my lord, you'll get it at,
Let me have a look at annexure J.
please, my lord. It's at page 74, my lord. ಯಾವ್ದು? 1/3, my lord, 1/3 and 1/5. My lands are 1/3 and 1/5.
Twenty-six thousand 299 square meters.
Please, my lord.
Then what happened after this?
My lord, this, how I got to know the land is acquired, is this, my lord. My lord, it so happened, my lord, on my lord, I filed an OS to partition my property along with the family members. Your lordship will get it at Annexure D.
Next year,
Annexure D, my lord. Annexure D, page 32, my lord. We filed a partition suit which came to be decreed in terms of the compromise petition. My lord,
what is your name?
my name is Hanumantappa D. I am the defendant and Madevaya. Defendant number 2.
It was in 2006.
2006.
Yes.
My lord, there after 2006, my lord, the entire revenue record.
What is Dasappa? Dasappa is
Father.
your father.
Please, my lord.
He had filed the declaration.
Please, my lord. He had filed the declaration.
And the notice of this declaration was given to you.
This
In page 75, it says,
please, my lord.
only a draft statement was prepared and got served on the son of the declarant,
Please, my lord.
19/11/85.
Please.
No
That's-
objections were received so far.
No. If your lordship may kindly see, after the sale deed, after the partition of the property, the entire revenue records till 2013 are in my name. Then in 2013, how I got to know this is, my lord, if your lordship may kindly turn to Annexure H, page 70. The typed copy is at 71. ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಹೋಬಳಿ ಚನ್ನಸಂದ್ರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 1/5, ಸರ್ವೆ ನಂಬರ್ 1/3 ಜಮೀನು ನಗರ ಭೂ ಪರಿಮಿತಿ ಕಾಯ್ದೆ ಅನ್ವಯ ಈಗಾಗಲೇ ಮಾನ್ಯ ವಿಶೇಷ ನ್ಯಾಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಇವರ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಅಂತೆ ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಅಂತೆ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಅಂತೆ ಚನ್ನಸಂದ್ರ ಮೇಲ್ಕಂಡ ಜಮೀನುಗಳನ್ನು ಸರ್ಕಾರದ ಸುಪರ್ದಿಗೆ ತೆಗೆದುಕೊಂಡಿರುವ ಜಮೀನುಗಳನ್ನು ವಿಭಾಗ ಮಾಡಿಕೊಂಡು ಮಾರಾಟ ಮಾಡಿರುವ ಬಗ್ಗೆ ತಿಳಿದು ಬಂದಿದೆ. ಈ ನೋಟಿಸ್ ಜಾರಿಯಾದ 3 ದಿನಗಳೊಳಗೆ ಕಚೇರಿಗೆ ಹಾಜರಾಗಿ. This is the notice. Therefore, then I got to know this land is acquired. If your lordship may kindly see, after that, a petition is filed. Now, my lord, the question is whether the position was taken under 10(6). The return statement, objections filed by the state.
What is the objection of the state?
Objection of the state is that, my lord, the position was taken by the revenue inspector or revenue officials, not by the competent authority. So lordship may kindly turn to para number 4 of page 3. It is submitted that in fact the consequent commencement of the Urban Land Ceiling Act, the land question had come to the provisions of the act and accordingly. The Special Deputy Commissioner Bangalore having held the inquiry into the matter with regard to survey number so and so, totally measuring so and so, by his order dated 7/3/1988 and confirmed the excess area already determined to the extent of so and so held by Hanumantappa, the petitioner. In view of the above fact, the circumstances and also the position has been taken over by the revenue officials. Your lordship, in the case of my lord, please, my lord, in the case of Gouda Siddhappa Patil in WP number 110109.
Please produce notice.
My lord, I have filed it, my lord. File court of ಇದೆ open court ಅಲ್ಲಿ court judgment ಆಯ್ತು ತಗೊಳ್ಳಿ ಇದಕ್ಕೆ. ಈ ರಾಮಚಂದ್ರ ಯಾರು? ದಾಸಪ್ಪನ ಮಗ.
The position was taken by the revenue officer, revenue inspector. There is. No, but if you have not taken position, the repeal will help him.
Position is not taken, award is not passed, no.
Where is the major taking position?
It's not there.
Like produce ಮಾಡಿದಾರೆ ಅವ್ರು. You said the position was taken by the.
Position not taken. They say that in the
There is
objection.
that document.
Deputy Commissioner.
ನಿಮ್ದೇನ್ interest ಇದ್ರಲ್ಲಿ?
Melody, this entire land, including other land, one housing society formed the layout. And housing society asked for.
Who gave you that land?
Allotment of this.
From whom?
So it's society.
How did the society get that land?
Society, well, as per the, my vendor of that society, they have taken land from this owner. According to the
I just,
If the ULC Act is repealed, should any of your benefits, you will also lose the land.
my lord, before my learned friend starts,
Sitting act. Land.
If I dismiss the writ petition, your land goes.
I have no any objection to rest the land with the government.
my lord, you,
Because of, they were impeded and harassing because of this.
All right, buddy, you have no locus stand in this case.
if your lordship may kindly see, my lord,
Invested my hard-earned money, because therefore, my lord.
Either you should support the petitioner.
No.
If you are opposing the petitioner,
Please,
you have no right to argue this matter.
my lord,
You are
my-
claiming under the petitioner,
my lord, my representation,
you are claiming under the petitioner.
no.
You are saying
he is claiming under the, if
You're
your lordship
saying-
may kindly take out the,
petitioner sold the property to the society, society in turn allowed the site to you. Your title emanates from them.
My lord, as per the, once the land.
They allegation ಬೇಡ.
Land wasted government.
ಬಿಡಿ, ನಿಮ್ದೇನೋ ಬೇರೆ interest ಇದೆ.
my lord, if your lordship may kindly take out the impleading application for a moment.
No.
For a moment, my lord,
ಬಿಡಿ, ಅವ್ರು ಬಿಟ್ಬಿಡಿ. Just show me the document under which position was taken by the revenue inspector.
ನಿಮಿಷ ಅವಕಾಶ ಕೊಟ್ರೆ ಆ record ಅಲ್ಲಿ.
ನಿಮ್ಗೆ ಅವಕಾಶ ಕೊಡೋದ್ ಬೇಕಿಲ್ಲ, ನಿಮ್ಗೂ ಇದಕ್ಕೂ ಕೇಸ್ ಸಂಬಂಧ ಇಲ್ಲ.
my lord,
Position by deputy commissioner has been taken.
he can't say that.
He will justify that.
If your lordship may kindly take out the impleading application for a moment.
ಅವ್ರು ಬಿಟ್ಬಿಡಿ, show me the
Please.
document under which position is taken.
Yeah, documentary. Lord, that the government, it's in the government file, my lord.
That government file ಅಲ್ಲಿ page 86, 87, 88, 89 ಅಲ್ಲಿ all section 10 file ಅಲ್ಲಿ position has been taken by the deputy commissioner madam. And sketch has been prepared madam. And my lord, draft statement prepared by the section 83 served on the, this is same petitioner, D. Hanmantappa. He made a signature on that.
I don't understand why my learned friend is arguing this. He is,
Served on the D. Hanmantappa madam. And the same has been gazetted and 10-3.
Madam, where have you said that the position was taken by the competent authority in your objections?
And my lord, suppressing all these facts, they filed a suit for partition that has been come to the knowledge of their department. They have.
In the impleading application allow ಆಗಿದೆಯಾ?
my lord, the reason I graciously told that it should be allowed. For a moment, kindly look into the impleading application, my lord. If he has got a semblance of right, I will be out of the court. Kindly take the,
By whom?
Deputy commissioner.
Deputy Commissioner, Your Worship.
What is there to show that?
But original records is office concern which is on leave.
my learned friend is arguing contrary to the objections what she has filed. She says it is taken over by the, she's taken over by the, no, I'm not getting angry. I'm not getting, why should I get angry?
Because their hard earned money have invested on the site, my lord.
But the declaration.
That site is even,
filed
my
by
lord,
the
the land is registered with the government. My proposal to society is bending before the government. my lord. That is the matter as per section 3 and 4 repealing act. Government is, if it is allotted to, regulating my title or allotted to the society, I will be pledged to safer side, my lord. My lord, day to day by day, I am harassing from the people from the land.
You will say.
This is mafia agogide swami. That is only on my submission.
As per the records, there is no any document to show that the
Is-
land has been allotted to the society.
Can't you say who took possession? Matter has been pending since when?
Your Worship.
Position ತಗೊಂಡಿಲ್ಲ ಅದಕ್ಕೆ.
After the order was passed in the year 88, did you offer him to pay any compensation? When? You have anything to show that revenue inspector took possession?
My lord, it's evident on the,
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಇಲ್ಲ my
Any
lord.
record?
ಇಲ್ಲ.
Government cannot pay
Post next Friday for further consideration.
My lord,
Further consideration. We
We
can
taken a-
produce that major in which is indicated that possession was taken by the revenue inspector. I'll accept it.
No, my lord, deputy commissioner has been taken.
Produce
I
it.
understand why my learned friend, my lord,
Madam, by the next date of hearing, the learned SCGP to secure the records. The records are not secured. The deputy commissioner shall be personally present before the court.
for further hearing, my lord, please, read.
Number 15, Shankar Reddy.
My lord, through VC, my lord, because your lordship, next.
it.
Great.
It's the case may not bear.
Directed us to allotment side. The DA brought regard the clarification from the state government in regard to the circular where not your are directed only to those, anywhere to only to those people who have paid other than the initial amount. The Lord directed, he have not paid, the Lord directed, he is there are several such cases not already they are in Supreme Court in other layers, but in Naraprabhu Kempegoda layer, this is all.
But you are now disobeying this order now. By not accepting the payment.
But we are
Not for the last 3 months.
Will be filing bada.
already decided, file an appeal.
No, you may take a decision. This order was passed in April 2024.
But there's a clarification because issued by the state government also pursuant to this notification.
That also I think I've interpreted in another case.
Not, that is a subsequent to the order passed by the writ petition.
That clarification as whether it was paid in part or was not paid at all. ಅದು ಮೂರ್ clarification ಒಂದು ಕೇಳಿದ್ರೆ ತಾನೇ ನೀವು.
ಇಲ್ಲ, ಅದು ಬೇರೆ layout. ಇದು
Same
particular.
ಇದೆ, ಇದು time extension ಅಲ್ಲಿ ಯಾರು ಕೊಡಬೇಕು ಅಂತ ನೀವು ಒಂದಿನ ತಕರಾರು ತೆಗೆದ್ರಿ. You raised a doubt. In one case, I have considered that and said, once the decision is taken, to extend the time. The question of payment either part after the allotment or after does not make any difference.
The similar such matters were pending before this Supreme Court in a writ appeal. The view taken by your lordships were also the view taken by the Honorable Division Bench. But the Supreme Court is pending before the Supreme Court and their states in respect of the extension of the time granted by this Supreme Court.
Now, at least I have given him an endorsement saying that you have come forward to give a demand draft, but we can't accept because you're filing an appeal.
Not for the last 3 months. Now, today is the last day, not
It shall be paid within a period of 2 weeks. Now he has purchased a demand draft. He's sitting on that money. He has already lost that money from his account. You don't accept it. You don't give him an endorsement.
So but we are making an appeal again.
ನೀವು ಏನಾರು ಮಾಡ್ಕೊಳ್ಳಿ.
We have cascading effect on, because all those several release have been cancelled. To them, it may not be applicable to only to those.
Murugesh, I think this,
I understand that. I understand, but not the.
you act like as if you are very prompt in your dealings. To take a decision to file an appeal, those 6 months have elapsed, you are yet to take a decision. But when citizens default, you become very, very strict. If you have the same attitude towards your conduct, that is one thing. ನಿಮ್ಗೊಂದ್ ಕಾನೂನು ಅವ್ರಿಗೊಂದ್ ಕಾನೂನು ತಪ್ಪಲ್ವಾ ಇದು? This was what I have interpreted in our declaration.
Then subsequent clarification is done from the state government. This was then brought to the state court. ನಂತರದಲ್ಲಿ ಪ್ರಾರಂಭಿಕ ಠೇವಣಿಯಲ್ಲದೆ ನಿವೇಶನದ ಪೂರ್ಣ ಮೌಲ್ಯದ ಪೈಕಿ ಭಾಗಶಃ ಮೊತ್ತವನ್ನು ಪಾವತಿಸುವ
Where is the order that I passed? You have a copy of the order that I passed? I had passed one order in another petition. interpreting this order. This 53/2024. This argument was advanced that clarification is sought for the awaiting clarification. I have interpreted that saying that there's nothing to be clarified because the government is clear in its intention to enlarge the time. Therefore, there's no question of granting extension and I have taken a decision. If not filed an appeal against that, then I direct you to act in accordance with that particular decision.
But today is the last day, not more thing to DD. 27, it expires.
Accept the demand draft. Without prejudice, accept the demand draft. You can always return it. If in case you succeed in the writ appeal, you can always return it.
If it is to be accepted, my lord, I will not be able to encash. Today will be the last.
I'll
day.
pass an order on 18th of April 2024. This court had directed the BDA to accept the balance title value along with interest, and also stated that the petitioner should pay the amount within a period of 2 weeks from the date of the order. The Shankar Reddy Learned Counsel for the petitioner submits that though the demand draft was purchased when
29/4/2024.
29/4/2024, the same was not accepted by the BDA. The Murugesh Charity, and hence he was constrained to make this application. Murugesh Charity, Council of the BDA submits that the BDA has now taken a decision. Yavak tagondidare?
After the writ order.
Day for yesterday. That's why my lord, I submitted on the last.
I should not have granted you time then.
No, day for yesterday. I
Has taken a
submitted
decision to file
that
a writ
day.
appeal 2 days ago. And therefore it would be unable to accept the demand draft. In my view, the order was passed on 18th of April 2024. And if the BDA takes its own sweet time to take a decision to prefer an appeal, that should not prejudice the petitioners in any way. The BDA is therefore directed to accept the demand draft and also encash the same. In the event the BDA does prefer an appeal, obviously the receipt of the demand draft and its encashment would be subject to the result of the writ appeal.
Now let there be a communication from them to the officials, my lord. So otherwise they will not receive it.
Or else have we got the demand draft now?
It is there, my lord. I've placed it on record, my lord, along with the application.
Shankar Reddy, Learned Counsel submits that he has a demand draft ready and he hands it over to the counsel for the BDA.
Secretary section.
I have directed, why are you worried? You just collected pursuant to my order. I have said, I have directed you to accept. He says it is ready, you accept and hand it over according to my order.
By the time I go and give it, they go and give it, they'll put it for encashment because this is the last.
Yeah, what last date?
Give it them.
29/4/2024, my lord, was the date on which it was taken. It would be valid till
Instruct
28/4.
them. We'll instruct them. I'll call it at 4:30 again if you want.
But I'll instruct the secretary.
4:30. Go and give it to him and come back.
Please.
Let us see what Murugesh will do.
For admission, film 16, Shri Manjunath NM.
For petitioner.
Yes.
Offence are the punishable under section 506, 504, 420, 468, 471, my lord. Alleged dispute were arised in the question of the alleged site, my lord, situated at Mysore. The originally site belongs to grandfather of the petitioners. And the complaint is none other than uncle of the petitioners. The matter is purely civil in nature and a civil suit is pending before the Mysore court, my lord, in OS number 424/2017,
Filed by?
filed by the complaint.
Where is that suit?
Please filed on subsequent your lordship, filing of the complaint. Whatever, idರಲ್ಲಿ ಏನಾಗಿದೆ unproperty and just come to my share.
Now you gone to the civil court, get it resolved there.
Question is, that is different. But the question is,
ನನ್ನ ಸಿಗ್ನೇಚರ್ ಫೋರ್ಸ್ ಮಾಡಿ ಒಪ್ಪಿಗೆ ಪತ್ರ ಮಾಡ್ಕೊಂಡು ನಾನು ಕೊಡೋದಿದ್ದದನ್ನು ಖಾತಾ ಚೇಂಜ್ ಮಾಡಿಸಿ ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿ ಎಸಿ ಮಾಡಿದೆ. ದಟ್ ವಾಸ್ ಸೆಟ್ aside. ನನ್ನ ಹೆಸರಿಗೆ ಖಾತಾ ಬಂತು. And then they have sold the property to some other person.
When was the suit filed?
Papers.
Should filed as
And
8/6/2017, my lord.
2015 and it was set aside. And
What happened to the suit is still pending?
It is pending for one.
and my
Read
instruction.
the complaint.
There are the similar complaints are there against this.
But I do.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ನನಗೆ ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹುಬ್ಬಳ್ಳಿ ಟೈಪ್ ಕಾಪಿ ಸಿಗ್ಬೇಕು ಗ್ರಾಮದ ಸೋ ಅಂಡ್ ಸೋ ಊರು ಮುಂದೆ ನಮ್ಮ ತಂದೆಯವರಿಗೆ ದಿನಾಂಕ 8/11/2066 ಕ್ರಯದ ಮೂಲಕ ಬಂದ ಸ್ವತ್ತಾಗಿದ್ದು ನಮ್ಮ ತಂದೆಯವರು ನನಗೆ ಪಾಲುದಾರಿ ಮೂಲಕ ನನ್ನ ಹೆಸರಿಗೆ ಸೋ ಅಂಡ್ ಸೋ ರೀತಿಯ 95-96 ಅಲ್ಲಿ ಬಹುಖಾತೆ ಆಗಿದ್ದು ಹಾಗೂ ಭೋಗದ ಗ್ರಾಮದ ಪಂಚಾಯತಿಯಲ್ಲಿ ಖಾತೆ ನಂಬರ್ 11/95/362 ಸೋ ಅಂಡ್ ಸೋ 88-89 ಸಾಲಿನಲ್ಲಿ ಖಾತಾ ವರ್ಗಾವಣೆ ಮಾಡಿಸಿಕೊಂಡು ನನ್ನ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಇರುತ್ತದೆ. ಆದರೆ ನನ್ನಿಂದ ಯಾವುದೇ ರೀತಿಯ ಒಪ್ಪಿಗೆ ಪತ್ರ ಪಡೆಯದೆ ದಿನಾಂಕ 12/5/2009 ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಮಳವಳ್ಳಿ ತಾಲೂಕು ಕಿರುಗೋಳು ಹುಬ್ಳಿ ಮಗನೂರು ನಲ್ಲಿ ವಾಸವಾಗಿದ್ದ MP ಪರಮೇಶ್ವರ್ ಅವರ ಮಗನಾದ MP ರಾಜು, ದಟ್ ಇಸ್ ಪಿಟಿಷನ್ ನಂಬರ್ 1 ಅಕ್ರಮವಾಗಿ MR ನಂಬರ್ 14789 ರಂತೆ RTC ಯಲ್ಲಿ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳೊಂದಿಗೆ ಶಾಮೀಲಾಗಿ ಖಾತಾ ವರ್ಗಾವಣೆ ಮಾಡಿಸಿಕೊಂಡಿದ್ದನ್ನು ನಾನು ದಿನಾಂಕ 9/12/15 ನ್ಯಾಯಾಲಯ ಮೈಸೂರು ಉಪಯೋಗ ಮೈಸೂರಿನಲ್ಲಿ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋಯಲ್ಲಿ ಶ್ರೀರಾಜು ಅಕ್ರಮ ಖಾತೆ ವರ್ಗಾವಣೆಯನ್ನು ರದ್ದುಪಡಿಸಿ ನ್ಯಾಯಾಲಯ ನನ್ನ ಹೆಸರಿಗೆ ಕಂದಾಯ ದಾಖಲೆ ಇತ್ಯಾದಿಗಳನ್ನು ಮುಂದುವರಿಸುವಂತೆ ತಹಶೀಲ್ದಾರ್ ಮೈಸೂರು ತಾಲೂಕು ಇವರಿಗೆ ನಿವೇಶನ ನೀಡಿದ್ದಾರೆ.
So 2009 Kata transfer, you challenge it in the year 2015.
Yes, my lord.
I came to the knowledge
And 2 years thereafter, you file this complaint.
ಅಲ್ಲ ಅದ್ರ ನಂತರ ಇದಾದ ನನ್ನ ಹೆಸರಲ್ಲಿ ಇತ್ತು. ನಂತರ it was that property was sold to one Dinesh.
No, 2015, you preferred an appeal.
Appeal I set aside. It came to my name.
Where is it? Where you said that?
ಇಲ್ಲಿ
Adara Mysore Nagara?
ಅದೇ 6ನೇ ಪೇಜ್ 14ನೇ ಪೇಜಲ್ಲಿ ಮೈಸೂರು ತಾಲೂಕು ಇವರ ನಿವೇಶನ ನೀಡಿದ್ದು ಅದರಂತೆ ಪ್ರಸ್ತುತ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಎಲ್ಲಾ ದಾಖಲೆಗಳು ಚಾಲ್ತಿಯಲ್ಲಿದೆ.
When was this order?
ಚಾಲ್ತಿಯಲ್ಲಿದೆ. This was in 2015 ಚಾಲೆಂಜ್.
Then what happened?
ಅದರ ನಂತರ JP ನಗರ 2 ಮೈಸೂರು MP ಪರಮೇಶ್ವರ್ ಅವರ ಮಗ MP ರಾಜುರವರು ತಾನೇ ಸೃಷ್ಟಿಸಿಕೊಂಡ ದಿನಾಂಕ 27/5/2001 ಪುಸ್ತಕ 2017 ಮೈಸೂರು ದಕ್ಷಿಣ ಜಿಲ್ಲಾ ದಾನಪತ್ರವನ್ನು ನೋಂದಾಯಿಸಿಕೊಂಡು ಮೈಸೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ವಲಯ 3ರಲ್ಲಿ
ಯಾರು ದಾನ ಪತ್ರ ಮಾಡಿದ್ದು?
ಸೃಷ್ಟಿಸಿಕೊಂಡು ಆಗ ಅಧಿಕಾರಿ ನಕಲಿ
ಇಲ್ಲ, ಯಾರು ದಾನ ಪತ್ರ ಮಾಡಿದ್ದು?
ದಾನಪತ್ರ ಅವರೇ ಮಾಡ್ಕೊಂಡಿದೆ. MP ರಾಜು
Petition number 1.
ಗಿಫ್ಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 2 ಗೆ ಮಾಡಿ ಪಿಟಿಷನ್ ನಂಬರ್ 2 sold it to one Dinesh.
Correct. Where is then what is the
It
forgery?
all transactions was.
ಅಲ್ಲಲ್ಲ, I have never, the property belongs to me. I have never given the property in a.
So this was before the order passed by the assistant commissioner.
Assistant commissioner, they have done this in sale deed ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
So what is the crime?
ಅದರ ನಂತರ
When they exhibit the gift deed, the Kata was not standing in your name.
ನಾನು ಅಲ್ಲ ಗಿಫ್ಟ್ ಇಲ್ಲ, ನಾನು 2015 ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ.
So therefore, this,
ನನ್ನ ನಾಲೆಜ್ ಅಲ್ಲಿ ಇಲ್ಲ ಆಯ್ತು. It was not in my knowledge.
so then what is the crime that you are alleging?
The crime is the forgery of my consent letter. One is the consent on the basis of consent
So
letter.
that's why I said 2009 was the transfer of Kata on the basis of the 4th consent letter. You prefer an appeal in the year 2015. You do not intend to take any action on the criminal side till 2000.
Since it was came into my name, I had not taken any action. Subsequently, I came to know that.
You are basically alleging a crime of the year 2009 in the year 2017.
Please, your lordship.
Then
And they have sold the property. Then I.
you are
came to
aware,
know that
you are aware of this in the year 2013 when you preferred an appeal.
No, 2015 I prepared the appeal.
13,
Hello, 15 I came to know on 9/12/2015.
and yet you keep quiet for 2 years. Civil court.
Agriculture is, my lord. ಅಲ್ಲ, the question
AC
is-
ಹತ್ರ ಹೋಗಿದ್ದೀರಾ, ದಾವ ಹಾಕಿದ್ದೀರಾ?
ನನ್ನ ಪ್ರಾಪರ್ಟಿಯನ್ನು ನನ್ನ ಬಂದ ಶೇರ್ ಅನ್ನು ಇವರು ಒಪ್ಪಿಗೆ ಪತ್ರ ಮಾಡ್ಕೊಂಡು
ಆಯ್ತು, ಸಿವಿಲ್ ಕೋರ್ಟ್ ಇತ್ಯರ್ಥ ಆಗದ್ ಬಿಡಿ.
ಸಿಮಿಲರ್ ಕೇಸಸ್ ಇದೆ ಇವ್ರ ಮೇಲೆ.
ಆಯ್ತು.
That's the section. I'll produce that documents because ತರ್ಲಿಕ್ಕೆ ಹೇಳಿದೆ.
Lord,
Forgery act ಇದೆ. The delay may not be the criteria, your lordship, because there is a forgery.
as per the will, the revenue records was entered in my name, my lord. Earlier, prior to that, the records, revenue records was standing in the name of
Now
the
it creates a will and
complaint. Thereafter that, the municipal authority have issued a notice to the complaint. But he was not at all appeared and he was not at all filed any objection to the said transfer of the kata.
Where have you said ಒಪ್ಪಿಗೆ ಪತ್ರ forgery? Which paragraph?
first starting ಅಲ್ಲೇ ಇದೆ.
I thought the kata was changed in his name on the basis of a bequest.
ನನ್ನ ಒಪ್ಪಿಗೆ ಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 12/5/2009
Let us read your plaint.
ಖಾತಾ ವರ್ಗಾವಣೆ ಮಾಡಿಸಿಕೊಂಡು ನನ್ನ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಸ್ವತ್ತವಾಗಿರ್ತದೆ. ಆದರೆ ನನ್ನಿಂದ ಯಾವುದೇ ರೀತಿ ಒಪ್ಪಿಗೆ ಪತ್ರ ಪಡೆಯದೆ ದಿನಾಂಕ 12/5. He must have produced a document there. That's the reason the khata was changed.
No, in the plaint, what have you said?
Plaint copy ನನ್ನ ಕಾಪಿ ಕಾಲ್ ಇಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. Petition copy ಮಾತ್ರ. Petition ಮತ್ತೆ complaint.
No, at there you in this suit which is right 3 months after the complaint.
After the complaint.
You don't refer to this forced consent letter. Your allegation is upon gathering information, the plaintiff ascertained that the first defendant by creating documents by way of forgery had submitted.
Don't have that document, your lordship. ಅಲ್ಲ,
Close this.
document ಇಲ್ಲ. Supply ಯಾಕಂದ್ರೆ ನಾ recent ವಕಾಲತ್ ಹಾಕಿದ್ದೆ. Documents ಇಲ್ಲ. They have supplied it because I have received only the.
Last date of hearing also I supplied, my lord.
It is act
Already 2 times I supplied.
2017 Sagbudi.
ಅಲ್ಲ,
He was,
ಅಲ್ಲ,
I'll
at
make
least
it,
I'll go through that.
I'll make it clear that nothing in this order will affect the merits of the suit. This can't be a crime.
Could be a crime, your lordship, unless.
In
ನನ್ನ property.
the complaint, you say there's a forged consent letter. In the suit, you say some forged documents.
I've seen that.
I'll give it to you. Go through it.
Or document called FIR complaint ಕೊಟ್ಬಿಟ್ಟು.
I'll have it at 2:30. Go through it.
Please. ಇಲ್ಲ sir.
Number 17, ಶ್ರೀಮತಿ ಅನುಸೂಯ ಹಿರೇಮಠ್.
Take my copy.
Please,
My lord, the respondent has paid 60,000 rupees, though the school fees was 1,45,000. I had paid 50,000 each of the children for one child, due to the court
Said that this
insisting.
is dismissed, isn't it?
Your lordship, the appeal has been dismissed, your lordship.
What is the arrears due?
Your lordship, it's around 27 lakhs, your lordship. Your lordship, the respondent needs some time to arrange for the money, your lordship. He's a kidney patient, your lordship, and he has a handicapped brother also. He requires some time to arrange for the amounts, your lordship. He's paid 60,000 for the school fees of the daughter yesterday, your lordship. 1 week or 2 weeks time, your lordship, to arrange for the remaining money. And permission to pay the amount in part, your lordship. He will not be able to arrange for all entire 27 lakhs, your lordship, at once.
When will you, how much will you pay now immediately after 2 weeks?
Immediately around 5 lakhs, your lordship.
The Tenant counsel appearing for the
My
respondent.
lord, the respondent has taken ladies for resorts every time and he is capable of paying 12,000 rupees per night. So he is not able to pay 8,000 rupees for maintenance, which was 285/2017. He is not paid.
First, let us try to collect as much money as possible. She is coming forward to pay 5 lakhs within 2 weeks. I'll record her undertaking. Let us see after 2 weeks.
Okay, my lord.
Tenant counsel for the respondent husband submits that the respondent would undertake to pay a sum of rupees 5 lakhs within a period of 2 weeks. So she also acknowledges that the appeal filed by the husband challenging the maintenance granted by the trial court has been dismissed and his liability would be around 27 lakhs. So to facilitate the payment of rupees 5 lakhs as undertaken today, release the matter on so and so.
My lord, it's 39 lakhs, my lord.
According to her,
To her, it's 27, but its total amount is 39 lakhs.
release for the consideration. I'm treating as part that if you don't do it on that day, I'll take some action against you.
9th of.
Thank you, my lord.
Number 18. Yeah, Raghavendra. Appear for the petition.
Lord, the petitioner files a private complaint against the respondent company, my lord. And the matter was referred for the
You are the
investigation.
complainant.
I'm for the complaint. My lord, the,
Who's for the other side?
Government.
my lord, the acceptance of the B report was questioned by me, my lord. Without the prosecution has, the IO has filed a B report without serving a copy about the B report.
If I reject the B report, will it not prejudice him in some way?
Pardon me?
If I reject the B report, will it not prejudice the accused in any way?
My lord, kindly order for the issue of notice.
So you implead him first.
Please, my lord, I will implement.
Who's the 2007 crime ಇನ್ನೂ ನಡೀತಿದ್ಯಾ?
My lord, I will make the part.
What is the complaint?
The complaint is against the respondent for the, regarding the financial irregularities and offense committed. Offense under section 463, 468 and 420 of IPC law. And investigating officer has filed a B report without serving me. And the court as London magistrate accepts the B report. I have challenged that order as it's not been served on me. The London session judge has rejected my revision.
When counsel is granted a week's time to implead the accused.
Please.
Number 19.
One is the case, I make one submission, my, they have furnished some of the documents. Accommodation.
Allah, I will, leaving that document, I'll argue the matter. Apart from those documents, I'll argue this matter. Let them establish only on the basis of the offense, let them establish the ingredients. ಅದ್ರಲ್ಲಿ ನಾನು ಏನ್ ತಮಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ, those documents were furnished earlier with respect to filing of the suit. And now, let me complete. Now I have filed the judgment copy before this honorable court.
What is the complaint? Where is the complaint?
Basic complaint, which is in page number 19, madam.
May I read the complaint, my lord? The dispute is with respect to the respondent was supposed to pay me money for having purchased the land. He has not paid the money, then we started asking to pay the money. In the meanwhile, we also filed a 138 petition before the trial court, before the Chikmagalur court. That was on in the year 2015, my lord. And this complaint was filed in the year 2016. As a counter blast, he has filed this complaint. I'll take your lordship to page number 19.
You had sold the property to them, huh?
I have sold the property, an adjacent property of mine, a coffee plantation, to him.
What was the suit filed by him?
Suit for recovery. It is on 29/11/2017, my lord. Let me, it's my case, I'll put it across.
Where is the plaint?
My lord, I have not furnished the plaint, I have furnished the judgment, copy of the judgment. At page number, the judgment copy has been filed in the additional documents which has been filed on 23rd, my lord, of this month. No, I'm just trying to put it across. There's a judgment copy on this. No, let me complete. Solpa ತಾಳ್ಮೆಯಿಂದಿರಿ ಯಾಕೆ? So suit ತಮ್ಮ ಮುಂದೆ
Where is the suit? Where is the judgment?
judgment I have furnished on 23rd, my lord, of this month.
For yesterday they have furnished.
That they are also aware of that judgment. They have not even filed an appeal.
The appeal is pending in RSA 1339 for 2023.
No.
They are not aware about.
No, irrespective of an appeal, there is a civil suit which is pending before the court, which they have challenged. And in the initial stage itself, in my petition, on the one of the ground is that it's a civil suit.
The complaint at page number 19. This complaint is dated 8/9/2016. You say on 2/9/2016, ನಮ್ಮ ತೋಟಕ್ಕೆ ಅಕ್ರಮ.
Suit came to be filed on 29/11/2017.
No.
After lapse of 1.5 years.
That's why I said, please come to page number 19. Last 4 lines. ಇದಾದ ನಂತರ ದಿನಾಂಕ 2/9/2016 ನಮ್ಮ ತೋಟಕ್ಕೆ ಅಕ್ರಮವಾಗಿ ಪ್ರವೇಶ ಮಾಡಿ ಸುಮಾರು 1 ಲಕ್ಷ ರೂಪಾಯಿ ಹೆಚ್ಚು ಬೆಲೆ ಬಾಳುವ ಕಲ್ಲು ಕಂಬ ಹಾಗೂ ತಂತಿ ಬೇಲಿಯನ್ನು ದರೋಡೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿದ್ದು ಈ ವಿಚಾರವನ್ನು ತಮ್ಮ ಠಾಣಾ ಗಮನಕ್ಕೆ ನಾನು ತಂದಿರುತ್ತೇನೆ. ಇದಾದ ನಂತರ ನಾನು ದಾವೆ ಹಾಗೂ ಖಾಸಗಿ ಮೊಕದ್ದಮೆಯನ್ನು ವಕೀಲರ ಮೂಲಕ ಸಲ್ಲಿಸಿದ್ದು ನ್ಯಾಯಾಲಯವು ತುರ್ತು ಕರೆಯನ್ನು ನೀಡಿ 9/9/2016 ದಿನಾಂಕ ನಿಗದಿಪಡಿಸಿರುತ್ತದೆ. So the suit must have been filed between 2/9/16 to 9/9/2016.
Another suit filed by, they are not furnished by law.
So you have filed, you are the complainant. What is that suit? Between, you say in the complaint on 2/9/2016, they came and removed the stones. On 8/9, you give a complaint saying that in between 2/9 and 8/9, you had filed a private complaint or dave mattu ಖಾಸಗಿ ಮೊಕದ್ದಮೆಯನ್ನು. So what is the suit that you had filed?
An inquiry.
Because the judgment that you have produced is filed by some MP Nived.
Yes, he is the one of the petitioner in this matter. my lord. Second petitioner. Petitioner number 1.
ನೀವಲ್ಲ, ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ ಯಾವ ಸೂಟ್?
ಅವ್ರ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು ಸರ್, ನಾನೇ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರೋದು.
In the complaint, he refers to a suit filed by him. He says he lodged a private complaint and also a suit between 2nd of September and 8th of September.
Now he says ಖಾಸಗಿ ಮೊಕದ್ದಮೆ. What is that ಖಾಸಗಿ ಮೊಕದ್ದಮೆ? Is it with respect to what is the incident which has been taken place on 2/9/2000?
Let him produce it. Let us see what exactly he will produce. ಏನಂತ ಗೊತ್ತಾಗ್ಲಿದೆ. Without that. Next week.
Take up next week, my lord. A date may begin.
Number 20. Number 20. Mudit Ashutosh.
For the respondent. And the complaint filing the parent sheet. I saw a copy also.
No, it's the copy. We've just received it at 9:15 this morning. I forwarded it to the petitioner as well. There are you might have not had the chance to go through the entire thing in a short time, but there are a few things that were pointed out that few entries apparently are being repeated, and a few places the amounts are not matching. Like the online booking platforms have paid X.
According to that statement, how much is due?
Also, my lords, according to that statement, 22 lakhs is due,
18 lakhs.
is what the total says, is what the petitioner has been.
The complaint. But the investigation officer has also collected all the messages, communications between the complainant and the accused. And they all more than 400 emails from
Yes.
generated from the.
In one of these
application.
messages
Then
also,
that's
my
a part
lords,
of
there's
charge sheet.
one message apparently wherein the respondent number 2 agreed to deviate a bit from the 200 rupees commission model and asked for a set price for the rooms that were booked through the petitioner here. Any balance would be kept, the difference for what they were able to sell it at as extra would be kept by the petitioner. That is what is another submission that I would like to place on record.
In none of these exchange of messages,
Huh.
you dispute the amounts that are due.
In the messages, my lords, it's not the amounts. He has sent messages which specifically state that I need X for the hotel room booking, which you do from your platform for me. Anything over and above X that the petitioner was able to sell would be kept, the difference would be kept by the petitioner company, deviating from the 200 rupees per booking commission, which was set according to the agreement. Those messages are there, my lords, and those we agree to.
There is no dispute at any point of time thereafter regarding the amount that is to be paid to him.
My lords, no, post that agreement, yes.
You're not being truthful as to what is the amount that you actually owe him.
No, my lords, we've been whatever records these petitioners have been able to find from there, as they were maintaining the reconciliation statement, those have been produced.
I can only protect from criminal prosecution if you are prepared to be honest and pay the money.
Yes, my lords, we are prepared to be honest and we are ready to pay. There is no doubt about that. Even now, the submission, even today is we are ready to pay, my lord. 18 lakhs is a little too much. It's not the figure. That is disputed, my lords. It's not 18 lakhs. As from the latest statements that was produced by us, around 3.5 lakhs is due. In top of this, my lords, there might be a variation of around 1-2 lakhs because there is amounts which are pending with the booking platforms. So they are not even in the possession of the petitioner. We're never in the possession of the petitioner because the petitioner's company closed and the account with the booking
There is
platform
no
closed.
difficulty in holding that there's an intention to cheat from the very beginning.
No, my lords.
And I'll confirm this prosecution if you're not fair.
Well, we have been extremely fair. There is nothing that we've
When was the money due?
money.
Are you holding on to your money?
Well, money has been due since 2020, my lords. Agreed. That
Because it's not your money.
yes, my lords. Yes, that also I agree. It's the sum, my lords, that we are disputing. That's about it. That's the only thing. And
Sit with them and convince him as to how much money is actually due. If
well, if maybe given a little more time, at least a day, on Monday we'll be ready, my lords, because
live it next Friday, by that time you verify it, read as parted. Relist on so and so for the consideration. If you don't come out honestly,
my lords, I will come out with everything the petitioner says clear and fair and square.
And state is filed on a vacating stay, my lords, and charge sheet is ready to file, my lords.
no, hangge settle ಆಗುತ್ತೆ ಅನ್ನೋದು.
Please, my lords.
21, is that come to the petition?
What is happened?
In this case, my lord, it is a complaint for trespass, my lord. I am the owner of the property. The second respondent, my lord, he demolishes the property despite an order of status quo. I have gone to the trial court, my lord, complaining that there is a violation.
Given the report,
Please, my lords, there was an order seeking to directions to the inspector J.C. Nagar, my lords. My lords, subsequently, my lords, after that, my lords, in 10/3/2020, my lords, the counsel for the plaintiff has filed the contempt, my lords. Since, my lords, on the order, my lords, they've attended that what the order has passed by the honorable court, my lords. They went and they've approached the premises, my lords. They've stopped the construction which were done by the
order of the court was is hereby directed to maintain the status quo.
Please, my lords. On
Inspector J.C. Nagar Police Station is directed to maintain the status quo and restore suitable property as per the order and submit the report on or before 28/2/2020. Where was the report?
a report, in meanwhile, my lords, they filed a contempt petition.
Report.
They have not filed the report, my lords, but physically they have attended the.
Was the report not filed? Is he not aware of the order?
Please, my lords.
What is the reason? That means he's supporting the other citizen?
No, my lords, physically they have, means without filing a report, my lords, they went and they were supported the order
What
by.
prevented him from filing the report?
Plus, meanwhile, they have filed a contempt petition.
What is the report that is filed? You said on the last occasion report was filed?
No, I didn't mention the report.
Last time I heard the report.
No report is filed, my lord.
Just
In
to,
fact, for 1 year.
Lordship has
construction was
instructed me
going
to.
on. 1 year construction was going on. Immediately, my lord, even after this order, not only to the JC Nagar police station, I've named those people. I've gone to the ACP, I've gone to the DCP, I've gone to the additional commissioner, stating that there is an order of status quo, there is an order for them to submit a report. Please do so. They have not done so, my lord. I filed a writ petition, I got an order. That order also was communicated to them, my lord, orally. They said, we know it is already possession is taken. We can't do anything now. You go to the BBMP since he is constructing, go and complain to the BBMP. If the BBMP doesn't do anything, you come back to us, we'll then acknowledge, he says, my lord.
Still, OS is pending, my lord, sir. Meanwhile, they have filed. OS is pending, my lords.
So he can get away with it?
No, my lords, not.
What was his duty as an inspector when the court ordered? Forget about the complainant coming to him. The court ordered him to maintain status quo. The court directed him to submit the report.
Please, my
If
lord.
this is the regard that he has to the court, I'll ask him to be hauled up for this.
No, my lords, not in that manner, my lords.
It was not a direction for the parties to maintain status quo. Direction was for the inspector to maintain status quo.
Please, my lords.
And non-filing of a report, I'll draw an adverse inference against him.
But he is not the IO when the order was passed, my lords. Other IO was there, my lords. We have.
Get that IO, whoever is that IO should be taken to
Please.
task.
Please, my lords.
Who's the IO?
Manjaya. Manjaya one, he was the
No,
IO
that's
at the
to
time
keep
of the.
The investigating officer was required to submit the report on or before 28/2/2020. So was required to maintain status quo in this soup property and also submit the report on or before 28/2/2020 before this court on so next Friday. Release the matter for further consideration.
Grateful.
Let him also be here, let them also come. What is the status as of today?
My lord, he has completed construction, he's got a residential house, my lord, in this scheduled property now, my lord. In fact, the BBMP has issued a demolition notice against which he is before the chief commissioner, my lord, questioning that order of demolition, my lord, because there was no sanction.
Obvious for him here.
No, he's served unrepresented, my lord.
See, these problems could be solved by them easily. They deliberately allow this to happen.
I'll take into
If
consideration.
the court directs them to maintain status quo and if they disregard it, they're in direct contempt, isn't it?
I'll try.
Direction was not to the other side to
Please.
maintain.
Please, my lords.
If that status quo is altered, then I will initiate action against them, suo motu for contempt.
I'll make them to appear before this.
Interim order may be extended.
Number 22. Pages. Not kindly pass for now.
Settlement.
Yes.
So,
For further consideration. For 23.
Lots, they have filed an affidavit stating that 20 sites would be demarcated and possession would be given. However, my lords, my only submission is that those 20 sites should be integrated into the layout and fully developed. And with respect to the remaining sites, they say that some litigations are pending.
For the earlier date of hearing, my lord has directed the BD to whether how many state sites are available in the layout and other sites, how many sites are vacant as of today without allotting to the allottees or any other person. My lord, I have sought for instruction, my lord, it requests for 2 weeks, my lord. Because my lord, we don't have a ready reference, my lord, because in Arkavati layout, day to day, my lord, there are several litigations. Hence, my lord, we need some 2 weeks time, my lord.
where is the affidavit that you have filed?
My lord, affidavit dated, my lord, 11/7/2024. Filed on 11/7/2024, my lord. If my lords turn to page number 7, my lord.
Yes, last occasion, my lord has obtained this matter for the reason that secure instruction because there is space sites which are available to be allotted to the petitioners. That's what my lord has pointed out last vacation. Orally, my lord has pointed out that. My lord's last occasion I filed an affidavit and also my lord has orally pointed out you better secure instruction as to whether there are stray sites which are available. Now subsequent development which has taken place, some third party made an application for impleading to be made as a party.
Yes.
Now, my lords, there seems to, my lords, their sale deed does not indicate under which survey they have purchased the property. And their original vendor under which they purchased the property has already been paid with a compensation under 4060 scheme. And my lords, the committee has already given a clear sheet that that landowner has already taken a compensation of under 4060 scheme. And all the claimants application, the allottee's application has been rejected. This is also a part of record along with my statement of objection. I'm sorry.
I am impleading applicant, my lord. And next state of a hearing, I filed the original documents. Original owner executed the GP and affidavit. His with
Original-
survey number.
The original owner has also taken the.
No, Your Honor, 93 from till today, I am the construct the building. I am getting the kata and electricity charges.
Sale deed.
It is.
Sale deed ಇಲ್ಲ.
ಅಲ್ಲ ಇದೆ ನಾನು ತಂದು ಕೊಡ್ತೀನಿ ಸರ್ ನೆಕ್ಸ್ಟ್ ಒಂದು ಸಾಟ್ ಅಕಾಮಡೇಷನ್ ಇವರನ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇವರನ್ನ the original owner sold the property fraudulently obtained the in the 40-60 ratio is no available in the site in that area ಇವರನ್ನ
ಅವ್ರ ಮೇಲೆ ಹೋಗಿ. ನಿಮ್ಗೆ ಯಾರು ಮೋಸ ಮಾಡ್ರ ಅವ್ರ ಮೇಲೆ
but the BDA has misguided the court and filed the affidavit available in the site in 1990.
ನಿಮ್ ಲ್ಯಾಂಡ್ ಓನರ್ ಅವ್ರ ಹತ್ರ ಕಾಸಿಸ್ಕೊಂಡು ಸೈಟ್ ತಗೊಂಡು ಯಾರು ಮೋಸ ಯಾರು ಮಾಡಿದ್ರು?
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ನಾವು ಇವ್ರ ಮೇಲೆ ಡಿಗ್ರಿ ತಗೊಂಡಿದೀವಿ ಸಮೀರ್ ಸೆವೆರಲ್ ಒಂದು 13 ಸೈಟ್ ಮೇಲೆ ವಾಸ್ತ ಡಿಗ್ರಿ.
ಯಾವುದೇ ಸೀಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಸರ್ವೆ ನಂಬರ್ ಮೆನ್ಷನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ತೀನಿ ಸಮೀರ್.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಹೇಳಿ ನೀವು ಸೇಲ್ ಡೀಡ್ ಸರ್ವೆ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡಿದಾರಾ?
ಅಲ್ಲ GPA ಮತ್ತು ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಇದೆ ಸಮೀರ್ ಸೇಲ್ ಡೀಡ್. ಆಮೇಲೆ ಹೌದು ಸರ್ ಒಂದು ಸೆವೆರಲ್ ಸೈಟ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದೆ ಸಮೀರ್. ನಾನು ತಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಸಮೀರ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಇದೆ.
On the last occasion, my lord, the lordship posed the same question. Survey number illa. Lord, I submitted. Honestly, in all fairness, my lord, revenue site ತಗೊಂಡಿದ್ವಿ. For that reason, survey number was not mentioned. So the only inference I could draw, my lord, from this memo, my lord, got at page number 2, my lord, my vendor's name is entered in all land records. ADLR or ಕೊಟ್ಟಿರೋದು ಅವ್ರ ಟಿಪ್ಪಣಿಯಲ್ಲಿ.
A gentleman has taken benefit from the BDA and has cheated you. Who is to be held responsible?
My lord,
we are in possession from 1991, my lord. We are not aware of him taking compensation or other. My lord, in this, my lord, BDA has served us a notice. Acquisition notice ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, award ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಮಾಡಿದೀವಿ. That reply has not been honored in any manner. ಹಾಗೆ ಉಳಿತಷ್ಟೇ. ಅದಕ್ಕೆ objection ಮಾಡಿದೀವಿ that I am in possession for so many years. ನಮ್ಗೆ notice is served on me, not my vendor.
You will not be entitled to an alternative site even under the Jujamba's case. Jujamba case ಅಲ್ಲಿ ಬರುತ್ತಾ ಏನಾರು ಅವ್ರಿಗೆ GP ಆಧಾರದ ಮೇಲೆ?
ಇಲ್ಲ, ಆತರ ಬರ್ದಿದ್ದಾರೆ. GPA ಇದ್ರಲ್ಲಿ ಕೊಡಬಾರ್ದು ಅಂತಾನೆ ಬರ್ದಿದ್ದಾರೆ.
Lord, if that's the case, my lord, on last occasion they told whatever pending litigation they will leave out for the time being. Lord, if that's placed on record, my lord, I might as well withdraw the application. Somewhere I may be protected.
Trying to protect you, but in what way, you tell me?
My lord, at least that, my lord, I am in possession, may be taken on record, my lord. It may be
That
support.
means I'm granting you injunction.
Lord, I have filed suit for injunction. That's still pending.
How's the suit filed?
In the year, my lord.
Are you referring to his suit in the affidavit?
ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಯಾವ್ದಾರ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ
ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಅವರೇನೆ ಹಾಕಿದ್ದಾರೆ ಸಮೀರ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ.
Is your suit found there?
Yes,
My lord,
please, my lord.
we have made a reference indicating in my, kindly see my affidavit. Page number. Yeah, the page. Tabular column. I made a tabular column, my lords.
Which is your suit number?
OS number ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇರುವಂತದ್ದು ಸೀಲ್ ನಂಬರ್ 13 ಇಂದ 17
3326, man.
33 ಹೌದು ಇದೆ
3326.
81/4
8326.
ಹೌದು.
Serial number 14.
OS number 322.
Obviously, they will not do anything even according to
Case
their
pending ಅಂತ ಇದೆ.
Serial number 16 already
affidavit.
declared.
You want to press this?
Please, my lord, if the lordship of that opinion.
ನಿಮ್ suit number ಏನ್ರಿ?
Serial number 16 ಇವರ 2660 of 2016 already decreed passed the judgment and degree honorable court.
8660 by 2016.
8660 of 2016 decreed against BD ಅಂತ ಇದೆ.
Yes.
ನಿಮಿಷ ಸರ್ ಪ್ಲೀಸ್. ಅದಕ್ಕೆ ನಾನು ನಿಮಗೆ
ನಾವು 3 ಸತಿ ಸ್ಟ್ರಕ್ಚರ್
13 side ಗೆ passed the judgment ಇವರ against BDA.
My lords, kindly see the tabular column. Seal number 13 ಇಂದ 17 ಒಳಗೆ OS ನಂಬರ್ ಯಾವ್ದೆಲ್ಲ ಇದೆ ಅಂತ ಹೇಳಿ I have narrated the from 1 to 12 there is no problem as such with regard to sites. From 13 to 17 out of which my lords for 13 and 14 OS case pending ಇದೆ ಅಷ್ಟೇ 3 ಸೈಟಿಗೆ ಡಿಕ್ರಿ ಆಗಿದೆ.
So you will not do anything in respect of those particular.
ಹೌದು, ಇವರಿಗೆ ಬೇರೆ ಆಲ್ಟರ್ನೇಟಿವ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ ಪ್ರೆಸೆಂಟ್ ಪಿಟಿಷನರಿಗೆ. ದಟ್ಸ್ ವಾಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ಮೇಡ್. ಸೊ 4 1 2 3 4 5 ಸೈಟ್ ಅಲ್ಲ, ಐ ಆಮ್ ಸಾರಿ, 7 ಸೈಟ್ ಇವರಿಗೆ ಬೇರೆ ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಸಿ ನಂಬರ್ 26 ಮತ್ತು 27 ಕಮಿಟಿ ಮುಂದೆ 2 ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ. So 7 site there is a litigation.
In para 8 they have said they submitted that formation of site in respect of cases pending in court, and cases pending before case and committee will be taken up after the finality of the cases through the BDA. The same may kindly be taken record in the interest of justice and equity.
Please.
I'll record that.
Please, ma'am. My lord.
An affidavit is filed on 11th of July 2024 in which the BDA has stated that out of the 27 sites that they had offered to the vendors of the petitioners, 20 sites were free from litigation as on date. But litigation is pending in respect to 7 sites. The details of the sites which are free from litigation, sites which are subjected to litigation, present and past, and sites which are pending before the committee is also indicated in tabular column. The BDA has stated that the 20 sites currently free from all litigation, it would take up the formation of sites within 8 months. This undertaking of the Commissioner BDA is taken on record, and 8 months time is granted to the BDA to form the sites. Next slide. The statements made by the Commissioner that the site formation of sites in respect of the cases which are pending in court and cases which are pending with the Justice Krishnan and Committee would be taken up after the finality of cases in favor of the BDA. The impleading applicants are persons who are litigating before the court and whose suit numbers are referred to in the tabular column at serial number 13 to 17. Since the BDA has stated that no action will be taken against in respect of those properties till the disposal of the cases, it would not be necessary to implead themselves as they are already protected by the statement given by the BDA. The impleading applications are therefore rejected as they become unnecessary. The BDA is directed to comply with the undertaking as aforesaid and file a complaints report. I'll release this after 8 months.
Well, that's one submission.
Sir, one the submission is BDA would form the above sites within 8 months after sites are free from pending litigation.
The your side bit.
Well, their statement is that with respect to sites where litigation is pending, they would require 8 months time after they are free from litigation. However, with respect to 20 sites which are available now, they have not made any statement with respect to the timeline.
They are right. Read the statement.
8 months. No, no. 8 months.
Read the statement.
Thus 20 sites are currently free from litigation. Consequently, BDA would form the above sites within 8 months after the sites are free from pending litigation. That is with respect to the 7 sites, my lord.
The sites are currently free from all litigation.
Yes, my lord.
Consequently, BDA would form the above sites within 8 months after the sites are free from pending litigation.
Yes, my lord.
I said in this respect 20 sites,
Please,
there's an undertaking that they will do. Other 7 sites they won't do.
Please.
Okay.
The list on 8 months.
Lords, with proper integration within the layout, my lords. Please.
ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ.
17 March 2025.
Can I request for update of this order through net at least? Internet, my lords may request.
For further consideration, please.
He will post for reporting complaints.
24?
what they have given. We could, I'll just place before your lordships the issues we have in what they have given, Lord. In the list of shops, ಒಂದು ನಿಮಿಷ ತಮ್ಮ ತೋರಿಸ್ಬಿಡ್ತೀನಿ. Get that. It's right on. ಒಂದು, and in serial number 2, they say there are 219 shops of 1,000 square feet. ಅವ್ರದ್ದೊಂದು list of memo ಕೊಟ್ಟಿದ್ದಾರೆ last time.
The memo indicates the existing market functionaries in page number 1.
Yes, yes,
87 leave and license,
yes,
102 private lease,
yes.
sublet from original allottees, 118 cell phone,
ಇದು.
41.
Kindly see the next page. Onion, garlic, ginger, potato, Yeshwantpur. Leave and license in APMC. ಈಗ details of shop and godowns occupied by onion, ginger, garlic and potato in Yeshwantpur. ಇದು ನಮಗೆ ಒಂದು ಮೇನ್. ಇದರಲ್ಲಿ up to 1,000 square feet 219, 1,000 to 1,500 square feet 64, 1,501 to 2,044 ಇಂತೆಲ್ಲ ಹಾಕಿದ್ದಾರೆ. Then let kindly see details of shop cum godowns available for allotment in Dasanpura. ಈಗ up to 1,000 square feet 265 are available. 1,000 to 1,500 square feet 132 ಇದೆ. ಆದ್ರೆ what is available is in the next page. ಇದು details, existing details. Next page ನಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ allottees whose period of 55 months on leave and license has expired is 102. ಇಲ್ಲಿ they are not giving ಈ 102 ನಲ್ಲಿ ಎಷ್ಟು, what is the dimension ಅಂತ ಕೊಡ್ತಾ ಇಲ್ಲ. ಇರ್ಲಿ for a moment.
That this is a note.
ಅದೇ ನೋಟ್.
They are saying in the first page altogether there are 348 shops in
Correct.
occupation.
Correct. ಈಗ ನಮ್
Saying that 348 shops, dimensions are mentioned.
yes, ಈಗ impossibility.
Then they are saying 420 shops are available there.
Yes, ಈಗ
All 348 subject to their verification of the market fee being paid.
yes,
If they are not entitled, then out of 348 there will be a further reduction
ಹೌದು. ಆಮೇಲೆ ಇನ್ನೊಂದು ಏನಾಗಿದೆ,
for allotment.
The-
So everybody will come within 420 only.
ಅಲ್ಲ, one problem Lord is ಈಗ ಈಗ already those who are existing there are 102 shop holders. More than that.
Yes.
102, one allottees whose period of 55 months on leave and license has expired. Or other, there are more than 102 allottees. What
That is
totally?
also given in page number 1. They have said 87 are available on leave and license basis.
Correct, from
There's no
APMC.
difficulty about that.
Private lease is
Private lease of 102.
102.
That's a sublease.
Self owned is 118. ಅಂದ್ರೆ ಅದು ಯಶವಂತಪುರ ಲಾಟ್, ಅದ್ ಬಿಟ್ಬೇಡ.
ಯಶವಂತಪುರಲ್ಲಿ ಅವ್ರು ಇರೋರ್ನೆಲ್ಲಾರು ಯಾರ್ಯಾರಿಗೆ ಇದಾರೋ ಅವ್ರನ್ನ ಅಕಾಮಡೇಟ್ ಮಾಡ್ತಾರೆ ಇಲ್ಲಿ.
ಮಾಡ್ತೀವಿ ಅಂತ ಇವ್ರು they are making.
To allowing them to keep the shops that they have there.
Correct.
Yeshwanthpur.
ಅದು ಯಾಕೆಂದ್ರೆ
That is a benefit that they get.
ಅಲ್ಲ,
Normally they can't have 2 shops.
ಅಲ್ಲಲ್ಲ
One at
ಅದೇನಾಗಿದೆ,
Yeshwanthpur and one at.
ಅಲ್ಲಲ್ಲ ಅದೇನಾಗಿದೆ, ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಓವರ್ ದ ಇಯರ್ಸ್ 50 years.
ಯಾರು ಮಾಡಿದ್ರು?
ಇವರೇ ಅಥಾರಿಟೀಸ್ ಆಸ್ ಪರ್ ದ ದೆನ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೂಲ್ಸ್.
They are entitled to keep them. There is no difficulty. about it.
ಅದೇನು that we cannot, I cannot forego that because it title has vested in me. Now not issue, problem is where this impossibility arises is this. ಅವರು 2013 ನಲ್ಲಿ ಎಲ್ಲಾ ಶಾಪ್ಸ್ನು ಆಕ್ಷನ್ ಮಾಡ್ಬಿಟ್ರು. That auction was on leave and license basis. There are 2 types of auction as per the rules. One is lease cum sale, another is leave and license. After 55 months of continuous occupation, they'll be entitled to lease cum sale as a matter of right. This is the rules. I'll be able to point out through the relevant provisions. Now, my point is this. Out of the allottees there, 70% of allottees are entitled to lease cum sale because they have completed 55 months and they have adhered to the conditions. Balance what will remain is 25%. The 25% that will remain will be the shops that they have, out of the old shops, only 25% will remain. Iga,
Now, are you saying that out of 420 shops, 102 will not be available?
illa.
Let us take, my lord, 102 is
Let
not
me just
available.
clarify. Your lordships are pointing out the correct thing. ಇಲ್ಲಿ ಏನಾಗಿದೆ, 265 small sheds are created in this list of up to 1,000 square feet. Yes, in the earlier notification,
What I had indicated, Mr. Vivek, suppose you are having up to 1,000 square feet in Yeshwanthpur,
yes,
you will be allotted within this 1,000 square feet.
ಅಲ್ಲ ಏನಾಗುತ್ತೆ ಅಲ್ಲ
You cannot be replicated to the same extent possible.
ಅಲ್ಲ
They have made four
what will happen
categories.
is this, ಏನಾಗುತ್ತೆ ಈ ನ್ಯೂಲಿ ಕ್ರಿಯೇಟೆಡ್ ಶಾಪ್ಸ್ ಇದಾವಲ್ಲ ದೇ ಆರ್ ಕ್ರಿಯೇಟೆಡ್ ಇನ್ ದ ಪಾರ್ಕಿಂಗ್ ಏರಿಯಾಸ್ ವೇರ್ ಇಟ್ಸ್ ಅನ್ ಅಮ್ಯುನಿಟಿ ಸ್ಪೇಸ್ ಇಟ್ ಕುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಬಿನ್ ಕ್ರಿಯೇಟೆಡ್ ಅಟ್ ಆಲ್. ಒಂದು
There is no challenge to that. If you
ಇದೆ
want-
ಮಾಡಿದ್ದೀನಿ, ಐ ಹ್ಯಾವ್ ಚಾಲೆಂಜ್ ದಟ್ ಇಶ್ಯೂ ಮುಲಾಡ್. ಅಂಡ್ ಇನ್ನೊಂದು ಏನಾಗಿದೆ, the original created shops for that market, its maximum capacity is the original created shops of about, ಇಲ್ಲಿ ಹೇಳ್ತಾರಲ್ಲ,
If you had
132.
No, if there are 219 people in Yeshwanthpur with less than 1,000 square feet, they can't expect more than 1,000 square feet.
No, that is not true facts, my lord. I have filed the objections to this. I filed. I kindly see, my lord, in the rejoinder that I have filed, on 11/10/23.
Response to this memo, you have not filed any objection.
ಇದಕ್ಕೂ ಮಾಡಿದೀವಿ. We have filed. We are filing now. Give me.
The idea was to accommodate you to as much.
ಅಲ್ಲ ಏನಾಗಿದೆ, ಅಕಾಮಡೇಷನ್ ಆಗ್ತಾ ಇಲ್ಲ. ರೀಸನ್ ಇಸ್ ದಟ್ ಆಲ್ರೆಡಿ ಓಲ್ಡ್ ಪೀಪಲ್ ಆರ್ ದೇರ್ ವಿತ್ ದ ಮೇನ್ ಶಾಪ್ಸ್. ನಾವು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ನಮ್ಗೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಪಾರ್ಕಿಂಗ್ ನಲ್ಲಿ
ಅವ್ರ ಕಿತ್ ನಿಮ್ಗೆ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಅವ್ರ ಕಿತ್ ಕೊಡೋದಕ್ಕೆ ಆಗದೆ ಇದ್ರೆ ದಟ್ ಇಸ್ ವಾಟ್ ಐ
ಅದರಿಂದ ಮಾರ್ಕೆಟ್ ನಿಲ್ಲಿಸಬಾರ್ದು ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಅವ್ರ ಕಿತ್ ಕೊಡೋದಕ್ಕೆ ಆಗದೆ ಇರೋದ್ರಿಂದ ದಟ್ ಇಸ್ ವೈ ಐ ಹ್ಯಾವ್ ಪುಟ್ ದಟ್ ರಿಲೀಫ್ ದೇರ್. ಏನಂತಂದ್ರೆ ಓಲ್ಡ್ ಪರ್ಸನ್ಸ್ ವಿಚ್ ಹೂ ಆರ್ ದೇರ್ ಫಾರ್ 10 years are contrasted with shifted persons who are there for 50 years. That is creating unfairness in the entire allotment.
I'm going beyond the purview of 226 and trying to ensure that there's as little damage caused to your business as possible. But if you want your pound of flesh and every drop of blood.
ಹಂಗಲ್ಲ ಮಲಾಡ್, ಏನಾಗುತ್ತೆ ಈಗ ನಾನು ಯಶವಂತಪುರ್ನಲ್ಲಿ ಮೇನ್ ಮಾರ್ಕೆಟ್ ನಲ್ಲಿ ಐ ಆಮ್ ಡೂಯಿಂಗ್ ಬಿಸ್ನೆಸ್. ನನ್ನನ್ನ ಅಲ್ಲಿ ಕಳ್ಸಿದ್ರೆ ಅಲ್ಲಿ ಮೇನ್ ಶಾಪ್ಸ್ ಕೊಟ್ರೆ ಓಕೆ. ವಾಟ್ ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಲಾರ್ಡ್ ಇಸ್ ದಿಸ್, if they are going to do this, let them make a seniority list year wise. ನಾನು 50 years seniority ಇದೆ, ಅವ್ರದ್ದು 10 years seniority ಇದೆ.
That amount of displacing people who are already gone there,
They
who chose to abandon Yeshwanthpur and took.
ಅವ್ರು abandon ಮಾಡಿಲ್ಲ, they are new persons there.
They have gone there initially, which when you chose not to go.
ಅಂದ್ರೆ they are
Now
not.
you want to steal a market over there.
No. We did not choose, my lord. They continued the market here. They said it is continued here. Sub-market is there. Sub-market ಗೆ ಹೊಸ players ಬಂದ್ರು. None of them who were here went there. Rules prohibited us from going there. The rule said if you have in one place, you cannot go at all. ಆ rule ಇಂದ
You cannot
now
go
I
on
kindly see the impossibility in the rules. That is what I am trying to point out. Property allotment rules.
Consider the matter on merits.
ಅಲ್ಲ ಅದು ಇನ್ನು ಟ್ರಬಲಿಂಗ್ ನಬಡಿಗೆ ಅವ್ರು ಏನೋ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು.
ಅದೇ merits. If you're not prepared, I can't force you to agree for the proposal. I'll consider the matter on merits.
ಅದಕ್ಕೆ ಇನ್ನ
If the
ಫರ್ದರ್ ಇದೆ.
notification is valid, it's valid. If it's invalid, it's
ಅಲ್ಲ ಅದೇ
invalid.
ಫರ್ದರ್ ಇದೆ ನಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್.
ಮಾಡಿಕೆ.
ಅದು ಟ್ರಬಲಿಂಗ್ ನಬಡಿಗೆನೂ ಬರ್ತಾರೆ. ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಬೆಟರ್ ಬಿಕಾಸ್ ವಿ ಕ್ಯಾನ್ ಕನ್ಸಾಲಿಡೇಟ್ ಆಲ್ ದಿಸ್.
I virtually concluded your arguments.
ಇಲ್ಲ ನಂದು ಇನ್ನ ಇದೆ. ಟ್ರಬಲಿಂಗ್ ನಬಡಿಗೆ is also engaged. We don't mind, your lordships may have it on any date. We don't mind. We will argue it. No issue. ನಮ್ದೇನ್ ತೊಂದರೆ ಇಲ್ಲ. ಇದು ಇನ್ ಫರ್ದರ್ ನಮ್ಗೆ ಆಗೋ ಕಷ್ಟಗಳನ್ನ ನಾವು ಹೇಳ್ಕೊಂತೀವಿ. ವಾಟ್ ಆರ್ ದ
ಕಷ್ಟದ ಪರಿಹಾರ ಹುಡ್ಕಕ್ ಹೋದ್ರೆ ನೀವು ಬಿಡಲ್ಲ. ನಿಮ್ ಕಷ್ಟದ ಪರಿಹಾರ ನೀವ್ ಕೇಳೋದ ಪರಿಹಾರ ಸಿಗಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಏನಾಗಿದೆ
ಬೇಡ ಬಿಡಿ, ಅದು why should I go into that? I thought I'll try to minimize your difficulty, but
human logistics
that I can't help it.
ಅಲ್ಲ ಹ್ಯೂಮನ್ ಲಾಜಿಸ್ಟಿಕ್ಸ್ ಪ್ರಾಬ್ಲಮ್ ಏನಂತಂದ್ರೆ ನನಗೆ ಹೋಗಿ ಚಿಕ್ಕದು ಕೊಟ್ಬಿಟ್ಟು 10 years ಅವ್ರಿಗೆ ಒಳ್ಳೊಳ್ಳೆ ಜಾಗಗಳು ಕೊಟ್ರೆ ನನ್ ಬಿಸ್ನೆಸ್ ಆಗಲ್ಲ. ನಾನು ಆಕ್ಚುಲಿ ಐ ಹ್ಯಾವ್ ಟು ಕ್ಲೋಸ್ ಮೈ ಮರ್ಚೆಂಟ್ ಬಿಸ್ನೆಸ್.
Finish your arguments. ನಿಮ್ ಮುಗಿಸ್ಬಿಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ ನಂದು ಇನ್ನೊಂದು ಡೇಟ್ ತಾವು ಇಟ್ಕೊಳ್ಳಿ. ಇನ್ನೊಂದು ಡೇಟ್ ದೆನ್ ಐ ಕಂಪ್ಲೀಟ್ ಇಟ್. ತಾವು ಎನಿ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್. Second. Second morning. What is the next day you suggest? Second is what day? Next Friday, no? Next Friday. Friday.
Next Friday.
But 25.
Let me see, I can't see it. Second is.
Number 3. Filing affidavit, complying with.
The affidavit is again contrary to the undertaking before this court.
ಅಲ್ಲ ಕೊಡ್ತೇವೆ ಅಂತ ಹೇಳಿ.
Allah, undertaking, last time my learned friend had undertaking, he'll report complaints, but now he's saying he's seeking time to report complaints.
ಆಯ್ತು ಸ್ವಾಮಿ.
Allah, it becomes contrary to the undertaking.
ಸಂಬಳ ಬಂತಾನೆ ನಿಮ್ಗೆ?
ಈಗ
ಇಲ್ಲ.
3 ತಿಂಗಳು ಬಂದಿದೆ.
ಏನು
Arrears
ಬಂದಿಲ್ಲ.
ಅನ್ನ ಇನ್ನೊಂದು
ಇಲ್ಲ,
ಒಂದು
ಏನು
ವಾರದಲ್ಲಿ
ಬಂದಿಲ್ಲ. See, the receptant ID second time was created on 9/7. I had in fact texted him also. See, this is within 2 days they could have got my salary. They have not done.
In para 2, he says, the report of duty in the university in the month of April 2024, salary for the month of May 2024 onwards has been sent but returned for incorrect recipient ID. Now again, the salary has been sent for his correct recipient ID, which has been furnished by him.
Now, only here I beg to correct. It was on 2nd time the correct receptant ID was sent on 9/7/2024. Today is 20.
ಇದೆಯಾ?
ಇದೆ ನೋಡಿ.
ಅದಕ್ಕೆ
ಹಣ
ಇಲ್ಲ, ಬಂದಿಲ್ಲ. ಏನು
ಅದಕ್ಕೆ
ಕಳ್ಸಿಲ್ಲ ಅವರು.
ಗೊತ್ತಿದೆ, ಅವ್ರು ಅಲ್ಲಿ receive
ಇವತ್ತವರೆಗೂ
ಮಾಡೋದು
ಕಳ್ಸಿಲ್ಲ ಅವರು.
ನಮ್ ರೋಲ್ ಇಲ್ಲ, ನಾವು ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೇವೆ ಹಣನೇ. ಈಗ ಇನ್ನೂ ಉಳಿದಿದ್ದ ಅರಿಯರ್ಸ್ ಬಗ್ಗೆ ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ ಕಳಿಸ್ಬಿಡ್ತೇವೆ ಅಷ್ಟೇ. ಇನ್ನೊಂದು ವಾರದ ಟೈಮ್ ಸಾಕು.
No, but this statement, is it correct that the salary has been sent for his correct recipient ID, which has been furnished? ಯಾವಾಗ ಕಳ್ಸಿದ್ರಿ ಇದನ್ನ?
ಯಾವ್ದು ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂತ?
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಟೈಮ್.
ಸೆಕೆಂಡ್ ಟೈಮ್ ಒಂದು 2 ದಿನ ಹಿಂದೆ ಆಗಿದೆ, 2 days ಬ್ಯಾಕ್.
ಯಾವತ್ತು?
ಯಾವ time? 23rd ಆಗಿದೆ. 23rd ಕಳಿಸಿ.
ಏನೋ ನೀವು ಈ ಕೇಸ್ ಕಂಡ್ರೆ ಏನೋ ನಿಮ್ಮ ಒಂಥರ ತುಂಬಾ ಇದಿದೆ.
ಅಲ್ಲ, ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ ಎಲ್ಲ ಪೇಮೆಂಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ, ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಿ.
I feel sorry for him because he has
ಇನ್ನೊಂದು
undertaken.
ವಾರದಲ್ಲಿ ಇದು ಮಾಡ್ತೇವೆ ಎಲ್ಲ. ಯಾರ್ಯಾರ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ನಾವು ಕೊಡ್ತಾ ಇದ್ದೇವೆ, ನಾವ್ ಯಾರು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಒಂದಲ್ಲೇ ರಿಸಿಪೆಂಟ್ ID ಇದು ಆಗಿದ್ದಕ್ಕೆ ಆಯ್ತು, ಇನ್ನೊಂದು ವಾರ ಅಂತ ಆಯ್ತು.
Receptant ID was created on 9/7.
ಆಯ್ತು
For the
ಸ್ವಾಮಿ,
second
ಇನ್ನೊಂದು
time.
ವಾರದಲ್ಲೇ ಸಿಗುತ್ತೆ ಹಣ ಅವ್ರಿಗೆ.
Affidavit is filed by the in-charge registrar stating that the salary of the petitioner in WP 10404 of 2023 was sent, but the same had been returned for, the same was returned since it contained an incorrect recipient ID. But thereafter, the salary has been sent to the correct recipient ID. Sridhar submits that the salary was resent about 2 days ago and should fall into the account of the petitioner. ಎಷ್ಟು ದಿನದಲ್ಲಿ ಆಗುತ್ತೆ ಅದು?
ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ ಕೊಡ್ತೇವೆ ಸರ್. ಇವತ್ತೇ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೇವೆ, ಅದೇನು ಒಂದ್ ದಿವಸದಲ್ಲಿ.
He also submits that the arrears would also be paid within a period of 15 days from today. This affidavit is taken record, released on sounds.
For hearing B group, seal number 26.
Therefore, petitioner.
My client is ready, but.
Mirads, I've talked to my client. ಮಾತಾಡಿದ್ದೆಲ್ಲ ಆಯ್ತು ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ they are having 6 ಜನ ಇದ್ದಾರೆ. They are not ready to malad forgo because they have lost 2 persons for the same the dispute ಇಂದಾನೆ ಅಂತ. That's why I secured one of. ಅಂದ್ರೆ ಇದಕ್ಕೆ ಓಡಾಡಿ one ಒಬ್ರು ಏನೋ developed mental this thing and died.
If you don't stop litigation, you're always.
Definitely, I have told them.
You're going to lose some more people.
Yes, definitely.
Total extent ಎಷ್ಟು ಅಂತ ಹೇಳಿದ್ರೆ?
ಸ್ವಾಮಿ, ಟೋಟಲಿ 3 acre 36 ಬರುತ್ತೆ.
3 acre 34.
3 acre 34 ಗುಂಟಾಸ್ ಬರುತ್ತೆ ಟೋಟಲಿ.
ನಾನು ಎಷ್ಟು ಹೇಳಿದೆ ಕೊಡಿ ಅಂತ?
ತಾವು 1 acre ಅಂತ
3 acre ಇದ್ರೆ 1 acre ಕೊಡಿ ಅಂತ. ನೀವು 3
ಅಲ್ಲ ಏನಿಲ್ಲ, ಒಟ್ಟು 4 acre ಅಂತಾನೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಂದಿದ್ದು. ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅಂದಿದ್ದು ಅದೇ. ಅದ್ರಲ್ಲಿ ನೀವು ತಾವು 1 acre ಅವ್ರಿಗೆ ಬಿಡಿ, ನೀವು 3 acre ಇಟ್ಕೊಳ್ಳಿ ಅಂತ ತಾವ್ ಹೇಳಿದ್ವಿ.
3 acres.
ತಾವು on the last acre.
Not even prepared to give 1 acre.
ಸ್ವಾಮಿ,
Not even prepared to give 1 acre.
ಅಂದ್ರೆ ನಾನು told them what are the consequences also. ಅವ್ರು ಹೇಳ್ತಾರೆ ನಾನು 60 ವರ್ಷದಿಂದ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, 60-70 ವರ್ಷದಿಂದ ಇಬ್ಬನ್ ಕಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದೀವಿ. ಅವ್ರೇನು
ಎಲ್ಲ
ಮಾಡಿಲ್ಲ.
ಆಯ್ತು.
ನಮ್ ಕಡೆನೂ ತೀರೋ ಹೋಗಿದಾರೆ ಸ್ವಾಮಿ.
And they are nowhere related to our.
Suppose I take a decision that Gumasta is also a village office holder.
I have told everything, my lord. The
And they are taking the risk.
ಅಲ್ಲ ಒಬ್ಬ ನಾನು ಕರ್ಸಿದೀನಿ ಅದಕ್ಕೆ. They should not think that.
Like, suppose I take that view, you will lose much more.
Definitely.
And the matter won't stay here. Either
It will go up to, my lord. Though no party will leave this matter because it is there from 60 years.
ಈಗ ಅವರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಆಗ್ತಿದ್ದಾರೆ.
ಅದು ಅವ್ರದ್ದು.
connected matter WP 32257/26.
ಅಲ್ಲ ಅವ್ರದ್ದು RSL ವಜಾ ಆಗಿದೆ ಅದ್ರ ಮೇಲೆ ಹೋಗಿದೀವಿ ಅಂತಾರೆ. ಅದು ವಿಲ್ ಮೇಲೆ ಅದು ದೇ ಪ್ರೂವ್ ಅಲ್ಟಿಮೇಟ್ಲಿ.
ಅವ್ರದ್ದೇನು ಕೇಸ್
ಅವ್ರದ್ದೇನಿಲ್ಲ.
ಇರೋದು ನಿಮ್ಮಿಬ್ರದ್ದು.
ನಮ್ಮಿಬ್ಬರದೇ.
ನೀವು 1 ಎಕರೆ ಕೊಟ್ರೆ ಇಲ್ಲಿಗೆ ಮುಗಿಯುತ್ತೆ, ಇಲ್ಲ ಅಂದ್ರೆ RSA ಮೇಲೆ ನಮ್ಮವರೇನೋ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿದ್ದಾರೆ.
ಅಲ್ಲ ಹೋಗಿದ್ರು ಕೂಡ ಅದ್ ಯಾವ್ದು ಪ್ರೂವ್ ದಿ ವಿಲ್, ಅವಾಗ ಅದಾದ್ಮೇಲೆ ಅವ್ರದ್ದು ಬರೋದು.
ಏನು ಮತ್ತೆ think it over, because if I take that view then you are in trouble.
Definitely, your lordship has expressed everything. ನಾನು ಇನ್ನೂ ಒಂದ್ಸಲಿ ಕೇಳ್ತೀನಿ ಸ್ವಾಮಿ ಅವ್ರನ್ನ. ಇವತ್ತು ಕರೆಸಿದೀನಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲಿ ಪಾರ್ಟ್ ಆಡ ಅಂತಾನೆ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ. ವಿ ಡೋಂಟ್ ವಾಂಟ್ ಟು, ಬಿಕಾಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾಸ್ ಹರ್ಡ್ ದಿಸ್ ಮ್ಯಾಟರ್.
Suggested a compromise was the matter could come to an end.
Yes. ಹೌದು.
ಅವರು ಬಿಡಲ್ಲ, ಅವರು ಏನ ಈ ಊರ್ ಕಡೆ
ತಮ್ಗೆ ಗೊತ್ತು.
ರಿಲಿಸ್ಟ್ on so and so.
ಅಲ್ಲ ಪಾರ್ಟ್ ಆರ್ಡ್ ಅಂತ ತಗೊಂಡ್ಬಿಡಿ. Nine eight through this.
Till 127.
The lordship, short accommodation, I had to keep the IO present today. He's held up in the other court, your lordship. NBW was issued evidence ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ. This is matter regarding A5's, A5 is the authorized signatory ಅಷ್ಟೇ. Everywhere he is the authorized signatory since he was the.
No, the complaint, if I remember it, was only against that
Sandeep Das.
During that period, A5, the present petitioner is the authorized signatory of, for all the.
Maybe the authorized signatory, the allegation was basically
That
change
is
of
the only, ಅದಕ್ಕೆ ಒಳ ಸಂಚು ಅಂತ ಹಾಕಿದ್ದಾರೆ, all are in hand in glove ಅಂತ.
on what basis does he say that?
He is the authorized signatory, your lordship, for all the checks.
Maybe the authorized signatory for the check.
That is it, your.
Application yaru?
Application is A1.
Then?
Involvement, but everywhere he is the authorized signatory. That is the only huge amount of 3 crores, your lordship.
So you're going to make everybody in BMRCL a party?
ಅಲ್ಲ, ಇವರು ಸಿಗ್ನೇಟರಿ ಚೆಕ್ಕಿಗೆ ಎಲ್ಲ ಇವರೇ ಸೈನ್ ಮಾಡಿರೋದು ಅಂಡರ್ ಇಸ್.
There's no problem with the investment. Investment was made. The allegation is something else, isn't it?
Please, your lordship.
Changing of the application.
Switch in and switch off
And
ಮಾಡಿದ್ದಾರೆ.
even according to them, the application was given by somebody else.
Please.
Without his knowledge.
How are you?
ಅದಕ್ಕೆ it is hand in glove ಅಂತ, that is the only thing, your lordship.
Like, show me hand in glove, ಏನಂತ ಇದೆ material?
ಇಲ್ಲ, ಆ ಮೆಟೀರಿಯಲ್ ಏನೂ ಇಲ್ಲ. He was the authorized signatory in all the checks and all that which was issued. Check signatory ಅವರೇ.
Page 102 is the complaint, my lord.
Page
102.
ಅಲ್ಲ.
Annexure B, my lord. Amended petition.
Where's the FIR?
Page 110, my lord. FIR.
Petitioner was the company secretary and general manager admin.
Now the quasi as against him then.
Please.
On 17th of October 2014, a complaint regarding mismanagement of funds of BMRCL and consequential loss was submitted by the company secretary. In this complaint, it was stated Sri Sandeep Dash, he was the executive finance, was responsible for ensuring that the surplus funds of the BMRCL was to be invested in accordance with guidelines and the decision of the board. But he had hatched a criminal conspiracy with a common intention along with one Sri Manjit, who was representing a financial service brokerage agency known as Messrs. GR Financial Services. And he had invested rupees 10 crores in principal cash management fund dash liquid option and a further sum of rupees on 19/1/2006 and a further sum of rupees 20 crores on 17/4/2006 in the same fund. It was stated that the investment rupees 10 crores was made through an application bearing number 1415511, which was signed by the said Sandeep Dash. And this application was through a broker. It was stated that the normal procedure for investment was direct, and the petitioner herein, who was the then secretary, company secretary and general manager administration, had signed and given an application bearing number 1478993, which was an application for direct investment. But Sandeep Dash had replaced the said application with the application bearing number 141555511, which was to be routed through a broker. It was specifically alleged that this replacement of the application was manipulated and BMRCL was kept in the dark. It was stated that Sri Sandeep Dash neither obtained approval of the managing director nor informed the company secretary, that is the petitioner, from departing with the procedure of making a direct investment as against investing through a broker. It was also alleged that no record was maintained in this regard and no noting was also effected in the file. And there was a material suppression of fact with the intention to mislead the higher authorities. It was therefore alleged that the decision to make the investment was taken unilaterally by Sandeep Dash, and the said investment of 30 crores was without the approval of the MD, and he was not competent to take a decision on his own. It is therefore clear the entire thrust of the allegation was only against Sri Sandeep Dash, the executive engineer. In fact, in this complaint, it was also alleged that the application was substituted without even informing the petitioner herein, who was the company secretary and who had prepared and given him an application for a direct investment. As a consequence of this complaint, a crime was registered in crime number 323/2014 against Sandeep Dash and Manjit for offences under section 409, 420, 465, 470, 120B, read with section 34 of the IPC. May pertinent to state here that apart from pertinent to state here that the petitioner herein was the company secretary and was also the authorized signatory for the check through which the investment was made was not arrayed as an accused. However, subsequently, after investigation, a charge sheet has been filed in which the petitioner has been arrayed as the fifth accused. In the charge sheet, it is stated as follows insofar as the petitioner is concerned, page 222. Second paragraph ಪೂರ್ತಿ ಆಗ್ತದೆ. As could be seen from the said statement in the charge sheet, the essential allegation is only against Sandeep Dash, but in passing, an averment is made that Sandeep Dash and the petitioner herein had conspired together when it was not even the case of the complainant BBRCL, that the petitioner was in any way responsible for the investment. And when in fact the complaint itself stated that the petitioner had furnished an application for making a direct investment, but Sandeep Dash had replaced the said application and had sought to invest the said amount through a broker. This allegation of a conspiracy between the petitioner and Sandeep Dash would be completely unacceptable. In my view, therefore, there is absolutely no material against the petitioner, and the mere statement that there was a conspiracy along with the first accused would not be sufficient to justify prosecution when the complainant himself had exonerated the petitioner in his complaint. The proceedings as against the petitioner is therefore quashed. Only as against the petitioner is quashed.
Twenty-eight adjourned, till 29. T. Sheshgiri Rao.
My lords, on the last date of hearing, I filed a application under order 1 rule 10 my lords, impleading the tenants who were there in that particular period of time where the electricity arrears bill was calculated. One is the Bank of Baroda, S12 Vijaya Bank, and one more is PF office, my lords.
Issue notice on the application to implead the proposed respondents. Since it is the case of the petitioner that during the relevant point of time, the petitioner had leased out the premises to the proposed respondents, and they are the persons who will be responsible for the demand.
Published.
Are they adjourned? Till 31, Sri Jaganmohan MT. Sri Jaganmohan MT.
Your lordship's kind permission, my lord.
Yes.
This, I have to receive petition copy. This is a counter to 30, next matter.
Next week.
Even 32 also, madam.
32.
Till number 33. We are certainly. Number 33. Number 34, Sri Mohan Baleshwar.
Lords, there is a compromise. Petitioners and the third respondent, who is a contesting respondent, I may be permitted to file the compromise petition.
What is the dispute?
Lord's
about?
dispute is regarding, there were 2 licenses held by the son of the first petitioner and the husband of the third petitioner.
Next year, J and R.
Yes,
What is the page number next search?
111.
This one standing in the name of H. Girish, huh?
H. Girish, there were two license, my lord. The dispute arose between the wife of Girish and mother of the Girish. Both made an application for transferring license as a legal heirs. Either, my lord, it should have been transferred in the joint name, or, my lords, they should have been diverted to civil court, but the license was transferred in the name of third respondent, which was challenged. Now, my lord, they have entered into
Opponent is the
wife.
Wife.
Now they have entered into a compromise. One license will be held by the mother. One license will be taken by the third respondent wife. That is a compromise, my lord, entered into. Under Rule 17A, my lord. On the death, my lord, it will devolve upon the legal heirs.
The impugn order indicated that the license should be transferred in the name of the wife.
Wife. So, my lords, now there are two licenses, my lord, CL2 license and the CL9 with the RVB license. But what we compromised is, my lord, CL2 license will be transferred in the name of the second petitioner, who is the son of the first petitioner, brother of the deceased Giri. And the CL9 license will be transferred in the name of the wife, including RVB license, that is the retail vendor of beer license.
Brother ಮಾಡ್ಬೋದಾ?
Madhu, class 2 here ಆಗ್ತಾರೆ ಸ್ವಾಮಿ. Class 1 here is giving consent. Mother is giving consent because what happened, my lord, there are 3 children.
ಬೇರೆ ಮಕ್ಕಳು?
There are three children. 3 ಜನ ಗಂಡು ಮಕ್ಕಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಒಂದು ಇವರು ಗಿರೀಶ್ ಅವರು ಅವ್ರ ಹೆಂಡತಿಗೆ ಒಂದು ಕೊಡ್ತಾ ಇದೀವಿ. ಇನ್ನೊಬ್ಬ ಸತೀಶ್ ಅಂತಾನೆ, ಅವನಿಗೊಂದು ಲೈಸೆನ್ಸ್ ಇದೆ ಆಲ್ರೆಡಿ, ಅವನ ಹೆಸರಲ್ಲೇ ಇದೆ.
Is he a party to this compromise?
Who, my lord?
That's Satish.
No, my lords. Because Girish had executed a will in respect of the second respondent.
Your choice. There will be some litigation.
No, my lords, because it's settled among the family.
License which was standing in the name of.
My lords, what happens is, my lord, CL9 license, we will, here only it is agreed that we are.
Let's go by your compromise.
Yes.
License was standing in the name of Girish, who passed away on. When did he pass?
My lord, he passed away on, my lord.
11/2/2022.
Yes.
Disputes thereafter arose regarding the right to succeed to the said license. And ultimately, by the impugned order, the authorities held that the wife of the deceased was entitled to succeed to the license. Being aggrieved, the mother of Girish has presented this petition along with her son,
That is brother, man.
who would thereby be the brother of the deceased. Today, a compromise petition is filed by which the parties have stated that they have resolved the disputes. It is stated that the deceased H. Girish had a CL2 license and a CL9 license
With RVB.
along with
With RVB, retail vendor of beer.
the license. It is stated that the CL2 license would be succeeded to by second petitioner,
Second petition.
whereas the CL9 license along with RVB license would be succeeded to by the wife.
The third respondent.
That is the third respondent. The terms of the compromise petition read as under. In my view, since the parties have arrived at a settlement and the wife has agreed to succeed to only one license and has also consented to the transfer of license in the favor of the brother-in-law, the same can be accepted. Writ petition is accordingly disposed of in terms of compromise petition, and the authorities are directed to act in terms of the compromise petition and transfer the license.
Under Rule 70A of the rules.
Fee ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ 17 ಅಂದ್ರೆ legal heirs.
Legal heirs ಅಂತ.
Because
ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಅಂತ ತಗೊಂತಾರೆ. ಈ ಒಂದ್ ಕೇಸಲ್ಲಿ ಹಾಗೆ ಆಗೋಗಿದೆ.
Rule 17A of the rules.
Please,
And mother and the brother is present for the court and.
all are present.
Sign months.
Yes.
Yes.
Number 35.
The petitioners made or the contractors made awarded some tender. Made as per the tender notification made, they have to pay the taxes and royalty in accordance with the as per prevailing at the rate made as per the prevailing rate. Made accordingly made they have paid the royalty also. There is no dispute about that. Made what happened is when they submit the bills to the engineers, executive engineers, apart from royalty, made as per prevailing rate, they have deducted 5 times made penalty on the royalty amount. That has been challenged made in the writ petition. Made in the writ petition made as per annexure made annexure G made
Yes.
and annexure F made previous made annexure F made, page 30. This court made has held, but you have no authority to deduct the penalty amount on the royalty. Made page 31 is the order, final order. Except royalty made, you cannot deduct the penalty amount, any amount. Page 30. Page 36 made is the order.
Yes.
Made even in spite of that, they have deduct the royalty amount,
The way
penalty amount.
minerals license was not produced, that where we are entitled.
Under the contract, was required to produce that license.
That under the contract, it is not there, that the government has issued a circular, without in the absence of the license, where that
So can the-
imposed.
No, can the government order modify the agreement that you enter into with them?
Right.
That under the rules that they have exercised and issued, that has been challenged, where in the para 8 of the judgment considered even that in the absence that we are entitled to recover. That is the judgment that page 30, that in writ petition 10331/2020, that in para 8 of the judgment in page 40, that the land council advocate for appeal filed a memo dated so and so, annexing communication dated 29/9/2020. By the assistant engineer, mineral irrigation and groundwater development department, Davangere, to produce the mineral dispatch permits, and if the contractors were to fail to produce the same, royalty equivalent to 5 times shall be deducted. And however, in this present.
As the court affirmed this, as the court said, this procedure can be accepted.
In this case, whatever we have collected, that we have deposited government before that order which has been passed by this honorable court.
Collect it from them and return it.
That it is, they have to there that the representation given to the government also.
You chose to collect on behalf of the government, so therefore you pay the money and collect it from the government. Nivetane togondhi responsibility.
That may kindly be, the ones we have collected, we are not holding, that we are entire and we are deposited.
When the petitioner is aggrieved by the deduction of penalty while clearing his bill, is the case of the petitioner that under the agreement that he had entered into with KPTCL, he had contractually agreed for deduction of royalty. And there was no clause which enabled the KPTCL to deduct 5 times the royalty as penalty. The KPTCL however submits that by virtue of the circular dated 29/9/2020, the KPTCL, by virtue of the circular issued by the government, KPTCL was entitled to deduct 5 times the penalty in cases where the agreements under which the articles were quarried or the mineral dispatch permits were not produced. This court in WP 10331/2020, disposed of on 12th of November 2020, while considering a similar case in which penalty was deducted, has concluded that the PW department therein was entitled to deduct only the royalty amount as agreed in the contract, and it would not be entitled to deduct any amount in excess of the contract. In this case also, since the contract admittedly does not enable the KPTCL to deduct any sum other than the royalty, the deduction of 5 times the royalty as penalty cannot be upheld. Consequently, the KPTCL is directed to refund the penalty that it has collected from the petitioner. Next, Learned Counsel for the KPTCL submits that the amount that was deducted as penalty has already been remitted to the government, and therefore the government may be directed to refund the said sum. In my view, it would be appropriate to direct KPTCL to refund the amount, and at the same time, the government shall also refund the penalty that it had collected from the KPTCL from the bills of the petitioner. This entire exercise will be complete within a period of 2 months when they have received a copy of this order.
36, the Sharath is go back.
Yeah, for the petitioner's counsel.
Yes.
Challenge here, my lords, is to Annexure A, which is, my lords, the order of penalty that is passed, my lords, by the excise commissioner. That's at, my lords,
Proposing you,
state government, my lords.
next week.
ಪ್ರತಿ ಸತಿನೂ ಈಗ ಹೋಗ್ತಾ ಇದೆ anyway.
They won't be ready. Stay idea, yeah?
Huh?
Stay idea.
Stay ಇದೆ. Stay ಇದೆ.
Every time they have taken action.
Ask them.
Please.
Number 37, Shri Cyril Prasad Pass.
Appearing for the respondents in this matter, Your Lordship.
My lords, may kindly pass over the matter, my lords. We're ready in the matter. Senior is engaged.
Your Lordship, we are seeking for an adjournment to file our objections in this matter, Your Lordship. A short accommodation may be granted.
List.
Number 38,
Obliged, Your Lordship.
R.V. Ramesh Kumar.
For the petition.
I appear for the respondents.
Lord, the installation of high tension wires. Lord, it's an admitted fact. Now, my Lord, the reason for the petition before my Lord says that, my Lord,
The compensation.
please, my Lord,
Please.
they have assessed it, but they refuse to pay this amount, my Lord.
Why?
My Lord, they have to make submission. My Lord, kindly turn to, my Lord, the
Now, what happened in
assessment
this
that has
case,
been
matter?
made. And actually F and my Lord, F1. Page 26, my Lord. ಸರ್ವೆ ನಂಬರ್ 67 ಗ್ರಾಮದ ಹೆಸರು ಮಿಟ್ಟಗಾನಹಳ್ಳಿ ಮಧುಕುಮಾರ್ ಸೋನ್ಸೋ 33,21,000 ರೂಪಾಯಿ. This is assessment for having the Milord high-tension wire being passing on through the lands of the petitioner. Now, if I produce the photographs there, Lord, as to how the Milord the high-tension wire passes through on his land. Kindly produce the photograph, Milord.
Then what is the problem?
That year, what happened? With regard to the payment of the diminution value, there is no dispute we have paid. And Lord, that trees with regard to the cut and remove also has been paid. But however, he has not disclosed. I have filed a statement objection detail in enclosing that what is the amount paid to the third petitioner as well as the petitioners 1 and 2. In my statement of objections, para 4 and 5, I have stated, narrated. That with regard to the borewell, that the where that we are requested to assess that borewell, that it is near that tower it is comes. That where that near in some other distance, that open well was there. That PW department, the first instant assessed the open well. That there is no damages, that we are not that it will not obstruct. However, then we are requested to the borewell. That also we have get it assessment. We have paid that money, but they are asking that it is in a open well. That you have once that you have secure report, you bound to pay that is.
The open well is not damaged in any way.
No.
That where near that tower, that is the borewell, that also I've got the assessment, the annexure R1. That annexure B, that payment has been paid, made.
Kindly appreciate this fact, page number, annexure page 24, my lords. This is the OM dated 11/12/2019. Lord, once the corridor passes on to the lands, we are not entitled to use that lands now. Now, the reason that is that since it is an open well, now they have instructed that we are not supposed to use that well. We have to close down that well,
Where have they said-
constructed. Please, my lord.
Where have they said that you should close down the well?
That's what I just said in my writ petition. They say that
Got a statement that they will not allow you to, they will not ask you to close down the well. And they'll permit you to use the well.
that is one, my lord, I concede that we subject to what my lord, the client says. Kindly, my lord, in fact, they have assessed it. The deputy commissioner, who's the authority,
The compensation should be something for which you have lost.
please, my lord.
If the well exists, and if you're using the well, where is the question of you,
That's exactly now.
once you ask for compensation, that means they're intended to close the well.
That's it. We'll do that. That's what, my lord, if that is the question, my lord, my learned friend says that, kindly give me 2 or 3 days time. I'll just ask my client whether he's acceptable for that or he wants a compensation.
Why do you want to do that? There is a well in existence, use it, they're not going to come in the way.
Because in
Then
fact,
they pay you the.
no, I'll just kindly, my lord, turn to page number. A committee is formed to assess the damages for, my lord, I will just see paragraph, page 25, my lords. ವಿದ್ಯುತ್ ಲೈನ್ ಹಾದು ಹೋಗುವ ಪ್ರದೇಶದಲ್ಲಿ ಬರುವ ಮರಗಳು ಸಂಬಂಧಪಟ್ಟಂತೆ ಐ ಸ್ಕಿಪ್ ಅಂಡ್ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಐ ರೀಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 3 ಮಿಲಾಟ್ಸ್. ವಿದ್ಯುತ್ ಲೈನ್ ನಿರ್ಮಾಣ ಮತ್ತು ವಿದ್ಯುತ್ ಲೈನ್ ಹಾದು ಹೋಗುವ ಜಮೀನುಗಳಿಗೆ ಬರುವ ಕಟ್ಟಡ, ಬಾವಿ, ಕೊಳವೆ ಬಾವಿ, ಇತರೆ ನಿರ್ಮಾಣ ಕಟ್ಟಡಗಳಿಗೆ ಅವಶ್ಯವಿದ್ದಲ್ಲಿ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಹಾಗೂ ಇತರ ಸಂಬಂಧಪಟ್ಟ ಇಲಾಖೆಯಿಂದ ಅಂದಾಜಿನ ನಿಗದಿಪಡಿಸಿ ಪರಿಹಾರ ಧನವನ್ನು ಪಾವತಿಸುವ ಬಗ್ಗೆ. Now, not they have assessed what is the damage that has been caused to the well. Page 25, milots, 3, clause 3, milots. So in terms of this milot letter correspondence, they have sought for the assessment by the Gramina Kudiyo Neeru Sarabaraju Mattu Naimalya Ilake. From this department submits estimate what would be the cost of this.
But by virtue of this, suppose it's a borewell upon which they want to lay the transmission line, for which you will be entitled for compensation.
Certainly not.
But if you are entitled to continue to use the well.
The borewell we have paid.
Compensating you.
Borewell we have
This
paid.
was, no, for a moment, I'll just kindly bear with me, Lord. For all this time, this was what I was told that there every now and then they are coming and obstructing that you have to close the board because you have to.
I will record a statement.
List. That for that reason, I just request 2 days time or 3 days subject to my lord's convenience.
I'll record it right now, whether even if it does not agree, I will direct.
Or else more kindly pass over that. I'll just call him and right now get back.
So.
39.
For petition, my lords.
For the respondent in this case.
Yes.
My lordships.
39.
Yes, my lord. My lordships, the petitioner, my lords, petitioner father was been granted the license, my lords. Then later on, my lordships, after his death, my lords, the license was been alienated to his wife, my lords. Then after that, yes, means mother of the petitioner, my lords. Mother of the petitioner, my lords. Then after that, my lordships, while she was in this thing, my lords, she transferred the license to the right now that current license holder, who is VK Purushottam, my lordship. My lordships, after that, my lords, these people that the issue has been raised, my lords. My lordship, the issue is in this case is, my lords, where my lords, after the death of the father, my lords, father of the petitioner, my lords, the license has to be transferred to all the legal heirs, my lords. Here in this case, my lords, it is transferred only to the Yashodama without the consent of all the other legal heirs, my lords. And after that also, myself, when the transfer has been taken place to the VK Purushottam, the respondent number 5, my lords, again in there also, my lords, the department has taken the consent of all the other legal heirs. But it is on the prima facie record of the department that the petitioner here in, my lords, he has not given any consent or something, my lordships, and there was no notice served to the petitioner on that record, my lords. And after that also, my lords, when the petitioner, my lords, he has the petitioner asked the department, my lords.
When did your father die?
My lords.
When did your father die?
Father died, my lords, on 29/11/1999, my lords.
When was the license transferred?
It was transferred to Yashodam then subsequent on that, my lords. Actually, that
That copy is not with us, my lords. We have applied to the department, my lords. It is yet to be received, my lords. But she died on 1/8/2011, my lords. Subsequently,
Had two sons, ma'am. One was, elder son was working in the government job. Hence, she transferred the license in the name of, other son, one more, other son. That is, he, under rule, 17B.
Hello?
Transfer
No.
after
The
the.
license was in the name of the father.
father, my lords.
Father
Yeah.
died.
The issue is
Then
in the
The license was transferred in favor of the mother.
Yes.
Mother has transferred.
mother has to take the consent of the, without the consent of the.
License to the son, mother, under.
Was the mother intended to sell the license all by herself?
No.
Yes, mother. I
No.
have annexure R1, can you refer my statement?
Next year.
Page number 12. ತಮ್ಮಲ್ಲಿ ಈ ಮೂಲಕ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಯಶೋದಮ್ಮ ಬಿ ಕೃಷ್ಣಪ್ಪ.
R1.
Yes, ma'am. Page number 12 in this right.
Yes.
ಕೋಡಹಳ್ಳಿ ಗ್ರಾಮ ಚನ್ನಪಟ್ಟಣ ಇವರ CL2 ಸನ್ನದನ್ನು 2010-11 ಸಾಲಿಗೆ ಹೊಂದಿದ್ದು ನನ್ನ ಆರ್ಥಿಕ ತೊಂದರೆಯಿಂದ ಮತ್ತು ತುಂಬಾ ಕಷ್ಟಕರವಾದ ಪರಿಸ್ಥಿತಿ ಇರುವುದರ ಪ್ರಯುಕ್ತ ನನ್ನ ಮಗನಾದ ಡಿ ಪುರುಷೋತ್ತಮ ಬಿನ್ ಕೃಷ್ಣಪ್ಪ ಅರಳಾರ್ ಸಂಘ ವಿರೂಪಾಕ್ಷಪುರ ಹೋಬಳಿ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಇವರ ಹೆಸರಿಗೆ ಸನ್ನದನ್ನು ವರ್ಗಾಯಿಸಿಕೊಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಕೋರುತ್ತೇನೆ.
ಎಷ್ಟು ಜನ ಮಕ್ಕಳು ಅವ್ರಿಗೆ?
ಇಬ್ರು ಮತ್ತೆ ಇಬ್ರು ಹೆಣ್ಣು.
ಗವರ್ಮೆಂಟ್ ಜಾಬ್ ಮಾಡ್ತಾ ಇದ್ರು, ಅವರು ಅವಾಗ ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು. ಗವರ್ಮೆಂಟ್ ಜಾಬ್
ಎಲ್ಲಿ ಹೇಳಿದಾರ ಹತ್ರ ಇಬ್ರು ತಾಯಿ ಎಲ್ಲಿ ಹೇಳಿದಾರ ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳಿದಾರೆ ಅಂತ ನೀವ್ ಹೆಂಗ್ ಹೇಳ್ತಿದ್ರ?
He bought the license.
The-
Purushottam paid the amount.
Purushottam is your brother.
Nothing, my lords. Actually, it was not been said to him at any cost, my lords. My lords,
Purushottam is your brother.
my lords.
Purushottam your brother.
Yes, my lords. He's my brother, my lords. My lords, in petition, my lords, page number 21, my lords. Annexion number, my lords.
No, your
F, my lords.
Your father died in 1999.
Yes, my lords.
2010, the license was transferred in the name of your mother. 2010.
No,
according
my
to your
lords.
synopsis.
2010, it was transferred in the name of my brother, my lords.
So 2010, when was it transferred in the name of the mother then? Much earlier.
Much earlier, my lords.
99 itself. For 10 years, it was the name of your mother.
It was in the name of my mother, my lords, but without the consent of her, my lords, it has been transferred to the name of my brother, my lords. There was no consent by her, by any of the legal heirs, my lords. My lords, it's not.
Tell us the information. He's working in the government, and
My lords.
so if
But they have to take the consent of us, my lords.
what is the rule
It is
which,
my right.
permits to transfer by succession? ಹೆಣ್ಮಕ್ಳು ಇಲ್ವಾ?
ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ. And there was no consent while transferring the license from the father to my father to mother, my lords. There was no consent, and the loop is there itself, my lords. Now, taking the due advantage of that, my lords, my brother has, my lords, he has, without the consent of me, my lords, he has taken the consent of my two sisters, my lords. And he has filed an affidavit to the department stating that they are ready to give that, my lords. Even after that, my lords, the department, without noticing me, my lordships, they have transferred this, my lords.
ನೀವು ಗವರ್ಮೆಂಟ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ?
Yes, my lords, I was in the government, my lord. My lordships, in this, my lord, there is a contrary by this thing itself, my lords. But what?
ಬೇರೆ ಸಿವಿಲ್ ಸೂಟ್ ಇದೆಯಾ?
My lords?
ಬೇರೆ ಸಿವಿಲ್ ಸೂಟ್ ಏನಿದೆಯಾ ನಿಮ್ಗೂ ಅವ್ರಿಗೂ?
Civil suit, I have to get, my lords. Actually, this is the NOC case, my lords. This is the first time I'm coming, so I'll just have to work on it.
My lord, I represent respondent number 5, my lord.
Yes.
My lord, in the year, my lord, 1919, my lord, after the death of the petitioner father and my father, my lord, the license was transferred in favor of my mother, my lord. At that point of time, my lord, the petitioner was in service, my lord. He is in police department, my lord. Therefore, my lord, he is unable to hold the license, my lord. At that point of my lord,
Why can't he hold the license if it was his
Lord,
father's
as per the
license?
rule, my lord, the government servant cannot hold the excise license, my lord, when he is having a profitable service in the government, my lord.
He is not applying for it. He is succeeding to it under rule 17A.
my lord,
He
my lord,
cannot apply, he cannot apply for a license. But if his father was a licensee, why can't it be devolved on to him?
my lord, my lord, even though my lord, when he is a public servant, he cannot hold the license, my lord, as per the 17A, my lord.
Read rule 17A.
My lord, CL, please, my lord. Transfer in the event of death. In the event of death, the licensee or the licensee, the deputy commissioner may on application by legal heirs of the deceased with the previous sanction of the excise commissioner, transfer the license or the lease as the case may be in their
So
favor.
the transfer can be only on the application of all the legal heirs, not just
Please.
one legal heir.
Yes, my lord.
Please, my lord. My lord,
If you
even
transfer in the name of your mother alone would
please,
be
my lord,
incorrect.
at that point of law, my lord, the petitioner has not objected because there is a prohibition for him to make an application or to object, my lord.
Then
At
I
that
will
point,
ask,
my lord, thereafter,
I'll
my
ask
lord, the
his name
license,
also to be included.
my lord, in the year 2010, my lord, my mother has transferred the license in
How
favor
can
of
your
me.
mother transfer? She is not the licensee. She is
My
the
lord,
successor to the license.
my lord, it was transferred under section 17B, my lord.
How?
Because, my lord, at that point of time, my lord, she has
Alright,
holding.
then I will hold that you succeed only to your mother's share and not to anybody else's share.
No,
Your
my lord,
mother's
that
share
issue
and
is
your
pending,
share.
my lord. Now, my lord, that issue is pending before the trial court, my lord. The petitioner has filed the suit for partition, my lord. Suit is also pending, my lord.
This is also subject matter of the suit.
Please, my lord.
This license is also subject matter of the
Please,
suit.
my lord. Please, my lord.
Where is the plaint?
Lord, in the petition, the petitioner has stated, my lord.
ಬೇರೆ ಆಸ್ತಿಗಳು ಏನಿದೆ? ಬೇರೆ ಆಸ್ತಿ ಏನ್ರಿ ಇದೆ?
Immovable
My lords, my lords, actually, this is the first time I have taken the case, my lords, actually, can I just have it?
What is the stage of the suit? Stage of the suit. Plaint ಇದೆಯಾ on record ಇದೆಯಾ ಇಲ್ಲಿ?
My lord, page number 9, my lord, para number 10. In para number 10, my lord, OS number 152 of 2021 before the learned senior civil judge Channapatna, my lord. Presented by Srimati Sumitra.
My lords, it's my sister has filed a case, my lords. It's not me, my lords.
No, in that suit, is this license also subject matter?
No, my lords. Let's put this.
ಎಲ್ಲ ತೆಗಿಸ್ತಿರಲ್ರಿ ಇವಾಗ, you're opening the Pandora's box. Your sisters also will now come forward.
Please, my lord, even my lord, this, my lord, the license is transferred in my favor, my lord, under section 17B, my lord.
No, the license was transferred in the name of your mother was on behalf of all the legal heirs. It was not an exclusive license to sell.
Because, my lord, at that point of, my lord, the petitioner, there is a bar for the petitioner.
Agala, you can't. How can you deprive the other children? It is your father's property. Everybody has a share.
Please, my lord. My lord,
Then
even,
you
my
should have
lord,
got your paperwork done correctly.
my lord, the petitioner, my lord, at that point of time, my lord, the petitioner, there was a bar for him to apply for.
Why are you worried? He will suffer. He would have resigned from his job.
My lord, now, my lord, after the lapse of.
How can you say that if he is disbarred, how can you become entitled to deprive him of a share? He has a share in the license.
No, let them, my lord, the suit, the rights of the parties can be decided in the suit, my lord.
So until then, you will enjoy the license.
That is what it is happening from past 10 years, my lords.
My lord, even, my lord, the assuming, my lord, as per the judgment of the Honorable High Court, my lord, the writ petition in the, my lord, the judgment reported in 2016 SCC online Karnataka 1834, my lord. My lord,
What is the next ref?
Annexure F is, my lord, the after adjudication, the department has given the endorsement, my lord.
It was not Yashodama's exclusive license to sell. At best, you would have acquired the right of Yashodama. And since you also had a share, your share was also included, but you can't deprive him of his share.
No, my lord, already, my lord, subject matter is seized by the civil court, my lord, let
It
the.
is filed by the sister, not
Please,
by
my
him. He may be a defendant there, but how can you deprive him of his right to have a share in the license?
Lord, in view of the judgment, my lord, this, the court, the honorable High Court has held, wherein, my lord, when there is,
Yenanta?
my lord, para number 3, my lord.
Yes.
My lord, when there is a suit is pending and there is a dispute regarding the legality of the petitioner, my lord, regarding license, my lord, the writ jurisdiction cannot be invoked, my lord. My lord, page, para 7, my lord, of the judgment, my lord. Insofar as the contention of that put forth by the learned counsel for the petitioner by placing reliance on section 17A of the rules, a perusal of the rule no doubt would indicate that legal heirs of the deceased license may make an application to the deputy commissioner of excise for transfer, and such application could be considered for transfer of license with the previous sanction of the excise commissioner in favor of such legal heirs. If in that light, the petitioners have sought for transfer.
Read para 9.
Please, my lord.
That's why this court refused to interfere.
Therefore, my lord, in the light of, if the provision is taken into consideration, unless there is an agreement between the legal heirs to seek transfer of license jointly in all their names or in the name of any of the one of the person with consent of the others, this court at this juncture cannot direct the license be transferred in the name of any one person where there is more one legal heir, my lord.
Para 11
Please, my lord. That apart, when I have already indicated that if there are more than one legal heir, it can only be the joint names of the name of the one person as agreed by others. In the absence of such agreement between the legal heirs, a direction in the writ petition to transfer a license to one legal heir would not be possible, my lord.
So therefore, if the license was transferred to Yashodamma without the consent of the petitioner, that would be wrong.
My lord, at that time, because, my lord, at that point of time, there was a bar, my lord.
What bar?
Because the petitioner was serving in the government.
That is not a disqualification here. That is not a disqualification here. The father has a license, he is entitled to succeed to it.
My lord, because, my lord, there was a bar there. Therefore, my lord, the license was transferred in favor of my mother.
There can't be a bar. You're under misconception. The bar can be for making an application for getting a license. But if his father had a license, on his death, he will succeed to the license. That is by operation of law, not by making an application.
Lord, even, my lord, legal, even though succession, my lord, there is a bar, my lord.
Illa country, bar irala. I'll quite just direct the name to be continued in the name of all the LRs. If all the LRs have rendered consent in favor of Purushottamma, it will continue in the name of Purushottamma and this person.
My lord, till then, my lord, the consideration, my lord, because all the legal heirs has to be consented for the license, my lord. They have to arrive. They have to arrive.
Did he grant a consent for transfer in the name of Yashodamma?
Please, my lord. At that point of time, my lord.
Where is the consent? If he has consented, then I'll accept the consent. Where is he consented?
Yes, no, my lord, petitioner has not given consent, my lord.
Then, if your sisters and your mother had and you had consented in the name of the license in the name of mother.
Please.
Yes, to that extent, Yashodamma's name will be there.
Please,
Yashodamma along with the petitioner.
Please, my lord.
The death of Yashodamma, your names will continue along with the petitioner.
Please, my lord. Now, my lord, after my lord, my mother, the license was transferred from my mother to in favor of my under rule 17B, my lord.
Yes, you have purchased your mother's share, not his share. The mother could not have sold the entire license. She had 1/4 share. If she had 2 children.
Please, my lord.
4 children, my lord.
She will have sold only 1/5 of her share.
Please.
Then if the sisters have consented, enjoy. But since he has not consented, he'll be entitled to 1/5 share.
My lord, if the Direction is given, my lord, in the, my lord, even the repetition is allowed, my lord, my right may be protected, my lord, because if the, now the present, the petitioners and other legal heirs made any adverse application to the authorities, my lord, the, again, license will be in the trouble, my lord.
There will be an adverse consequence. He becomes a license holder along with you.
Please, my lord.
So you will have to share the business with him.
My lord, let me, lord, it may be taken next week, my lord, I will come with the, any
Actually, there is nothing, my lords. There is nothing to be. It is a prima facie crime, my lords, and I'm suffering from past 10 years, my lords.
It may be treated
Just
as a
because of
matter, my lord, I will
I'm suffering from
take
past 10 years, my lords.
necessary instructions with my client, my lord. Let them, all the petitioners and the other legal heirs make a submission before this court. So the matter may be concluded, my lord, at the logical, my lord. Lord, I will take the instructions of my client, my lord. I will come back before this honorable court, my lord, next week, my lord. Let the all the petitioners, petitioner, respondent, and all the legal heirs make an agreement before this honorable court. My issue may be settled before this honorable court itself, my lord.
After the matter was heard at length, my lord counsel for the both respondent submits that he would secure instructions and explore the possibility of a settlement. So, release next Friday for further consideration. Or then a court mugskoldi adhan sumne.
Please, my lord, please.
Accept some amount and be done with it. For 10
Yes,
years,
ma'am.
he has run the business.
Yes, my lords.
Please. Oblige.
Next, second. Deeply obliged, my lords.
You're the petitioner.
Your Lordship, I appeal for the
Respondent in this case.
Your Lordship, this matter is about compensation for laying ST lines over my property by PGCIL respondent. In this case, Your Lordship, they have granted the compensation by treating my land as agricultural land. But admittedly, as per their own objections also, the land is residential in nature. It's non-agricultural in nature. Even before they conducted the survey, 1 year before they acquired the land for the purpose of laying ST lines, the land had been converted for non-residential purposes. So the valuation differs for agriculture and the non-agricultural land. But they've considered the valuation of an agricultural land for the grant of compensation, whereas they should have.
What is there to show it is converted?
It is there in their statement of objection itself, and annexure, give me a note. Conversion order is there at annexure B, Your Lordship, page number 60. They give their statement of objection.
They have drawn a line over this, or what have they?
They have drawn a line over this, and at one place they've constructed a tower also. So there are two types of compensations. The widths of the line will have to be compensated by considering 50% of the land value as per the Government of India guidelines under Section 67 of the Electricity Act. And for the area where they occupy the land itself, where the tower is installed, the land underneath the tower will have to be compensated at the rate of 85% as per the Government of India guidelines. But Your Lordship, kindly see the statement of objections itself. Page number 6.
Yes.
The supervisor, the first sentence, second line, Your Lordship. The supervisor of land and records, assistant director office, certified the survey report on August 2016. As per the survey report, survey number, so and so, all these survey numbers belong to me to the extent of 5 acres. Stood in the name of petitioner and were agricultural lands. Your Lordship, then the survey numbers, same survey numbers, were converted into non-agricultural on 28/1/2015. The survey happened in 2016. They put the lines after 2016. On 28/1/2015, they were converted as per their own statement of objection. Then the survey number 32, 34, 37/1, 37/2, 39/3 were again converted on 12/2/2015. After the survey had been conducted is what they're saying. The survey report was certified only in August 2016. Then see the next paragraph, Your Lordship. The respondent submits that the Deputy Commissioner Chikbalapur, based on the circle rate guideline value stamp rates, had determined the market value of the land with inputs from various sub-registrars and had arrived at the value of the lands for payment of compensation in various villages and has fixed 14 lakh per acre for dry wet agriculture land and 15 lakh for garden land. My land, Your Lordship, has been categorized as dry agriculture land, and I have been granted compensation at the rate of 14 lakhs. Kindly see the compensation that they've granted, Your Lordship. But
regarding the converted land being used for drawing a line. Is
Sorry.
there any guideline by the?
Your Lordship, the state, the central government merely says 85% of the land value have to be compensated wherever there is a tower. And where there's no tower, 15% of the land value.
No, but if it's converted land.
Yes.
You obviously can't put up a construction under the converted, under the line.
No, I can't put up the.
Conversion had
construction
lapsed also on that date.
Sorry?
The conversion had lapsed as on that date, my lords.
No, no.
Whether it's lapsed or not, that can be extended. How
It
can
has
you-
been extended. I provided the order also.
Lords, my only contention is, he has a remedy under section 16 to file a petition before the district judge. Seek for enhancement in the event the compensation paid is not adequate under section 16 of the act. He has received the compensation, there is no dispute about it. Annexure R4, which I have filed
Ask you to
at
read
page
it down.
number,
I'll ask you to redetermine the compensation on the ground that they are converted lands. And I'll also direct you to redetermine the compensation in regard to the fact that they can't use the entire corridor area for the converted purpose. You would have spent enormous amounts of money to get it.
I've already drawn the lines, my lords. I've drawn the lines as of 2018 itself,
You may draw the
2017.
line. You may draw the line, but compensation that you have to pay.
Compensation we are willing to, my lords, and let it be determined by the district judge. I have no problem.
So you will have.
Because that will be factual.
Your
Yes, that is
assumption
what it says, my lords.
your
My lords, that is
assumption
what it says.
that is not correct.
Sorry, my lords.
Your
I didn't
assumption
hear.
that it's your assumption
Yes, number.
that it was an agricultural land and you will compute the value of the land as it is an agricultural land is incorrect. That is a fundamental error.
My lords, to that extent, my lords, in the event it was converted as on that date, yes. And if there is something more which he is entitled to, he will have to establish it. My lords, my only.
You are admitting in your counter.
Well, I have stated so that there was. No, I'm not disputing it. I'm not disputing it. All I'm trying to say is, my lords, the only thing is I don't want to push you from one forum to another forum. I don't want to do
That's what you
it.
have.
I just thought that in the event I might have to have the right to cross-examine him. If for some reason he has certain.
Redetermine the compensation by considering it as a commercial land. Thereafter is agreed, will again go to the district judge under section 16.
Yes, sir.
This is a fundamental error in your calculation. That will have to be redone, isn't it? In the light of your admitted
Just
position.
not, if it finds favor in the eyes of the court, if my submissions find favor, I just thought once and for all he can go under section 16. And if he is entitled to, if he establishes it, I'll give it to him. I'm bound to pay.
Redetermine it. Thereafter let him go. You're just going to
It's the
hold on to
deputy
the
commissioner who has to do it, my lords. My lords, that will be the deputy commissioner. Under the guidelines framed by the Ministry of Power, it is a deputy commissioner who has to do it.
Anything else?
That's all.
Get in the afternoon.
Very good. Grateful.
Sorry, Sanction express.
Lord, but serial number 46, Lord, the matter is settled between the parties. Appear for respondent number 2. Another friend appears for the petitioner, Lord.
What is settlement?
It is a case of complaint and counter complaint, Lord. Both are.
What is here?
Please.
I'll take it in the afternoon. I have a division matter, Christian can't take it.
Please.
Lordship, kindly, my lord.
Serial number 4, they are not prepared to file that update today also. APMC, they are requesting the next week. May I kindly request my lord in the next week, let the.
Lordship, we are filing.
Along
this statement of objections, affidavit is also there.
No, that other advocate requested accommodation. Who is representing the 7th respondent, the committee, APMC committee. Next Friday, further hearing and they want to avoid it because the market, they have spoiled it.
Next Friday for the consideration.
Lordship, in the reserved matter, Lordship sought for an original file of entire levy. Before acquisition, all the documents are here, JMC has been done, everything is here, I will hand over.
Because there is some doubt as to whether there's the industrial area around. It is not very clear in the map.
And
What is the industrial area around that?
before issuing preliminary notification, all communication and JMC is also done. That is with this.
My lord, serial number 44, my lord. The petitioner is seeking the prayer for the adoption of section 47 clause 5 of the Electricity Act, my lord. I need some information because number of restrictions are.
My lord, petitioners are present, my lord.
Because
My
I
lord,
need
if
to.
the matter
highlight
could be
this
heard today,
also,
there's
my
an
lord.
urgency in the matter, my lord. It was posted today to.
Serial number 49. Senior counsel inconvenience ಇದೆ ಸರ್. more ಅವ್ರ ಫೈಲ್ ಅವರೇ ತಗೊಂಡೋಗಿ one week time.
Thirty-two ಏನು ಆಯ್ತಾ? ಸರ್ 32 2 ನಂಬರ್ 32 ಅಜ್ಜನ 32 ಎಷ್ಟು ಬೆಂಚ್ ಹೋಗಿ ಬರ್ತಾರೆ ಧಾರವಾಡನಲ್ಲಿ.
ಸರ್ ಒಂದು ಮ್ಯಾಟ್ರ್ 19ಗೆ ಇತ್ತು, ಡೈಲಿ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ. 19ಗೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಮ್ಯಾಟ್ರ್ 11235 ಆಫ್ 24. ಅದ್ ಕೆಳಗೇನೆ ಪೆಂಡಿಂಗ್ ಅಲ್ಲೂ ಇಲ್ಲ ಸರ್, ಬೆಂಚಲ್ಲಿ ಕೇಳಕ್ಕೆ ಹೇಳಿದ್ರು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ರೆಸ್ಯೂಮ್ ಆಗುತ್ತೆ ಸರ್?
ಸರ್ ಪೆಂಡಿಂಗ್ ಹತ್ರ ಕೇಳಿದೆ, ನಿಮ್ಮ ಇಲ್ಲೇ ಇದೆಯಾ ಕೇಳಕ್ಕೆ ಹೇಳಿದ್ರು. ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದು. 19ಗೆ ಇತ್ತು ಮ್ಯಾಟ್ರ್, ಅದು ಡೈಲಿ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ. ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದೆ, ಅಲ್ಲೂ ಇಲ್ಲ.
ಏನ್ ಸೀರಿಯಲ್ ನಂಬರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 74 ಇತ್ತು 19ಗೆ 11235 ಆಫ್ 24. ಬೃಂದಾವನ್ ಇದೆ, ಹೈಡ್ರೋ ಇದೆ.
ರಿಸರ್ವ್ ಮ್ಯಾಟರ್.
ರಿಸರ್ವ್ ಮ್ಯಾಟರ್. ಟೈಮ್
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಏನಾಯ್ತು?
ರಿಸರ್ವ್ ಫಾರ್ ಜಜ್ಮೆಂಟಾ ಸರ್?
6 ನಿನ್ನ ಏಜಿ ಬಂದಿದ್ದಲ್ಲ ಬಿಟ್ರಾ? ಆ ಟೈಮ್ಗೆ ಕರ್ದಿಲ್ಲ, ಮುಂಚೆನೆ ಕೊಟ್ಟಿದ್ರು ಅಂತ ಅಂದ್ರು ಗೌರ್ಮೆಂಟ್ ಅವರು. ಇಲ್ಲ, ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಏನಾಗಿದೆ ಸರ್? ಕೋಡ್ ಆಫೀಸರ್ ಸರ್.
1 ವೀಕ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ.
ಆಯ್ತು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ರೆಸ್ಯೂಮ್ ಆಗುತ್ತೆ ಸರ್? ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ರೆಸ್ಯೂಮ್ ಆಗುತ್ತೆ ಸರ್?
ಹೌದು, ಬೆಂಚ್ ಇದೆ ಒಂದು, ಅದಾದ್ಮೇಲೆ ಬರ್ತಾರೆ.
ರೈಟ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
The court officer. Hello, court officer.
Hello. What is, sir? Hello. What up, sir?
Court officer. Court officer, court officer, Court officer. Court officer. Hello, court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಸರ್, ಧಾರವಾಡದಿಂದ ಅಭಿಷೇಕ್ ಮಾಲಿ ಪಾಟೀಲ್ SCGP ಅಪೇರ್ ಆಗ್ತದೆ.
ಎಲ್ಲ ಮ್ಯಾಟ್ರಲ್ಲಿ ನೀವೇ ಅಪೇರ್ ಆಗ್ತೀರಾ?
Sorry, my lord, I'm troubling your lordships again.
Shabas.
Shabas
Your
is
Lordships, Your Lordships, I appear for the respondent SLDC in the matter. We have received instructions. They will be issuing standing clearance by 5 o'clock today.
ಅಲ್ಲ, ನಾಳೆ 2 ದಿನ ರಜಾ ಇದೆ.
I'll call it at 5:30. Ask him to do it by before
Please.
4:30.
Please, Your Lordships, we'll do that. Great.
Downward bench matters. Seal number 1, Shri Anandar Kolli.
Please, for the petitioner matters.
Yes.
Was already connected petition as allowed by this honorable court matters in annexure C matters. The petition,
Ask Katsurma to take notice.
please. Matters sought for stay matters. Is being a government servant matters.
I'll have it next Friday. Take out notice on him. To Katsurma to take notice for response. Relist on. Okay.
Seal number 2, Shri Naveen Chitra.
Your Lordship, in this case, I'm appealing for the petitioner, Your Lordship. In connected matters, Your Lordship, Your Lordship has allowed the petition which is filed with accused number 2 and 3. And now the accused number accused number 1 has filed the present petition. This matter is squarely covered. The copy of the order passed by Your Lordship is produced at annexure D at page number 57, Your Lordship.
Take out notice on Katsurma.
ಇಲ್ಲ ಸ್ವಾಮಿ, ರೆಸ್ಪಾಂಡ್ ಅವರು 1, 2 ಗವರ್ಮೆಂಟ್ ಅಪೇರ್ ಆಗ್ತಾರೆ ಸ್ವಾಮಿ.
ಗವರ್ಮೆಂಟ್ ಅವ್ರತಾನೆ?
ಹೌದು ಸ್ವಾಮಿ, 1 and 2 ಇಬ್ರಿಗೆ ಅಪೇರ್ ಆಗ್ತಾರೆ ಸ್ವಾಮಿ ಅವ್ರೆ. ರೆಸ್ಪಾಂಡ್ 1 and 2.
ಅದನ್ನ ಹೇಳಿ Katsurma ತಗೊಳ್ಳಿ ನೋಟಿಸ್ ಅಂತಂದೆ ಇಬ್ರಿಗೂ.
ಹಾ ಸ್ವಾಮಿ.
Seal number 3. Seal number 3. Anwar Pasha.
Katsurma to take notice for respondents relist.
Passed over matters. Seal number 5, Shri Ramesh Chandra.
For the petitioner, my lord.
Appearing for the respondent.
Idರಲ್ಲಿ they have disconnected the electricity on the ground that the Khata has been challenged. That was challenged in this before this honorable court. A status quo was order passed, my lord. Bescom has disconnected the electricity on the ground that Khata has been cancelled by the BBMP. Writ petition was fine.
The Revati by name owner, my lord, she has filed objections before our MD, my lord, stating that the Kata has been cancelled and the BBMP also has given the letter. Based on that, we have done, my lord.
How many years did you have connection? ಎಷ್ಟು ವರ್ಷದ connection ಅದು?
ಸುಮಾರು 15-16 ವರ್ಷದಿಂದ.
My lord, there is earlier the owner by name Revati was there. They have purchased.
Electricity connection was in existence for 15 years?
Yes, ma'am, it was there. The BBMP has issued the letter for us for the.
Where is that letter?
My lords, may annexure A, my lord, they have stated in the.
Copy ಇದೆಯಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ, ಅದನ್ನ produce ಮಾಡಿಲ್ಲ. I'll file my statement.
Party here?
ಇಲ್ಲ, ಅದು ಅವರು ಏನು ಕೊಟ್ಟಿದಂಗೆ ಕೊಟ್ಟಿಲ್ಲ ಇಲ್ಲಿ. ಅವರು ರೆಸ್ಪಾಂಡ್ ರೇವತಿನ ನಾನು ಇದರಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ BBMP ಕೇಸಲ್ಲಿ.
ಸೂಟ್ ಇದೆಯಾ ಅನ್ನೋದು? ಇಲ್ಲ,
ಸೂಟ್ ಇಲ್ಲ. He is the one of the ನಮ್ದು ಫ್ಲಾಟ್ ಸ್ವಾಮಿ, one flat. He is the neighboring owner. She complained. 2003 21 ವರ್ಷದಿಂದ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆ.
There is a one.
ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು.
ಅವ್ರದ್ದೇನು ತಕರಾರು ನಿಮ್ಮ ಮೇಲೆ?
ನಮ್ಮ ಮೇಲೆ ಅದು ಅನ್ಆಥರೈಸ್ಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಇದು ತಕರಾರು. ನಾವಲ್ಲ, ಅದು ಹಿಂದೆಡೆ ಅದು 2011 ಹಾಕಿದ್ದಾರೆ. ದಟ್ ವಾಸ್ ಅಲೌಡ್. ಆಫ್ಟರ್ 11 years ಇದು ಹಾಕಿರೋದು, ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದು. ದಟ್ ಇಸ್ ವೈ ಐ ಫೈಲ್ಡ್ ಅ ರಿಟ್ ಪಿಟಿಷನ್ ಹಿಯರ್. ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ವಾಸ್ ಪಾಸ್ಡ್. ಲಕ್ಷ್ಮಿ ಕಳಿಸಿ ಪೇಜ್ ನಂಬರ್ annexure.
My lord, as per my information, one suit is there, my lord, 880.
ಅವ್ರ ಪಾರ್ಟಿ ಇದಾರಾ?
ಹೌದು, ಅವ್ರ ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
Post along with the number so and so. As an interim measure, the respondents, the Bescom, is directed to restore the power supply to the petitioner's apartment.
Apartment.
So the petitioner shall over be liable to pay the electricity charges.
Number 9.
26,870.
My lords, we had in fact informed the landlord advocate that 25 is what we could push. I tried my best to push them to 25. They were at 15. I requested them, told them you can put an end to the.
I'll just ask.
Joint memo ಆಗ್ತೀರಾ ಏನ್ ಮಾಡ್ತೀರಾ?
Lordship may record it and
Please.
by next Friday we'll let it be treated as.
My lords, in fact, this may be taken as part heard. We'll report it to your lordships.
Lordship may record the.
Release so for further consideration. Next Friday. Get the DD ready and close this.
I'll require a couple of days time to bring the DD.
Next Friday.
Next Friday. Next Friday. My lords, a week after next, they'll have to go 25 minutes. My lords, week after next, the date may be fixed. Interim order may be extended, my lords. Grateful, my lords.
Seal number 11. Srimati Sudha.
My lord, Madam Baliga was appearing for depot manager R2. She's on her legs in Court Hall 1 and has sought for a short accommodation for Monday. However, my instructions on behalf of R1 is the permission for releasing of the funds has been granted. 24 to 48 hours, my lord, and we'll make the payment.
Released on Wednesday. Wednesday first.
Seal number 16. Petitioner.
ಹೆಸರು ಮಾಡೋಣ ಸರ್.
Seal number 22. Shri Tejas.
Please, sir. Let the matter be referred to the mediation, my lord, in the whole article.
Mediation and advertisement, that's another tactic to.
No, not like this, my lord. We have informed the client, accused number 1. We informed that this honorable court has insisted to go for a settlement, and but he is asking for it some time. That is the issue, my lord.
Post next Friday for further consideration.
Please.
It has parted next Friday. By
Please.
that time, see that it is settled.
Please.
Seal number 38.
Petitioner, my lord. Now the only appreciation that since the my lord corridor line passes on them, or ಅದು ಯೂಸ್ ಬಾವಿನ ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೂ ಆಗಲ್ಲ ಬಿಕಾಸ್ ಅಲ್ಲಿ 2 ಸತಿ ಮೋಟರ್ ಇನ್ಸ್ಟಾಲ್ ಮಾಡಿದ್ದಾರೆ. ನೀವು ಆಫ್ ದಿಸ್ ಹೈ ರೇಡಿಯೇಷನ್ಸ್ ಮೋಟರ್ ಕೂಡ ಹಾಳಾಗ್ತಿದೆ ಒಂದು ಅಂಡ್ ಲೈಫ್ ಥ್ರೆಟ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. Now I just explain it. Since water is a bad conductor of electricity, my lord is aware of that. Water is a bad conductor of electricity. So ನಿಮ್ಗೆ ಏನು ಇದಿದೆ ಪವರ್ ಸಪ್ಲೈದು, it has an impact on the usage of this well also. So that I just want to bring it to my lord's notice. ಹಂಗಾಗಿ ನಾನು ದುಡ್ಡು ಕೊಡೋದು ಕೇಳ್ತಿಲ್ಲ. This is only contention that tomorrow some mishap happens, then they would hold me liable for that. So for that I need some lord protection from the court.
What mishap can happen?
ಈಗ ಅಲ್ಲಿ ಬೋರ್ವೆಲ್ ಪಂಪ್ ಸೆಟ್ ಇನ್ ಮಾಡಿ ಇನ್ಸ್ಟಾಲ್ ಮಾಡಿ ದೆನ್ ಅದು ತೆಗೆಯುವಾಗ ಮತ್ತೆ ಯಾರು ಬಾವಿಲಿ ಹೋದಾಗ ಅದೊಂದು ಕಳಜಿದೆ ಅವ್ರಿಗೆ, ಅದನ್ನ ಗಮನಕ್ಕೆ ತನ್ನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
If you can establish that some mishap occurred because of the power line.
That's exactly what he want to appraise of that fact. So the rest of that, that's the only thing.
The claim in this petition is for issuance of a mandamus to direct respondents 1 and 2 to pay compensation. But it is the case of the petitioner that the respondents had in fact assessed the compensation in respect of the open well, which was situated below the power line, which has been drawn. And therefore, he would be entitled to compensation. An argument is advanced that because the compensation for the open well was assessed, there is an obligation on the part of the authorities to pay compensation. Not counsel appearing for respondents on the other hand contends that the petitioner would be entitled to make full use of the open well that exists underneath the line that has been drawn. And there will be no impediment from the respondents for using the well, and the respondents cannot be directed to pay compensation in respect of a well which continues to exist and which continues to be in the use of the petitioner. A perusal of the photographs which are produced along with the writ petition do indicate that the well continues to be in existence and there is no impediment for the petitioner to use the said well for his agricultural activities. If the well continues to be in existence and also is being used beneficially for the petitioner, the question of the respondents paying compensation for this open well as claimed in the representation will not arise. I see no reason to entertain the petition. Petition is therefore dismissed.
Sorry to interrupt. They said they will not interrupt because that's what my ground before the court.
Clear that the respondent authorities shall not cause any impediment for the petitioners to make use of the open well that exists underneath the line that has been drawn.
ನಮ್ಗೆ ಹೇಳಿದ್ದೆ ಅವ್ರು ಮುಚ್ಚಿ ಯೂಸ್ ಮಾಡ್ಬೇಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಕೋರ್ಟಿಗೆ ಅದೇ ದಟ್ ಇಸ್ ಓನ್ಲಿ ರೀಸನ್ ವಿ ಹ್ಯಾವ್ ಕಮ್
Number 40. It's above.
Number 40, my lords, serial number 40. I just have an additional submission to be made, my lords, if it is.
Yes.
Lords, sir, what has happened is, my lords, in so far as this conversion order itself, which has been produced, the conversion order says that within a period of 2 years, he has to use it, which he has failed to do so. Only in 2019, he has again reapplied for renewal of conversion.
So Samuel, you are aware the moment they collect the conversion fine, the nature of the land stands changed automatically. Whether they.
He has not done it. He has not done it. That is the thing.
Whether he
And
has
my
done
lords,
it or
and
not.
I don't have the power to adjudicate. I
No,
don't have, because I go by what the DC says.
I have
The
power to
DC has
adjudicate.
fixed it.
I have the power to adjudicate. I will hold that the moment conversion is filed, the nature of the land stands converted automatically, whether it has been completed within the time stipulated or not. We are concerned with the nature of the land, not whether the order was implemented or adhered to.
It's page 77, my lords, if I can just show it, just for a minute, my lords, for my own satisfaction. Page 77, clause number 12, my lords. I just tell me, read it out.
13. Clause number
ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ PWD 711.
No, 13. Clause
13.
13.
Yes.
ಭೂ ಪರಿವರ್ತನೆ ಮಂಜೂರಿ ಯಾವ ಉದ್ದೇಶಕ್ಕೆ ಆಗಿರುತ್ತದೆ ಅದೇ ಉದ್ದೇಶಕ್ಕೆ ಈ ದಿನದಿಂದ 2 ವರ್ಷಗಳ ಒಳಗಾಗಿ ಉಪಯೋಗಿಸತಕ್ಕದ್ದು.
Is there a consequence? Will it lapse?
If it is not lapsed, he went and approached for a renewal in 880.
It lapse in the change, when the nature of the land become agricultural again.
No, my lord, if it is.
It will not, my lords, it will not become agricultural again. What I'm trying to say is, at the time when he had not used it, I had drawn the lines. And the deputy commissioner has said that he's only granting compensation based on this. If he wants, let him approach the deputy commissioner. I have no problem.
No, according to me, he'll be entitled for compensation for the entire corridor stretch because he cannot use it for erecting any buildings. If it is an agricultural activity, at least he could have used that land. And therefore, they would pay 30% of the value of the land. But now by virtue of this power line, if he wants to use the land.
Whatever he is entitled to as per the Supreme Court guidelines, we have no problem. But let it be adjudicated by the deputy commissioner, because I don't have powers either under the act to do so.
No,
So I displace the judgment of the Supreme Court, my lords, in a century text.
No, by my order, I will empower you to decide Supreme Court compensation in the.
Supreme Court judgment, my lords, in the century textiles, my lords, I just place it before the court, only for the power, so that it will benefit.
Where is the order assessing compensation?
Your lordship,
The order assessing compensation.
that order, your lordship, is at annexure D. C.
84.
84, sorry.
84.
Sorry.
No.
No.
Which is the order by which?
Annexure D, 87, your lordship. Annexure D.
Annexure E, page number 90.
Annexure D is the PGCL document, the respond number 1. And annexure E is the
Based on the annexure E, my lord,
deputy commissioners.
compensation has been paid. Annexure E, my lords, assessment determination of compensation.
D is a summary of the affected landowners with extent details.
They've given the rate of compensation also, and they've classified the land also. This is the respond number 1's document.
My lord, your lordship kindly peruse annexure E, my lords.
It is based on annexure E. Yes, annexure E is the deputy commissioner. Page number 90.
Zero.
You're challenging annexure E.
No, they are not challenged.
They have
No,
not
yeah.
challenged annexure E.
No, your lordship, compensation to us has been paid by respondent number one, not by the DC.
On the basis of annexure E, isn't it?
On the basis of annexure E, your lordship, it may be directed that the DC has to rework the compensation by treating this land as non-agricultural land.
Challenge annexure E for a minute.
They are not challenged.
Wait a minute. What is the judgment you want to rely upon, Samuel?
It is in Century Textiles, my lords.
Which
Page
paragraph?
number, paragraph number 28 and 29. Over the page.
This petition is filed seeking for a direction to the second respondent to pay eligible compensation towards residential lands belonging to the petitioner in terms of the provisions of the Electricity Act, read with section 10D of the Telegraph Act. In compliance with the guidelines laid down by the Government of India, right, annexure F. The prayer is also made to direct the second respondent to assess the compensation in the light of the present day market value, or in the alternate, direct the petitioner to pay interest at the rate of 14% per annum from the date of acquisition till the date of the payment. It is not in dispute that lines were drawn over the lands of the petitioner, and the details of the lands which are affected by the drawing of the power line is indicated in annexure D. It is also not in dispute that before this line was laid,
And also, annexure D is comprising of all the farmers, but only pertaining to petitioner is
it
certain.
is also not in dispute that the lands belong to the petitioner is also included in annexure D.
Yes.
Then counsel for the petitioner submits that the lands of the petitioner were in fact permitted to be used for non-agricultural purposes as provided under section 95 of the KLR Act, and the petitioner had also paid the conversion fine. He therefore submits that the land in the nature of the land cannot be treated as an agricultural land, and for the purpose of assessing compensation, the respondents are required to ascertain the value of the land as a non-agricultural land and thereafter determine compensation. He submits that the respondents on the other end are seeking to rely upon the official memorandum dated 20th of March 2018 issued by the Deputy Commissioner, in which the Deputy Commissioner has fixed the value of the lands on the premise that all of them are agricultural lands. He submits that the beneficiaries have paid compensation only in accordance with this particular official memorandum, which would be incorrect, and the petitioners would be deprived of their right to an appropriate compensation. Sri Samuel, appearing on behalf of the beneficiary, contends that the petitioner's petition ought not to be entertained, since he has an alternative remedy of approaching the district judge under section 16 of the Telegraph Act. He also makes a submission that the order of conversion that the petitioner placed reliance upon was to be utilized within a period of 2 years. And since admittedly this land was not used for the purpose for which it was permitted to the Deputy Commissioner within 2 years, the petitioner cannot claim compensation on the premise that it is a non-agricultural land. It is to be stated at the very outset that the moment the Deputy Commissioner exercises statutory power under section 95 of the Land Revenue Act and permits the occupant to use it for a non-agricultural purposes and collects the conversion fine as provided under the provisions of the Land Revenue Act and rules, the nature of the land is irreversibly changed. The value, the requirement of utilizing the land for the purpose for which it is permitted within a particular time frame would have no consequence for determining the nature of the land. It is to be noticed that even if the period of 2 years had elapsed and the land had not been utilized, for the purpose for which it was permitted, the land would not revert back to being an agricultural land. Since on the permission being granted under section 95, the nature of the land stands converted and the land transforms to be a non-agricultural land, the compensation payable in respect of this land would also have to be on the premise that is non-agricultural land. The respondents therefore were not justified in placing reliance on the official memorandum of the Deputy Commissioner dated 23/2018, Annexure E, to determine the compensation on the basis that the lands of the petitioners were agricultural lands. As far as the argument that the petitioner has an alternative remedy to approach the district judge, in my view, it is settled law that an alternative remedy is not an absolute bar. In this case, it is not, it is in fact admitted by the respondent beneficiary that the lands had indeed been converted prior to the drawing of the lines. But nevertheless, the beneficiary contends that as per the OM, they have treated the land as agricultural lands. In the light of this admitted position, that the lands had been permitted to be used for a non-agricultural purpose by the Deputy Commissioner under section 95, even before the line is drawn, the entire basis for arriving at the compensation would palpably be incorrect. And therefore of the view that notwithstanding the fact that the petitioner has an alternative remedy, it would be appropriate to direct the respondents to redetermine the compensation.
Only respond number 3.
Respondent number 3 to redetermine the compensation by considering the land of the petitioners as non-agricultural lands.
And in accordance with the
third respondent shall also take into consideration that by virtue of the order of conversion being granted, the entire corridor area cannot be used for, what is the purpose granted? What is the purpose?
residential, Your Lordship.
The entire area cannot be used for erecting residential buildings. The third respondent shall therefore consider payment of compensation in respect of the corridor area, keeping in mind that the entire piece of land under which the lines are situated cannot be used as provided under the permission granted section 95(3). So this exercise of redetermining the compensation shall be carried out within a period of 2 months from the date of receipt of a copy of this order.
Your Lordship, if I may request, compensation to be determined as per the guidelines of central government in the same.
Saying, let them do it whatever. If you go by the guidelines, you will not get the comment of the entire area.
Yes.
So they will not abandon that government guideline, but I think you should press for the entire area.
Entire area, yes, Your Lordship. Grateful, Your Lordship.
Also number 16.
Yes.
Plaint, Your Lordship, para 4, he has given the same statement. Para 4. What is the, he has relinquished the right to Elkondili.
No, where have you said about this forced consent deed, consent application?
Consent application, he has stated that consent, ಒಪ್ಪಿಗೆ ಪತ್ರ ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲ. ಅದರಲ್ಲಿ what he has said is, he has stated that I have relinquished my right ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೇಳಿ.
ಈಗ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ ನೀವು?
ಅಲ್ಲಿ ಒಪ್ಪಿಗೆ ಪತ್ರ ಹೇಳಿದ್ದಾರೆ.
ಅದು ಇಲ್ಲ.
ಅದು ಸ್ಪೆಸಿಫಿಕ್ ವರ್ಡ್ ಇಲ್ಲ, ಬಟ್ he has ಅಲ್ಲ ಜಸ್ಟ್ ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ಕೆಳಗೆ ನೀವು and I have relinquished my right ಹೇಳ್ಕೊಂಡು. That's the reason, Your Lordships, because let the investigation go on.
Petition allowed.
Much.
Seal number 41.
For petition. Annexure A and B are charged. But father of the petitioner, my lord,
we'll file our objections, Your Lordship.
it is covered by Annexure
Your Lordship,
C, my
it's
lord. Kindly see,
2024 matter and I have to check with the records and file the object.
kindly see
Take the
page number.
instruction from officials.
24th matter, sir, time ಕೊಡ್ತೀನಿ. 2024 matter.
Actually,
We list.
cover Annexure N.
42. Pawan Chandra Shetty.
In this case, I appear for the respondent.
Yesterday's matter, my lord.
The yesterday matter. Let that so far as in terms of the circular
Judgment.
that I may make one submission. Where that it is a division bench the heard the matter and reserve for pronouncement. With regard to the two grounds that where nominal compensation based on the circular which made that he requires to be agitate before the trial court. To the extent that where that they have to establish that as to the compensation quantum entitlement by giving even that apply the Motor Vehicles Act. Under the MEC that some extent doctor evidence, all this has been recorded. That even in the writ petition that nothing has been placed on record, those things are concerned. Under
This
this,
is notional income.
the even notional income that it has to be taken into no consideration. Under those circumstances that it is an entire body of the that percentage has to be assessed. The doctor has to be examined. All these things are not the division bench heard and reserved. That may kindly be treated as a parted and may kindly post it on week after next week. That outcome of that not that
ನಾನು ಇದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿ
ಅಲ್ಲ ಬೇಡ ಬೇಡ
Smell.
ಬೇಡ ಸುಮ್ಮನೆ ಬಾರ್ಡನ್ ಬೇಡ may kindly treat parted that I am not saying that treat parted
ನಿಮ್ಗೂ ಇನ್ನೊಂದು ಕೇಸ್ ಆಗುತ್ತೆ
ಬೇಡ ಬೇಡ ಬೇಡ
ಸಪೋಸ್ ರಿಟ್ ಅಪೀಲ್ ವಜಾ ಆಯ್ತು ಅಂತಂದ್ರೆ
that if it then I will consider that I will place it on the judgment that I will consider that place it on judgment and I will leave it to the court so far as the determination is concerned. Week after next week,
My lord,
Further
further
consideration.
hearing, my lord.
much.
for further consideration.
Much obliged, my lord.
Number 43. Srimati Asha K.
To appear for the petition this case, my lord.
Okay.
This case.
Yes. Yes. Yes,
Let
let
up-
matter.
Yesterday's, partly heard and yesterday.
Paper comments.
Well, ma'am.
Today.
Stay order copy which is granted by the civil court.
Have they entered appearance? What is the stage of the suit now?
Suit, evidence stage, my lord.
Do you have a copy of the written statement?
Written statement already filed and evident, no,
A copy of the
I am the plaintiff in this case.
Do you have a copy of the written statement?
Copy of written statement, I don't find. To get the electricity connection, my lord, possession proved.
Because here there's no finding recording your possession. Therefore, I'm asking you.
Yeah.
If there's a finding recording your possession, it would have been easy for me to dispose it of.
Okay, we are in the position in order to prove the same gas connection agency bill has been furnished as annexure by page number 32. And my lord, so the Aadhaar copy of the petitioner.
My lord, the question before your lordship is there whether they are authorized occupation or unauthorized occupation. my
But
lord.
you have given them temporary connection,
Yeah,
then you accept their possession.
the temporary connection, I have to take the instruction by my lord, on what basis AW has given. So that I will check with my, but the
Next sir sees the house. Next sir sees the photograph of the house.
Yes, same house.
temporary connection already surrendered, my lord. They are asking for the permanent connection now.
Temporary connection was obtained for purpose of construction, my lords. After completion of construction, they surrender duly.
But my condition of supply clearly says that, my lord, I can't furnish the permanent connection.
I'll pass an order permitting you to grant power supply permanently, subject to the result of the suit. I'll make clear that he will not claim any equity on the basis of this electricity connection. If he loses in the suit, he will have to surrender that also. If he has put up a construction,
Yes, my lord.
he should have electricity, isn't it?
However, my lord, the condition of supply clearly says, my lord, I can't grant the
I can grant is included in the sixth.
Obligation.
The prayer in this petition is for issuance of a mandamus to provide electricity connection to the house of the petitioner. The petitioner contends that he was granted a temporary connection and he had thereafter surrendered the same and had sought for a permanent connection. Over this permanent connection that he had sought for is refused on the ground that there was a civil suit pending in industrial suit property between the petitioner and another. Learned counsel for the petitioner points out that the house is completely constructed as could be seen from the photographs produced on Annexure C. And the electricity receipts that are produced as Annexure D would also indicate that the temporary connection had been given to the premises.
My lord, as a special case, it may not be relied in future.
Learned counsel for the petitioner submits that the petitioner had secured an agreement of sale under which he had paid the entire sale consideration to the owner. And since there was a denial to execute the sale deed, he was constrained to file a suit in OS 187/2023. And in the said suit for swift performance, and in the said suit, the trial court has also granted him an interim order and protected his possession. And an interim order status quo, thereby protecting his possession. Learned counsel appearing for BESCOM on the other hand submits that in light of a civil dispute regarding the property in question, it would not be able to entertain the application of the petitioner for grant of power supply permanently.
Return objection.
And the regulations don't provide for granting electricity connection. A perusal of the photograph at Annexure C would indicate that there is a full-fledged construction put up and the receipt which is produced Annexure D also indicates that the said premises was serviced with a temporary connection. The petitioner has also produced a receipt for establishing that he has availed of a gas connection, an LPG gas connection, LPG connection, and he has produced the identity cards of his two children to indicate that they are residing in the said premises. In my view, the very fact that BESCOM had granted the temporary connection by itself establishes the possession of the petitioner. If a person would avail of a temporary connection has thereafter put up a structure and claims for grant of a permanent power supply from it would be improper for BESCOM to put up the plea that the premises is unauthorized. So, if there is any civil dispute pending in respect of the property, obviously the grant of electricity connection would be subject to the result of the ultimate decree that the civil court may pass. In the instant case, it would be appropriate therefore to direct BESCOM to provide permanent electricity connection to the petitioner. Shall however be a condition that this permanent connection granted to the petitioner would not result in acceptance by the BESCOM that the premises was, that the property was free from dispute. The connection that the BESCOM should provide shall be subject to the ultimate result of the suit. And if the petitioner fails in the suit and is called upon to surrender possession, he shall not claim any equity on the premise that he had been granted electricity connection. So, BESCOM is therefore directed to grant power supply as ordered above. The writ petition is disposed of in the terms mentioned above.
Return objection is pending. I am filing return objection.
Written,
Objection.
See number 44, Sridhar Prabhu.
Word matter, my lord. Under section 47, my lord,
Time ಬೇಕು ಅಂತಿದ್ರು.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ
Lord,
ಇಷ್ಟೇ, I'll only,
File my statement of objections, my lord. They are seeking the prayer 47.5 has.
ಇಲ್ಲ
three
UPI ನಲ್ಲಿ,
implications.
I'll open the case.
ನೀವು ಬೇರೆಯವ್ರಿಗೆ ಒಂದು ಅವಕಾಶ ಕೊಡಿ.
ಇಲ್ಲ ಇಲ್ಲ, ನನ್ ಕೇಸ್ ಆಯ್ತು.
ನಾನೇ ತಾನೇ ಕೇಳಿದವ್ರನ್ನ.
ಇಲ್ಲ, I'm sorry.
Section 47 point subclause 5 ಕೆಳಗಡೆಗೆ implication.
Check with the power supply application.
No, my lord.
Next ಸರಿ ಏನು?
Annexure A is, my lord, endorsement we have issued, my lord.
What is the endorsement?
May I read, my lord? ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಮತ್ತು ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀಮತಿ ಸೀತಾಲಕ್ಷ್ಮಿ ಗಂಡ ಕೃಷ್ಣಪ್ಪ ಆದ ತಾವು ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖದನ್ವಯ ನಿಮ್ಮ ವಾಣಿಜ್ಯ ಸ್ಥಾವರಕ್ಕೆ ಸೊ 5.76 ಕಿಲೋವ್ಯಾಟ್ ಅಧಿಕ ಭಾರಕ್ಕಾಗಿ ದಿನಾಂಕ 22/4/2024 ಅರ್ಜಿಯನ್ನು ನಾನ್ ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ನಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ಸರಿಯಷ್ಟೇ. ಭದ್ರತಾ ಠೇವಣಿ ಹಣವನ್ನು ಬೆಸ್ಕಾಂ UPI ಅಥವಾ ಸ್ಕ್ಯಾನರ್ ಮುಖಾಂತರ ಹಣ ಭರಿಸಲು ಬಯಸುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿರುತ್ತೀರಿ. ಪ್ರಸ್ತುತ ಬೆಸ್ಕಾಂ ಕ್ಯಾಶ್ ಕೌಂಟರ್ ನಲ್ಲಿ ಹಣ ಪಾವತಿಸಲು ಸೌಲಭ್ಯವಿರುತ್ತದೆ. UPI ಅಥವಾ ಸ್ಕ್ಯಾನರ್ ಮುಖಾಂತರ ತಾವು ಹಣವನ್ನು ಪಾವತಿಸುವುದಾದರೆ ಈಗಾಗಲೇ ಬೆಸ್ಕಾಂ ಜನಸ್ನೇಹಿ ಸೇವೆಗಳ ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ತಂತ್ರಾಂಶದಲ್ಲಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದರೆ ದಿನದ 12 ಗಂಟೆಗಳಿಗೂ ಸಹ ತಮ್ಮ ಆನ್ಲೈನ್ ನಲ್ಲಿ ಹಣ ಪಾವತಿಯ ಸೌಲಭ್ಯವಿರುತ್ತದೆ. ಈ ತಂತ್ರಾಂಶದಲ್ಲಿ ಡಿಜಿಟಲ್ ಮೋಡ್ ಆಫ್ ಪೇಮೆಂಟ್ UPI ಮತ್ತು ಸ್ಕ್ಯಾನರ್ ಮುಖಾಂತರ ಹಣ ಪಾವತಿಸುವ ಸೌಲಭ್ಯವಿರುತ್ತದೆ. ಈ ಸೌಲಭ್ಯವನ್ನು ತಾವು ಉಪಯೋಗಿಸಿಕೊಳ್ಳಬಹುದೆಂದು ತಿಳಿಸಲಾಗಿದೆ. ಹಾಗೂ ಹೆಚ್ಚಿನ ಮಾರ್ಗದರ್ಶನ ಬೇಕಿದ್ದಲ್ಲಿ ಕಚೇರಿಯ ವೇಳೆಯಲ್ಲಿ ಬೆಸ್ಕಾಂ ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿಯವರ ಸಲಹೆ ಪಡೆದು ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಬೇಕೆಂದು. This is the thing, my lord, they are seeking the UPI payment ಮಾಡ್ತೀವಿ, ನಮ್ಗೆ ಎಕ್ಸ್ಟ್ರಾ ಲೋಡ್ ಬೇಕು ಅಂತ they ask, my lord. Then we said them, if you want to pay, you go for the fast track. There is a app is there, you download it and you can pay through UPI. They are seeking, we wanted to pay it in the counter by scanner only. That was the one prayer, my lord. And the second prayer of the petitioner is 47 point, section 47 subclause 5 of the Electricity Act has to be implemented. They are seeking, my lord. In that aspect, I have to file the statement of objections, my lord, because
Only if permitted,
prepaid meter ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
only if permitted, my lord, I'll make submissions.
They had applied under the non-fast track mode.
Yes, my lord.
So you are suggesting they want to pay the amount through the UPI.
My lord, they are
There's no provision for accepting money under the UPI.
in the counter, in the counter,
Correct.
my, in the counter.
Asking them to file an application under the fast track procedure.
Correct.
No application,
Correct,
my lord.
correct.
ಬಿಟ್ಟು ಕೂತ್ಕೊಳ್ಳಿ ಒಂದು 2 ನಿಮಿಷ, ನಾನು I'll call upon you.
My lords, may kindly see the page number 53, my lord. Annexure E.
Now, the endorsement is only to that effect.
Yes, my
If
lord,
you
that
want
is the
additional
only
load,
effect.
If you want to pay by UPI, you make an application to the fast track procedure.
Fast track ಅಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಆಲ್ರೆಡಿ ಅದನ್ನು ಮಾಡಿದ್ದಾರೆ. My lords, may kindly see the annexure E.
Annexure?
E, page number 53, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 25/10/2023 ತಾವು ತಮ್ಮ ವಾಣಿಜ್ಯ ಸ್ಥಾವರಕ್ಕೆ ಅಧಿಕ ಭಾರ 5.75 ಕಿಲೋವ್ಯಾಟ್ ಕೋರಿ ಬೆಂಗಳೂರು ಬೆಸ್ಕಾಂ ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ತಂತ್ರಾಂಶದಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿರುತ್ತೀರಿ. ಅದೇ ದಿನ ನಿಮಗೆ ಡಿಮಾಂಡ್ ನೋಟಿಸು 27,320 ಗಳಿಕೆಗಳೇ ಜನರೇಟ್ ಆಗಿರುತ್ತದೆ. ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ತಂತ್ರಾಂಶದಲ್ಲಿ 24 ಗಂಟೆಗಳ ಸಹ ಮನೆಯಲ್ಲಿ ಕುಳಿತು ಆನ್ಲೈನ್ ನಲ್ಲಿಯೇ ಹಣ ಪಾವತಿಸಲು ಮಾನ್ಯ KERC ನಿರ್ದೇಶನದಂತೆ ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿರುತ್ತದೆ ಹಾಗೂ ಕೆಳಕಂಡ ಆನ್ಲೈನ್ ಮೋಡ್ ನಲ್ಲಿ ಹಣ ಪಾವತಿಸುವ ಅವಕಾಶವಿರುತ್ತದೆ. Now they wanted, my lord, they wanted to go for the counter, they wanted to scan it and they wanted to pay it.
So people coming forward to pay money, you're not prepared to accept.
No, my lord, we are accepting.
Want to pay digitally, you will have to make an application.
No, my lord, in the counter also we are accepting, my lord. They wanted in the counter for the scanner, my lord. That is the only one prayer, my lord.
Ultimately ಕಾಸು ಕೊಡ್ತೀನಿ ಅಂದ್ರು ಬೇಡ ಅಂತಿದ್ರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಬೇಡ ಅಂತ ಇಲ್ಲ ನಾವು. ಅದು about 10,000 ಆದ್ರೆ they have to pay the DD, my lord. They don't want to go for the bank and pay the DD. For that reason, you put the scanner here only. We will scan in your counter. We wanted to tell them, sit in your home and pay it. That's it, my lord.
Even in our port, we are providing for repay facility, isn't it?
Yes, my
And
lord.
for people coming for.
My lord, and also, my lord, we are adopting that one, my lord. It was in a process, my lord. That was the one prayer, my lord. The second prayer which they sought, my lord, section 47 subclause 5 of the Electricity Act, my lord. They are seeking the prepaid meters for the permanent electricity, my lord.
Where is that?
My lords may kindly see the prayer one. Issue a writ of certiorari or any other appropriate writ or in order to quash the mandamus dated so and so, so and so. Second respondent rejecting the application of the power supply to the petitioner and refusing to provide the prepayment meter. For this reason, my lord, I need some time to file my statement of objections, my lord. For the reason I am seeking the time, my lord.
ಇಲ್ಲಿ ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಹೈಕೋರ್ಟ್.
This prepayment meter, where is it provided under the act or the regulations?
47, my lord, is
It only says.
no, it is page 39 is the judgment of this honorable court, referring to that regulation also. my lord.
Show me the
Page-
section.
Yes, 47(5), my lord.
47(5) only says
Yes,
there would be no need of taking security in the event.
yes. If the person requiring is prepared to take the supply through prepayment.
What is the regulation which provides for?
Yes,
you
that is, my lord, security deposit regulation,
I'll file my statement.
which my lords will find.
On 8 inches.
Yes. That your lordships will find security deposit regulations, my lord, are already, I'm sorry, my lord, it is.
We are not on security deposit. If you want a prepayment.
ಅಲ್ಲ ಅದರಲ್ಲೇ ಇದೆ ಅದ್ರಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತಿದೆ ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್. ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಸಿ ದಟ್ ಇಂಪ್ಯೂನ್ಡ್ annexure itself, there is a direction from KERC to put that meter within March 2000. Kindly see, my lord, the endorsement itself. Lordships may see ಮುಂದುವರೆದು, may I read, my lord, that third, fourth paragraph.
I want to see the regulation or the.
Yes. ಅಲ್ಲ, I am reading that, my lord, and showing to my lords the provision also. ಮುಂದುವರೆದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ
Provision ತೋರಿಸ್ಬಿಡಿ first.
regulation, my lord, prepayment regulation that I have not brought. I am sorry. Lordships may see, my lord, there is a direct 6/2/2024 ನಲ್ಲಿ ನಿರ್ದೇಶನ ಪೂರ್ವ ಪಾವಕ ಮಾಪಕಗಳನ್ನು ಅಳವಡಿಸುವಂತೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ KERCಯು 6/2 ಎಂದು ನಿರ್ದೇಶನ ನೀಡಿರುತ್ತದೆ. ಇದರ ಪ್ರಕಾರ ಎಂಬಿಕಿ ಕಾರ್ಯಾಲಯದಿಂದ ನಿರ್ದೇಶನ ಬಂದ ನಂತರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು. Already there is a direction issued by KERC in terms of security deposit regulations.
Until the prepayment meter issue is resolved.
Yes.
The question of this payment would not.
No, my lord. That prepayment meter I have given up. I have not said only ಇವ್ರು UPI ಕೊಡಲ್ಲ ಅಂದ್ರಲ್ಲ, ಅಲ್ಲಿ ಹೋಗಿ ಇವ್ರದ್ದು UPI ಕಟ್ಟೋಗಿಂತ ಬೆಟರ್ ಆಯ್ತು ನನಗೆ ಹಾಗಾದ್ರೆ ನಿಮ್ದು ಡೆಪಾಸಿಟೇ ಬೇಡ, 47(5) ಪ್ರಕಾರ ನಾನು ಕೊಡೋದಿಲ್ಲ ಅಂತಾದ್ರೆ ನನಗೆ ಇದೇ ಕೊಡಿ. ವಾಟ್ ದಿಸ್ honorable court has done, resolved that issue also, my lord. Similar petition, page 39, lordships may see, resolved that issue also. Lordships may see, my lord. Page 39, lordships may say very identical issue. Learned counsel for petitioner submits. Petitioner is prepared to take the supply through prepayment meter under 47(5). Now the solution offered is, lordships will find para 5, my lord, on page 40, in view of so and so above, person requiring supply to take through prepayment meter, he shall not be liable to furnish security as contemplated in so and so. In this case, petitioner is prepared to take the supply through prepayment meter. As the prepayment meter is presently not available, it is appropriate for 1 and 2 to supply electricity to the petitioner by collecting approximately monthly charges in advance without insisting on the security contemplated under so and so referred above. Amount of the petitioner lying in the deposit of so and so shall be adjusted towards the energy charges. This order shall cease to be enforced once so and so provide the meter. Now meters are already being provided, and the KERC also time and again has given them, because this is 2003 Act, my lord. Metering regulations, security deposit regulations, everywhere the meters are available. What they are doing is only for temporary supply they are supplying these meters. For regular they are not supplying. This will solve the problem, my lord, for prepayment for both consumer and them. Like prepayment mobile ತಗೊಂಡಂಗೆ ನಾವು ದುಡ್ಡು ಕಟ್ಬಿಡ್ತೀವಿ, ನೀವು ತಗೊಳ್ಳಿ ಅಂತ ಇವರು ನಮ್ಮ ಹತ್ರ ಬಂದು ಚಾರ್ಜ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು, ಈ ತರ UPI digital.
Objection. Let us see what she has to.
And lordships may see this is upheld by section the next, my lord, division bench also, page 41.
A letter make a submission as to why the prepayment meter is not available.
Yes. If not, my lord, let them under non-fast track mode, let them accept my this application is
Already applied now onto the fast track mode, isn't it?
Sorry, my lord.
You already applied under the fast.
No, I have not applied. That is rejected. ಅದನ್ನು ವಿಲೇ ಮಾಡಲಾಗಿದೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಮೇಡಮ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
Yes, lordships will see that is rejected already. Lordships will see, my lord, page 58.
ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಾವು ನಿಗದಿತ ಅರ್ಜಿಯನ್ನು ಮುಖಾಂತರ ಕೋರಲಾಗಿದೆ. ನೀವು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ನಂತರ that is rejected already.
We read annexure in which you have.
Annexure E, page 53, my lord.
Yes, yes. After that only 53 ನಲ್ಲಿ ನಾನು ಮಾಡಿದ್ದೆ.
Registered in the online and the
Correct,
payment was.
correct. ಅದಾದ್ಮೇಲೆ ಮರು ನೋಂದಾಯಿಸಲು, ಆದ್ದರಿಂದ ಈ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಿ 54 your lordships may see, ಮರು ನೋಂದಾಯಿಸಲು ಕೋರಲಾಗಿದೆ. That is already rejected. ಅದು ಮಾಡಿ ನಾನ್ ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ಇವು ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಮತ್ತೆ ಹಾಕಿ ಅಂತ ಪ್ರತಿ ಸರ್ತಿ ಮತ್ತೆ ಹಾಕಿ. Every time I approach this honorable court, mattome haki anta. I complete my submissions. And also, my lord, I made another submission at 55. Adukku ashte. They say mattome arji haki. Every time I approach, this is second round of litigation.
Madam, tarkari ಅಂಗಡಿ ಅವರು ತಗೊಳ್ತಾರೆ.
Alla Swami.
ತಗೊಳ್ಳಲ್ಲ ಅಂತ ಒಂದೇ ಹಠ.
She has applied in the fast track. The amount was quantified, my lord. She has not paid that, my lord. My lord, the basic criteria here, my lord, the not only they
Fourth
want the
application.
additional load, my lord, the 47.5, that was the major criteria. my lord.
ಏನಲ್ಲ ಅದಲ್ಲ.
And I don't seem to understand. I said every grocer is now having a scanner before him and you
Alla.
can't give him a QR code to make the payment.
ಸಾಫ್ಟ್ವೇರ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
My objections.
Lordships may seem, lord.
What was the slowest in adopting technology and you are even worse than us.
Kindly see, my lord, the last paragraph on 23. ಮುಂದುವರೆದು
The alternative
page
is
23.
there, my lord,
I
in the
just read
fast
this,
track.
lord, lordships will see. Page 23. ಮುಂದುವರೆದು ತಮ್ಮ ಮನವಿ ಪತ್ರದಲ್ಲಿ, am I reading with your lordships? 23. ಮುಂದುವರೆದು ತಮ್ಮ ಮನವಿ ಪತ್ರದಲ್ಲಿ ನಾನ್ ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ನಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸೌಲಭ್ಯವನ್ನು ಒದಗಿಸಿದಂತೆ ತಮ್ಮ ಮನವಿಯನ್ನು ಸೋ ಅಂಡ್ ಸೋ ಕ್ಯಾಶ್ ಕೌಂಟರ್ ಮುಖಾಂತರ ಪಾವತಿಸಲು ತಂತ್ರಾಂಶವನ್ನು ಅಭಿವೃದ್ಧಿಪಡಿಸಲು ಮೇಲಧಿಕಾರಿಗಳ ಗಮನಕ್ಕೆ. ದಿಸ್ ಈಸ್, ಮೈ ಲಾರ್ಡ್, ದ ರೀಸನ್. ಆಯ್ತು, ನಾನು ಪ್ರೀಪೇಮೆಂಟ್ ಬೇಡ, 1 ತಿಂಗಳು ಇವ್ರು ಅಡ್ವಾನ್ಸ್ ತಗೊಳ್ಳಿ. ಮೇಲಧಿಕಾರಿಗಳ ಗಮನಕ್ಕೆ ತಂದಿದ್ದಾರಂತ ಇವ್ರು. ಒಂದು UPI ಸ್ಕ್ಯಾನರ್ ಹಾಕ್ಲಿಕ್ಕೆ ಮೇಲಧಿಕಾರಿಗಳ ಗಮನಕ್ಕೆ. Under the non-fast track mode, all aged persons, my lord, disabled persons, they come.
They can sit in the home and they can do it in a fast track, my lord.
No,
Disabled
fast track
person
ಅಲ್ಲಿ ನಂದು
not
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
necessary to come to
Application
counter,
is
my lord.
rejected.
Not rejected.
And that
Yes, my lord.
if somebody wants to pay you money,
Yes, my lord.
if this is the accepted mode now, for you to adopt that, you require a person to come to the court and ask for a writ petition.
No, my lord, they have applied in the fast track, my lord, that.
Somebody wants to come and give you the money.
Yes, my lord.
You should, the government is screaming from the rooftops that you should go digital and you want to go back to collect currency notes. One of the grievances in the petition.
My lord, regarding the first prayer, it will be.
Already that disposed of.
They direct the MD to file an affidavit as to why you are not adopting
Yes,
UPA.
yes.
One of the grievances in the writ petition is that the petitioner is being called upon to seek for power supply by adopting
Additional load, my lord.
the fast track mode. Since only UPI payments are permitted. It is stated in Annexure A that if the petitioner were to insist on payment of the requisite sums while applying under the non-fast track mode, he cannot deposit the money by availing of an UPI facility because it has not been provided for by the BESCOM. It is rather strange that in this age and time, BESCOM is refusing to accept money through UPI when the whole world is accepting payments through UPI. The money letter is therefore directed to file an affidavit as to why the facility of providing UPI payment or online payment is not made available in respect of all aspects of payment to BESCOM. Let the affidavit be filed on or before. At least then ivaga attention baruttalla ivaga.
Fast track.
Take some
Fast track.
resist on.
For further consideration, but otherwise it will just fail into oblivion.
ಜಾಸ್ತಿ ಆಗೋಯ್ತು.
One, it will help lakhs of people, my lord. At least the disabled people, the aged people
Alla,
will be
the-
benefited. At least your lordships have,
The
again I have to
first-
argue the whole thing, re-argue the whole thing. Lordships have heard it.
9. 45, Sri Ramchandra Reddy.
For the respondent. For the additional. Matter concerning two excise licenses.
Using the due process of law, my lord, if I may respect to submit. Lord, the prayer your lordship may kindly see. The first prayer, he says, the DC order, it is already commissioner appellate authority passed the order and finalized, it was finalized. Then, my lord, that appeal also filed an appeal before the KAT, that also it is pending for final hearing. Without that, my lord, already their matter is pending for adjudication. He filed a writ petition and again he's saying that, my lord, the DC's order is.
What is the matter about?
It's a point of jurisdiction. The excise commissioner has the power to renew licenses under the excise rules. Two licenses were granted in the name of a partnership firm known as Sandesh Enterprises. A CL9 license.
Who are you?
I'm
You are
the
the firm.
managing partner and the firm. And my lord will see the
Form of
next
two partners, brother and sister.
I'll just complete, my
The
lord.
brother, you're the sister, huh?
Yeah,
Yes.
absolutely. And we are a partnership firm, my lord. We applied for license for running a bar and restaurant. It is a CL9 license which was issued in the name of the firm Sandesh Enterprises. And we also run a wine store in a different location for which we are the same firm, for which we applied what is known as a CL2 license for wine stores. Both of these licenses, CL2 and CL9, were granted in the name of the firm Sandesh Enterprises. Now, my lord, this happened in 2000, and thereafter it's been renewed periodically. Every year in June, you have to renew it. It's an annual license due for renewal in the June of the calendar year. In 2014, my lord, we applied for renewal. The commissioner had the power under Rule 5A to collect the renewal fees and to renew the license. That's all he had to do. Now, my lord, what happened there was, at that point in time, there was some dispute between partners and a suit was filed. And some interim order was passed in that suit, restraining one of the partners, the sister, from interfering with the conduct of the business by the brother who was the managing partner. Now, that was a civil proceeding which had nothing to do with the jurisdiction of the excise authority or the excise law. My lord, then that matter, an interim order was passed in favor of the brother, which was in challenge in before by way of an MFA by the sister. And in disposing of the MFA, this honorable court held that find the license, let the license be applied for, and let the suit be decided on merits. This is all that happened. And my lord, with that order, the sister goes to the excise authority and calls upon him to pass an order, while civil court is conceived of the matter, to pass an order that the CL2 license, in so far as the wine store is concerned, will be run exclusively by her. And the CL9 license, in respect of the bar and restaurant, will be run exclusively by the brother. Such an application in a renewal of a license is beyond the jurisdiction of an excise authority. He has no authority to get into a dispute between partners of a partnership firm.
What did he do?
He passes an order, which is at Annexure A, directing that the license, though renewed in the name of the firm, the CL2 license will be exploited only by the sister, and the CL9 license will be exploited only by the brother. And he also, in the end, puts a rider, it is subject to the outcome of the suit. And my lord, this order was challenged in appeal before the Commissioner of Excise. It all happened in 2014. While the appeal was pending before the Commissioner, the suit came to be decided. And in the suit, it was held. An agreement which was referred to, which tried to divide the businesses, is completely opposed to public policy, opposed to the provisions of the Partnership Act. And that agreement dividing businesses in a partnership firm is an anathema to the concept of partnership itself, and therefore is null and void of the declaration of the civil court. So any which way you look at it, even though the excise authority had no jurisdiction to pass an order dividing the licenses, standing in the name of the firm amongst the partners, and he had also qualified it subject to the outcome of the suit. And in 2019, the civil court decided that such an agreement is not known in law. It
Is dismissed or not?
suit is dismissed.
Saying that unregistered partnership.
I'll just complete.
Yes.
My friend will hear, my lord will hear, my friend. The court specifically in paragraph 22 of the judgment dismissing the suit categorically held an agreement between partners dividing two businesses as separate businesses does not lie. It is void.
That decree has been challenged.
No, it has reached finality.
So the firm continues.
The firm continues. But what has happened is, my lord, in 2014, when the commissioner passed the order dividing the CL2 for the sister and CL9 for the brother, and what has happened is he also passed an order directing the police authorities separately, subsequently, to restrain the managing partner from coming anywhere near the wine store or disturbing the sister from running the show. And all of this was subject to the outcome of the suit. And now the suit was decided in 2019. And my lord, it is simply this. My lord sees Rule 5A. It only says that you pay the fee and the license has to be renewed in the name of the licensee.
This, what does the appellate authority says about the suit?
My lord, the appellate authority
Pending for hearing, my lord.
misconstrues the judgment in the suit. He says that because that agreement dividing the businesses was not registered, it's only on that ground that the court had dismissed the suit. And therefore, he goes ahead giving validity to that agreement.
Next, G is the order of the appellate authority.
Yes. And my lord, this is the suit. I just pass on the judgment of the civil court.
Plaint was rejected.
Yeah, plaint was rejected, and kindly come to para 20, my lord, of that order. I mean, it's here, my lord. I'm just furnishing the judgment.
May I make a submission, my lord?
Nimsha,
I'll avoid unnecessary, my lord, unnecessary. Again, he is taking another court's hard time. I will make a submission. My lord, this, whatever my learned friend had said, it is under compromise. High Court has given, they filed a compromise petition, both our brother and sister. They compromised the petition. They says, as per the partnership agreement, we are doing separate business. Permit us to, the court directed, or separate application ಕೊಡಿ ತಗೊಳ್ಳಿ, separate ಆಗಿ ಮಾಡ್ಕೊಡಿ ಅಂತ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದೆ.
ಎಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ರು?
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೈಕೋರ್ಟ್ ಸರಿ.
ಇನ್ MFA ಅಲ್ಲಿ ಒಂದು ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಕೊಟ್ಟರು.
ಎಂಟ್ರಿ ಮಾಡು.
ಎಸ್, ಎಗ್ನೆಸ್ಟ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ MFA is filed. ಅದು ನನ್ನ ಫ್ರೆಂಡ್ ಹೇಳ್ತಾ ಇಲ್ಲ. ಆ MFA ನಲ್ಲಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸೆಡ್, ಈ ದೇ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್, ದೇ ಸೆಡ್ ವಿ ಹ್ಯಾವ್ ಸೆಟಲ್ ದ ಮ್ಯಾಟರ್. ನಮಗೆ ಇಬ್ಬರಿಗೂ ಸಪರೇಟ್ ನಮ್ದು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಇರೋದೇ ಸಪರೇಟ್ ಮಾಡ್ಬೇಕು ಅಂತಾನೆ, ನಾವು ಸಪರೇಟ್ ಆಗಿ ಬಿಸ್ನೆಸ್ ಮಾಡ್ಬೇಕು ಅಂತಾನೆ ಡೀಡ್ ಇರೋದು.
ಸೂಟ್ ಯಾಕೆ ನಡೆಸಿದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ರೆ?
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದು ಇದಕ್ಕೆ, ಇವ್ರು ಸೂಟ್ ಹಾಕಿರೋದು ಎತ್ತಕ್ಕೆ ಅಂದ್ರೆ ಇಂಜೆಕ್ಷನ್ ಕೊಡೋದು, ನಾನೇ ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್, ನನಗೆ ಬಿಸ್ನೆಸ್ ಎಂಟೈರ್ ಬಿಸ್ನೆಸ್ CL2 CL9 ಎರಡೂ ಕೊಡ್ಬೇಕು ಅಂತ.
ಎಷ್ಟು ದಾವ ಆಯ್ತು? ದಾವ ಇದೆ, ಎರಡು ದಾವ ಆಯ್ತು.
ಸ್ವಾಮಿ,
ಎಷ್ಟು ದಾವ ಆಯ್ತು?
ಒಂದು ದಾವ ಹಾಕಿದ್ರು. ಅದರಲ್ಲಿ ನನ್ನ ಪಾರ್ಟ್ನರ್ಶಿಪ್, ನಾನೇ ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್, ನನಗೆ ಎರಡು ಬಿಸ್ನೆಸ್ ಮಾಡ್ಕೊಬೇಕು, ನನಗೆ ಕೊಡ್ಬೇಕು ಅಂತ. ಅದ್ರ ಮೇಲೆ ಒಂದು ಇಂಜೆಕ್ಷನ್ ತಗೊಂಡ್ರು. ಅವಾಗ ಕೋರ್ಟ್ ಹೇಳ್ತು, ನಿನ್ ಪಾರ್ಟ್ನರ್ ಮೇಲೆ ಇಂಜೆಕ್ಷನ್ ತಗೊಳಕ್ ಬರಲ್ಲ, ಯು ಕೆನಾಟ್ ಟೇಕ್ ಯೂಸ್ ಓನ್ ಪಾರ್ಟ್ನರ್ ಅಲ್ಲಿ. ಮತ್ತೆ ಫರ್ಮ್ ಇಸ್ ಇನ್ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಫರ್ಮ್, ಯು ಕೆನಾಟ್ ಫೈಲ್ ಎ ಸೂಟ್ ಆಲ್ಸೋ. ಡಿಕ್ಲೇರ್ ಮಾಡಿದೆ ಇಟ್ ಇಸ್ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಫರ್ಮ್ ಅಂತ. ಈಗಲೂ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಫರ್ಮ್ ಅಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿರೋದು. ಓಕೆ, ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಮತ್ತೆ ಕೋರ್ಟ್ ಸೆಟ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ರಿಂದ ಅಲ್ಲ, ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದನ್ನ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದಾಗ ಇವರೇ ಬಂದ್ಬಿಟ್ಟು ಎರಡೂ ಪಾರ್ಟಿ ಲಾಯರ್ಗಳು ಬಂದು ಸಪರೇಟ್ ನಾವು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂತೀವಿ, ನಿಮ್ಗೆ ನಮ್ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ, ನಾವು ಸಪರೇಟ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತೀವಿ ಅಂತ. ಕೋರ್ಟ್ ಹಸ್ ಗಿವನ್ ಎ ಡೈರೆಕ್ಷನ್, ಅವ್ರಿಬ್ಬರಿಗೂ ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ತಗೊಂಡು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ. ಆಫ್ಟರ್ ಕನ್ಸಿಡರಿಂಗ್ ಆಫ್ಟರ್ ಅಪ್ಲಿಕೇಶನ್, DC ಆಲ್ಸೋ ಟೇಕನ್ ಕೇರ್. ನೀವಿಬ್ರು ಅಫಿಡೇಟ್ ಹಾಕಿ, ನಾನು ಕೊಡ್ತೀನಿ, ಇಲ್ದಿ ನಾನು ಕೊಡೋದಿಲ್ಲ ಅಂತ. ಇಬ್ರು ಸೇರಿ ಅಫಿಡೇಟ್ ಹಾಕಿದ್ದಾರೆ, ಜಾಯಿಂಟ್ ಅಫಿಡೇಟ್, ನಮ್ಗೆ ಸಪರೇಟ್ ಕೊಡಿ ಅಂತ. ಸಪರೇಟ್ ಅಫಿಡೇಟ್ ಹಾಕಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅಷ್ಟೆಲ್ಲ ಆದ್ಮೇಲೆ ಅದನ್ನ ತಗೊಂಡು ಕಮಿಷನರ್ ಮುಂದೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. ಸರ್, ಇದು ನಮಗೆ ನನ್ನ ಕಂಪನಿ ಫರ್ಮ್, ಇದು ನನ್ನ ಫರ್ಮ್, ನಾನು ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್, ನಾನೇ ಎರಡೂ ಮಾಡಬೇಕು, ಅವಳು ನನ್ನ ತಂಗಿ ಅಕ್ಕನಿಗೆ ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತ ಅಪೀಲ್ ಹಾಕಿದ್ರು. ಆ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು 2014 ಅಲ್ಲಿ. ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿ 2014 ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿ, ಬಿಕಾಸ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಬರಲ್ಲ, ನೀವು DC ಹತ್ರ ಹೋಗಿ ಅಂತ. ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. ಆದ್ಮೇಲೆ 3 ವರ್ಷ ಬಿಟ್ಟು 1700 ಡೇಸ್ ಆದ್ಮೇಲೆ ಅದೇ ಆರ್ಡರ್ ಮತ್ತೆ ಕಮಿಷನರ್ ಮುಂದೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. ಅವಾಗ ನಮ್ ಹೈಕೋರ್ಟ್ ಗವರ್ಮೆಂಟ್ ಡೈರೆಕ್ಷನ್ ಪ್ರಕಾರ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ DC ಬರುತ್ತೆ ಅಂತ ನಾವು ಹೇಳಿದ್ರಿ. ಈಗ DC ಬರಲ್ಲ, ನೀವೇ ಬಂದಿದೆ ಅಂತ ನೀವೇ ಮತ್ತೆ ತಗೋಬೇಕು, ಹೊಸ ಅಪೀಲ್ ಹಾಕಿದ್ರು. ಅದು ಬರಲ್ಲ, ಯಾಕಂದ್ರೆ ಸ್ಟೇಟ್ಯೂಟರಿ ಅಪೀಲ್ ಅಲ್ಲಿ ಹಿ ಕೆನಾಟ್ ರಿವ್ಯೂ ದ ಪಿಟಿಷನ್, ಹಿ ಕೆನಾಟ್ ಫೈಲ್ ಒನ್ ಮೋರ್ ಅಪೀಲ್. ಅದನ್ನು ಹಾಕಿದ್ರು. ಅದ್ರ ಮೇಲೆ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮಾಡಿ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಸಿಸ್ ಮಾಡಿ ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಹಾಕಿದ್ರು. ರಿಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು, ನೀವು ಹೋಗಿ KT ಹೋಗಿ KT ಚಾಲೆಂಜ್ ಮಾಡಿ, ಇವೆಲ್ಲ ಇದನ್ನ ಹೈಕೋರ್ಟಿಗೆ ಬರಲ್ಲ, ಹೈಕೋರ್ಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತು. ಅದ್ರ ಮೇಲೆ ಕಮಿಷನ್ ಮತ್ತೊಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು, ಅದು ಮತ್ತೆ KT ಅಪೀಲ್ ಹಾಕಿದ್ರು. KT ಅಪೀಲ್ ಅಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ನಾಟ್ ಗ್ರಾಂಟೆಡ್, KT ಅಪೀಲ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಹಾಕೊಂಡಿದ್ದಾರೆ, ಮೊನ್ನೆ 22ಕ್ಕೆ ಹಾಕೊಂಡಿದ್ರು. ಅಷ್ಟೆಲ್ಲ ಇದ್ದು ಅದನ್ನ ಸಪ್ರೆಸ್ ಮಾಡಿ ಅಗೈನ್ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು ಅಂತ ಈಗ ರಿಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ನಮ್ದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿದ್ದು DC ಪವರ್ ಇಲ್ಲ, ಅದ ಚಾಲೆಂಜ್ ಮಾಡಿದ, ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಇಲ್ಲಿ.
You mentioned in the writ petition that there was a compromise.
There is no compromise. My friend has completely misled the court.
I put it in copy.
My lord,
Was there a compromise?
there was no compromise.
Where is
There
the
was no,
order?
the order of the High Court does not refer to any compromise.
Where is the order in the MFA?
Yes,
My lord, it is reflected in the.
MFA.
My lord, may I just complete?
I'm asking you.
I'm just
Remember
pointing out.
TCS, I don't know
If
if
my friend
you
can just
asked-
hold his horses till I finish. Kindly see,
Give me the order of the,
it's extracted. I'll just point out.
you don't have the copy as such?
Well, no, the full order is extracted in the order of the appeal order. Kindly see page number.
I'm having copy, my lord. You'll ನೋಡಿ para 2, my lord. They have even this one para 2 ನೋಡಿ.
What is your client's name?
Kindly see page 50.
Clients and Sagar, Sandesh Enterprise managing partner Sagar.
ಇಲ್ಲ ಇಬ್ರಿಗೂ ಹೇಳಿದ್ರಲ್ವಾ?
ಇಬ್ರಿಗೂ ಹೇಳಿದ್ದಾರೆ ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ ಅಂತ. ಮತ್ತೆ
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ, ಬೋತ್ ಪಾರ್ಟೀಸ್ ಗಿವನ್ ಕನ್ಸೆಂಟ್ ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಐ ವಿಲ್ ರೀಡ್, ನನ್ನ ಕಾಪಿ ಇಲ್ಲ, ಅದೊಂದೇ ಕಾಪಿ ಇರೋದು. ಬೋತ್ ದ ಕೌನ್ಸಿಲ್ಸ್ ಅಂಡ್ ದ ಸಬ್ಮಿಷನ್.
ಇಲ್ಲ, ಒಬ್ರು CL2 ಹಾಕಿ ಒಬ್ರು CL9 ಹಾಕಿ ಅಂತ
ಅಲ್ಲ ಹಾಗೆ ಹಾಕಿ
ಸ್ವಲ್ಪ
ತಾಳಿ. ಸ್ವಾಮಿ ಅದಕ್ಕೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅದು ಪಾರ್ಟ್ನರ್ಶಿಪ್, ರೀಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ನೋಡ್ಬಿಡಿ ಸ್ವಾಮಿ. ಅಲ್ಲೇ ಹಾಕಿ ರೀಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಅಲ್ಲಿ CL2 ಇವರೇ ನೋಡ್ಬೇಕು. CL2 ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಇರೋದೇ ಹಾಗೆ. ಕಂಪ್ಲೀಟ್ 100% CL2 license has to be looked into by the sister. 100% CL9 license
ಇದ್ರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿಲ್ವಲ್ಲ ಅದು?
ಅದ್ರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿ, ಅದ್ರಲ್ಲಿ ಇಬ್ರು ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ, ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಲಿ ಅಂತ
ಬರ್ದಿಲ್ಲ.
ಇದೆ ಫಾರ್ಮ್. ನಾನು ಓದ್ತೀನಿ. ಅಲ್ಲಿ ಮೇಕ್ ಪರ್ಮಿಷನ್ ಟು ಮೇಕ್ ಎ ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. Read that. Both the councils, both sides submitted that the CL2 and CL9 license granted in favor of the Santesh Enterprises expire on so and date, and it submitted that the appeal may be disposed of by granting liberty to both the parties to approach the concerned authorities to renew the aforesaid licenses in accordance with law. Accordingly, both the parties are at liberty to apply renewal licenses by making separate applications. ಒಂದ್ ಲೈಸೆನ್ಸ್ ಒಂದಲ್ಲ, ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್. ಅದನ್ನ ಹೇಳಿ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ದಿಸ್
ಅಪ್ಲಿಕೇಶನ್.
Yes.
ಎರಡಕ್ಕೂ ನೀವು ಒಬ್ರು ಹಾಕೋಬಹುದು, ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ.
ಅಲ್ಲ,
CL2 ನಿಮ್ಗೆ CL9 ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
ಅದನ್ನ ಸ್ವಾಮಿ ಅದನ್ನ ರೀಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಒಂಚೂರು ನೋಡ್ಬಿಡಿ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಬಿಟ್ಟು ನಾನು ನಥಿಂಗ್ ಹ್ಯಾವ್ ಟು ಸೇ ಮಚ್.
The licenses are at annexure.
ರೀಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
I'll finish him.
Yes.
ಎಲ್ಲಿದೆ
ರೀಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ಸ್ ಸ್ವಲ್ಪ ನೋಡಿ ಸ್ವಾಮಿ. ಪೇಜ್ ಇವರೇ ಹಾಕಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
4/8/2010
ಹೌದು.
ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದು ಯಾವ್ದು?
ಅದ ಪೇಜ್ ಇ ಸ್ವಾಮಿ.
ಆರ್ಡರ್ ಡೇಟ್ ಯಾವ್ದು? MF
ಇದು ಬಿಫೋರ್ ಫೈಲಿಂಗ್. ಇದು 30th June 2020. 30th June 2013.
13. Reconstitution prior to that.
Prior to that.
And you did not bring it to the notice of the court, this is the reconstituted partnership deed.
ತಂದಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಅದನ್ನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಮಿಷನ್, ಅದು ಹೈಕೋರ್ಟ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿದೆ. ಇದು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಅಲ್ಲ, ಇದು ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್. ಇದನ್ನ ಕೆನಾಟ್ ಬಿ ಎಂಟರ್ಟೈನ್ಡ್ ಅಂತಾನು ಮಾಡಿದೆ. ಇವರು ಈಗ ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್ ದ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಆಲ್ರೆಡಿ ಡಿಕ್ಲೇರ್ಡ್ ಅಂಡ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಚಾಲೆಂಜ್ ದಟ್ ಆರ್ಡರ್. Court has declared that this partnership is an unregistered partnership. They have no authority to file a suit antanu madidare.
The suit was invested of this particular reconstitution or the
on same subject.
The suit hakiddu in respect of the original partnership deed or the reconstitution?
Reconstituted partnership deed. Original.
That plaint is rejected.
Yes.
So there is no interim order in force now.
ಅಲ್ಲ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದರಲ್ಲೇ ತೆಗೆದಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅಪೀಲ್ ಅಲ್ಲೇ MFA ನಲ್ಲೇ ತೆಗೆದಿದ್ದಾರೆ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿಬಿಟ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ.
MFA can survive, MFA interim order can survive till the disposal of the suit. Once the suit itself goes, then this interim order will appear of no consequence.
Yes. MFA is suit dismissal ಆಗಿದ್ದು ಮೊನ್ನೆ 2019.
ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ.
They are not filed an appeal. And moreover, my lord, ಇದರಲ್ಲಿ ಕಮಿಷನ್ ಇನ್ನೂ ಇದಿದೆ. This commission
in 2010 partnership where do they admit this? They admit this, they don't dispute this annexure E.
ಎಲ್ಲಿ ಸ್ವಾಮಿ?
This annexure E, you dispute this, Subramanian?
Yes, my lord, it's been declared as null and void by the court.
Yes.
Is it admitted by you?
It was admitted, it was contested, and it was declared null and void. My lord, the
Where is
judgment.
the suit? Where is the suit?
The judgment is before my lord. Kindly see.
Suit himself filed
Every
suit.
attempt is made to prevent me from pointing out the relevant paragraph to the court. Kindly see para 22, my lord.
Where is the plaint? What is the prayer in the suit?
My lord, the prayer in the suit was to permit him to run the business as a managing partner, contrary to the arrangement in that.
Suit was for an injunction?
Yes. The interim order which was granted in my favor was for me to run both businesses as managing partner. And that, kindly see para 20, my lord. 22.
You are the plaintiff.
Yes. Kindly come to para 22.
1 minute. Let me look. So your suit was dismissed, rejected.
Yes, and kindly come to para 22 thereof.
And in the suit itself, you admitted that there was this reconstituted partnership deed.
Yes, which we contested as,
The dismissal of the suit, the result is you have no protection from interference from them,
kindly see para 22, my lord.
isn't it?
No, not really.
You filed a suit for.
No, let me refer to the judgment itself. Kindly see para 22.
Yes.
Now, my lord, it reads from the recitals in the said reconstituted partnership deed. That is the deed, my lord, the fourth.
Whatever is said in
Yeah,
para
it is
22.
clear. It is,
Your contention that you are an exclusive position and you should be protected by a degree of injunction is.
it was rejected, but
It's
in
refused.
the reason for rejecting that,
Be the reason,
Yeah.
you accepted the reason,
yes,
whatever be the reason, you don't have an injunction which entitled you for exclusive running of the business. Correct?
I never sought for an exclusive right. I mean, as a partner, my lord, I cannot ask for an exclusive right. I
Right
can
or
only-
wrong, you did may file a suit for some relief of injunction.
I only sought relief that I should be allowed to run as the managing partner of the firm.
So
But
you're-
whatever, the suit was misconstrued in many ways, but kindly see the observation of the court.
You're bound by the terms of the reconstituted partnership.
Not at all. Kindly see para 22. I'll be reading,
Until you set aside, until you seek for setting aside of this partnership.
it
deed.
has been set aside in para 22. Kindly see.
That was only a suit for injunction. I'm not prepared to accept that the reconciliation partnership deed goes because your suit for injunction is dismissed.
No, my lord, kindly see the reasons why it was rejected. May I,
Whatever be the
whatever-
reason, there is no challenge laid to this reconstituted partnership deed in a properly framed suit. There's no decree declaring that this reconstituted partnership deed is null and void. So until this reconstituted partnership deed stands, you will be bound by the terms of the deed. Where you will get one,
my
they'll
lord,
get the other.
no, my lord, may I make this submission to the court? My lord will kindly see, I mean, I understood what my lord has said, but my lord may kindly see may I just take 2 minutes, my lord? Paragraph 18 of this judgment. I mean, whatever it's worth, I mean, my lord may rule any way, but it's my duty to point out paragraph 18. I won't take more than 5 minutes, my lord. I'll time myself.
Page number, sir.
At the para 18, my lord, at page number 18. My lord has it?
Yes.
Yeah. At the cost of repetition, as per the reconstituted partnership deed dated 4th of August 2010, the plaintiff has to look after Sanjay Bar and Restaurant of Messrs. Sandesh Enterprises, and he shall take all the profits and remuneration of Sanjay Bar and Restaurant. Whereas the first defendant, Shailaja, shall take all the profit and remuneration of Victoria Wines, Shaila Wines. And even it is recited in the said document that both the partners shall be authorized to sign their bank accounts separately. It is also recited that the plaintiff shall open bank account as managing partner of Mrs. Sandesh Enterprises, and that account will be in respect of Sanjay Bar and Restaurant, and Mrs. Shailaja shall open bank account as partner of Mrs. Sandesh Enterprises, and account will be in respect of Mrs. Victoria Wines only. When the provisions of the Indian Partnership Act state that profits of the business of the firm shall be pooled together and then distributed to the partners, contrary to the same, in the said document, it is cited that the profits or loss of a particular business of the partnership firm shall be enjoyed or borne by that particular person or partner. It is also recited that license fees to be paid separately. That means not in the name of the partnership firm. It is also recited in the said document that regular books of account shall be maintained by both the parties separately, both the partners separately. Both the partners shall be authorized to sign their bank accounts separately, and separate bank accounts shall be opened. All the said are to be done in the name of the partnership firm as per law. In para 19 of the said document, it is recited the application of the Indian Partnership Act, except to the extent mentioned above in the deed. In this deed, to the contrary, all the other provisions of the Indian Partnership Act shall be applicable to the firm. Any agreement which is inconsistent to the provisions of any law is void. The learned judge extracts section 23, and then in 22 he concludes, from the recitals in the said reconstituted partnership deed, it is clear if the terms and conditions of the said document are permitted to apply, and the said conditions are forbidden by law, and if permitted, it will defeat the provisions of the Indian Partnership Act. Now kindly come to Annexure A.
While dismissing the suit,
Yes.
any observation is made,
Yes.
that will be of no consequence because ultimately in para 24, the suit is, plaint is rejected on some other ground. These are passing observations made by the court.
Doesn't matter, my lord.
Which does not
Doesn't
bind him
matter.
in any manner.
Doesn't matter. Kindly come to Annexure A. Kindly come to Annexure A because it was made subject to the outcome of the suit. My lord, may I make the submission? May I make the submission? For a moment, let's ignore the suit and the civil proceeding.
Then you fall back upon this reconstituted partnership deed.
My lord, the
Suit goes.
reconstituted partnership deed if the suit goes declaring the reconstituted partnership deed as void,
Not on that ground, if the suit had been decreed, holding that the recourse partition bid is a.
it is a decree. Rejection of plaint is also a decree under the definition of the CPC. I'm not on that. It's a decree appealable by a regular first appeal.
That is a suit for injunction, that is all. Then what, nothing said in that suit.
My lord, may I make the submission? Let's go beyond the judgment of court. Kindly see the license. I just draw my lord's attention to the licenses. Kindly see annexure.
Will direct the department to go by this reconstituted partnership bid until it is set aside in a manner known to law.
My lord, will see a void document need not be set aside. If it's.
I will make it clear that.
With due respect, my lord.
There are judgments to the effect.
I
that
would only.
Even if they are void, some court should.
No,
declare it
my
to be
lord,
null and void.
I'm today, well, not due respect, my lord's opinion on the validity of the deed or otherwise, and my lord, with respect.
I'm not
With
questioning
the
that.
due
validity of
respect to the
deed.
court, the view which my lord has taken is plausibly a plausible view. I'm not for a moment trying to dispute, but in my respectful submission, my lord, the civil court was very right in declaring that. I mean, my lord's opinion is also there. But moving beyond that, kindly see, I'm on the statutory provision here. Kindly see Rule 5A. I'll take only 5 minutes. Kindly see Rule 5A.
I will not go by the rules because rightly or wrongly, you have entered into reconstituted partnership bid, which the department accepted for quite some time. And licenses were granted on the basis of this reconstituted
No,
partnership. bid.
kindly see the order accepting it. Kindly see the order accepting
That
it.
was because of your intervention of the court.
Sorry?
That was because of the order that you obtained from the court
What is the order I obtained from the
by
court?
filing the suit and in the MFA.
What is the order I obtained?
Yours is civil
My
litigation.
lord, the licenses were in the name of the firm. The renewal has to be in the name of the
You
firm.
initiated a litigation saying that you are entitled to
My lord,
injunction.
whatever litigation I initiated in the civil court, kindly see the powers of the authority in the Rule 5A. Kindly see Rule 5A, my lord. I mean, if I don't refer to Rule 5A, then I would have not succeeded in arguing the matter. This is the Karnataka Excise Sale of Indian and Foreign Liquor Rules 1968. My lord, if my lord has the same journal or it's Rule 5A. My lord will have to look at the Karnataka Excise Sale of Indian and Foreign Liquor Rules 1968. Compromise.
Yes,
My lord, has Rule 5 capital A,
yes.
it deals with renewal of license. My lord, sub rule 1, the excise commissioner or the deputy commissioner, as the case may be, on an application made to him along with the license fee prescribed in Rule 8, renew the license granted under these rules. Sub rule 2, that's all he has to do, receive the fee and renewal. He cannot get into an argument. He is renewing the license in the name of the firm. And he has done so. Kindly see page 35 of my writ petition. 35 of my writ petition, my lord, the CL9 license my lord has. I just want to pose one question to the court, my lord, and my lord will consider that. Kindly see Annexure C. Now this is the renewed license. My lord has page 35.
Yes.
It's renewed, my lord, and in the name of Sandesh Enterprises.
It says managing partner, Mr. Sandesh.
Yes.
Enterprises.
Yes.
And it indicates partners Sagar and Shairaja.
No, either the license stands in the name of an individual or in the name of a firm. Kindly see CL2 license.
Yes,
Kindly
sir.
see CL2 license, my lord, page number 36.
Same thing.
It's in the name of Sandesh Enterprises. The only jurisdiction the statutory authority under the excise law has in terms of Rule 5A, my respectful submission, my lord, is to renew the licenses and collecting the fee. What happens in the civil court, inter se between the parties, unless and until the firm is dissolved, and then an intimation is sent that the firm does not exist anymore, then the renewal of a license in the name of the firm cannot occur. Kindly come to the Annexure A, which is the impugned order, at page number 18.
Yes.
My lord has the operative portion of the order.
Yes, yes.
It's 22nd April 2014. Now, what the he is, my lord, passing an order. We do not know under which jurisdiction he's passing this order. May I like to know, an authority would act under under a power conferred to him under law. Now kindly see, before I proceed to read the operative part, kindly come to page 15. The opening recitals in the order. And my lord, as subject, he refers to renewal of CL2 license in favor of the managing partner Sandesh Enterprises. Right? Rule 5A mandates you pay the license fee, license will be renewed. Does the excise commissioner is vested with any power to exercise to venture even into a quasi-judicial dispute, inter se between partners of a firm?
Is going by your reconstituted partnership deed, which is going by the admitted reconstituted partnership deed.
My lord,
He is renewing the license.
my lord, he has to only renew the license in the name of the firm.
It is also open for him in the light of the deed that you produce to specify as to who will be the recipient of CL2, who is the recipient of CL9.
But my lord, what he does then, what he is doing then is he's issuing 2 licenses in individual names. Now you can't have.
Yeah, he will issue the license name of the firm, but he will also make it clear that as per the terms of the partnership deed which was submitted to him, CL2 license will be run by so and so, CL9 will run by so and so.
Virtually giving
Understanding.
that understanding,
your
my lord,
acceptance.
that understanding, my lord, has passed through. I mean, with due respect, I don't have to rely on that judgment. A partnership firm cannot be divided in that manner. It is anathema to the partnership law.
If you have any grievance about your reconstituted partnership deed, you know what is.
My lord, the partnership deed was not registered. The agreement.
Rightly or wrongly, there is some deed. If that deed is creating.
No, it was never registered. What is on the register in Form B of the part? I have produced the Form B as well. It's the only partnership deed which my lord will find at page 19. The original partnership, my lord, may kindly accept this argument. I'm stating a matter of fact. That's the only.
In this.
No, due respect.
The suit filed by you.
Yes.
You did plead that there was a reconstituted partnership.
I did plead that
As far as the excise authorities are concerned, they are not legal experts.
No. We actually challenged that deed as being illegal. That what was meant was that I will run the show as a managing partner and my.
Not your prayer, Mr. Mandian.
Sorry, it doesn't matter. The court. My lord will see. Now we have whatever it's worth. My lord has a order of the civil court. I mean, my lord, may I make this submission? One other submission, my lord will look at. Let's take, for example, I won't take more time. I hope friends can bear with me for another 2 minutes.
Have a division bench at 4 o'clock.
My lord, may I just short accommodation? On one point, I'll convince the court because it's a serious matter. It goes to the root of partnership law and whether partners can agree in this manner.
Wait, I'll finish the division bench and come back. I won't take more than 5 minutes.
ಸರ್ ಮತ್ತೆ ಬರ್ತಾರೆ ಪಾಸ್ವರ್ಡ್
ಈಗ 24 ಅಲ್ಲ
ನತಿಗೆ ಕತಮ್ಮ ಅದೇ ಬಂದಿರೋದು ಕಮಿಷನರು ಇದಲ್ಲ ಅವನಿಗೆ ಇವ್ರು ಪಾಪ ಅವ್ರ ಪಾರ್ಟ್ನರ್ ಆಗ್ಲಿಲ್ಲ ಅರ್ಲಿಯರ್ ಇವತ್ತು ನಾಟ್ ದ ಪಾರ್ಟ್ನರ್ ಇದ್ರಲ್ಲಿ ಪಾರ್ಟ್ನರ್ ಆಗಿ ತಗೊಂಡಿದ್ದಕ್ಕೆ ತಲೆ ಮೇಲೆ ಮಾಡ್ಕೊಂಡು ಒಬ್ಬೊಬ್ರು ಎರಡು ಅಲ್ಲ ಅವ್ನ ಪಾರ್ಟ್ನರ್ ಇರ್ಲಿಲ್ಲ ಮೊದಲು ತಮ್ಮನಿ ಕೆಲಸ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಪಾರ್ಟ್ನರ್ ಮಾಡ್ಕೊಂಡು ತಲೆ ಮೇಲೆ ಕುತ್ಕೊಂಡು ಈಗ ನನಗೆ ಎರಡು ಕೊಡು ಅಂತ ನಿನಗೆ ಒಂದು ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಡ್ತೀನಿ ನಿನಗೆ ಅಂತ ಹೇಳಿ ಮನೇಲಿರೋದು ನಾನು ಕೊಡ್ತೀನಿ ಬೇಡಂತೆ ನನ್ನ ತಮ್ಮ ಅಲ್ಲ ನಾನು ಇರ್ತೀನಿ ಅಂತ ನನ್ನ ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್
Court officer, sir. Court officer. Court officer. Sir.
ಕೋರ್ಟ್ ಆಫೀಸರ್ಗಳು ಇವರೆಲ್ಲ ಸೇರಿ ನನ್ನ ಪ್ರಕಾರ ಎಲ್ಲ ಕಡೆ ಲೇಡೀಸ್ ಇರಬೇಕು. ಸರಿಯಾಗುತ್ತೆ.
ಅಲ್ಲೇ ಇವಾಗ ಧಾರವಾಡದ ಹಿಂಗೆ ಅಲ್ಲಿ ಎಲ್ಲ ತರ ಗೊತ್ತಿಲ್ಲ. ನಾಳೆ ಗೊತ್ತಾಗುತ್ತೆ. Yes, to be made of, be made of. ಒಂದೇ ವಾರ. For pronouncement of orders, seal number 52.
In my view, since these are amendments regarding this interview petitioners in the present subject matter has been deliberately suppressed, it would be appropriate to impose cost while dismissing this petition. Consequently, this petition is dismissed with cost rupees 25,000 payable by each of the petitioners to the Karnataka State Advocates Clerk Association within a period of 4 weeks from the date of receipt of a copy of this order.
Seal number 53.
Appeal for respondent.
This petition is allowed. The petitioner is directed to pay a sum of rupees 3,86,43,475 at rupees 1,83,834 per square meter to the BDA within a period of 1 month from today. The BDA is directed to convey site number 1573/A in the first sector of HSR layout, Bangalore, measuring 210.21 square meter to the petitioner within a month of the petitioner paying the aforesaid amount.
Seal number 45.
Yes.
Just 2-3 things. My lord sees that 4th August 2010, that is the troublesome deed, which basically goes against the entire concept of a partnership. My lord will see virtually it's a dissolution, right? Virtually it's a dissolution. My lord will accept that fact. That was resonated in the order of the civil code. You cannot have something and call it a partnership. Either you're there or you're not there. You can't have a partnership and not be a partnership. My lord, that is the argument which found favor in the civil code, which I would say that makes, but my lord, 2-3 things have happened which I need to bring to the notice of the court. My lord will see, show me the compromise. The date is 4th August 2010.
Yes.
my lord will see, a day prior, the compromise. And very importantly, the date.
Is it different suit?
Yes, a day before. The compromise was done a day before this deed. And kindly look at the terms of the compromise.
This was the first suit.
Yes, the first suit. And very categorically stated that the 2000 partnership deed will be followed by both the parties. And when they went in for renewal of license on 16th, yes. So all is not what meets the eye. And my lord, for renewal of license, the affidavit of both brother and sister, kindly see, on 16th August,
Yes.
no mention of 4th August 2010. In that affidavit, filed on 16th August 2010, seeking renewal of license in the name of the firm. Kindly come to the Partnership Act, chapter dealing with dissolution of firms. It provides various modes of dissolution by efflux of time if the contract, the partnership deed provides for a time period for the venture, by act of parties, by agreement. And what is required to do under section 63? You need to file that dissolution and report it to the registrar so that he officially records it in his register. Kindly see the certified copy of the register of firms as it stands today. My lord will see on the right side, references made to the compromise.
Yes.
No reference to the 4/8/2010 deed. Nowhere have the parties accepted the 4/8/2010. Yes, in a suit where he should have sought for a declaration that 4/8/2010 is anathema and therefore void, which he did not seek specifically for obviously wrong drafting, but the court has rightly interpreted it as an anathema to the partnership deed. It is not reflected in the Form B. An affidavit is filed for renewal, stating that the 2000 partnership deed. And my lord, the renewal of a license in the firm can be only in the name of the firm. In a renewal proceeding, may I submit, my lord, with due respect, on a point of jurisdiction, my lord, on a statutory power vested in the excise commissioner or deputy commissioner of excise to renew a license. It is not the grant of a license. He is renewing a license which is already there. The rule 5A mandates that he should collect the fees and renew it. Either he renews it in the name of the firm or he rejects it. Is it open for him in a renewal proceeding to virtually issue 2 fresh licenses, though in the name of the firm? Virtually what he has done is he's issued licenses to 2 independent individuals, which is not contemplated under the terms. May I make this submission? I haven't referred to all the provisions of the Excise Act. My lord, the law is this. Today, if I'm running a partnership firm and I have a CL9 or CL2 license in the name of my firm, and one of my partners is exiting, and I reconstitute the firm with a new partner, the license cannot be renewed. I need to apply again. I need to pay the entire fees for license again. That is the law. It was done having one license. Partners would retire with the same license to avoid the payment of the license fee. Dealing with the excise authorities, they used to follow the procedure. Throughout the country, wherever excise license is issued in the name of the firm, where a partner retires and a new partner steps in by way of reconstitution, the license, excise license lapses, there can be no renewal. You will have to apply a fresh for CL2 or CL9 licenses by paying a huge fee, which runs into 4 to 5 lakhs of rupees. So it was curbed to avoid the payment of the fees. Now, what virtually has happened here is the excise commissioner has given complete go-by to the rules of excise law. He sat as a quasi-judicial authority, decided a dispute between 2 partners of a partnership firm as though he is a civil court. He has renewed the license in the name of the firm, but by a subsequent qualification said that one license virtually would be run by one partner and the other by another partner, virtually giving independent licenses to others. Kindly see the ramifications it has. I have a GST in the name of the firm. I need to know what sales goes on. I have no clue as managing partner of the firm of what is going on in the wine store run by my sister. I'm paying taxes. I'm paying income tax. The firm is assessed for income tax purposes. I need to disclose my income, not only from bar and restaurant, because firm is one entity. It's running two businesses. I also have to disclose income from my business in the wine store. I am not getting any details because under the cover of the illegal order, she has hijacked the wine store and running it without, under the name of the firm, without any accountability to GST, without any accountability to income tax. Look at the position I'm in. My lord, this is the bizarre consequences this order has resulted in. My only thing is this, my lord, there can be no two ways. If they want to go separate, like, I mean, beyond my client's interest or anybody's interest, virtually that 4th August 2010 unregistered deed, which is not even referred to in our own affidavit, virtually is a dissolution deed. My lord, only in a dissolution those partners share the businesses and say that this is mine and that is yours. If it is a dissolved firm, then the licenses go. Either the excise commissioner comes to the conclusion, if he's relying on 4/8/2010, then it has to be a dissolution and there can never be a renewal. It will be a loss for both sides. It cannot be a hybrid version as it presents itself today. My lord may kindly come and appreciate the argument. You cannot have a hybrid situation where you will have a license in the name of the firm and then run independently by two independent persons. That is my respectful submission. I've tried to understand these concepts. I have provisions all out dealing with reconstitution of the partnership firm where you will have to apply afresh by paying the license fee for CL2 and CL9 licenses. All that is given a go by this hybrid order where the renewal is in the name of the firm, but with a catch that the two businesses will be run as independent businesses. The deed is not reflected in the Form B register. And my lord, my submission to the court is, if that deed is to be recognized today, if my friend says, I stand by the deed, the firm is over. There's nothing to be renewed. It is I'm very clear on this, my lord, the position, the law has to take a stand. If he goes by 4th August 2010, the firm is over. Either the firm stays or the firm dissolves. If my friend relies on, let me put it openly, if my friend relies on 4th August 2010, then there is no firm. The deputy commissioner either issues a license in the name of the firm or does not issue or renew the license in the name of the firm. He cannot adopt a hybrid situation, which in the way it has been presented today.
Okay, that is the ideal solution. You also don't stand by 14/8.
That is unfortunately, may I make the submission to the court? Let my friend take instructions and come back.
Say that the firm stands dissolved according to your submissions. Both of you will not be entitled to license.
That is the unfortunate. My lord was very right. Unless my friend is able to tell the court that 4/8/2010 is void, then no problem presents itself. Let him take instructions and report to the court. That's all, my lord.
Is not aware, my lord. But last time kindly reconsider. He says 2010 partnership. He was not a partner at all. In 2010, he inducted as partner. My lord, his sister is doing the business along with some other partners. Earlier he was partner and he lost, he made the loss, heavy losses and removed the partnership. Then, my lord, he was unemployed. Then sister called him. He filed a suit with not as a partner in the earlier suit. He filed a suit. Then without my consent partnership deed ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ನನ್ನನ್ನು ಪಾರ್ಟ್ನರ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ನನ್ನ ತೆಗೆದುಹಾಕಿದ್ದಾರೆ. That is the case. That is not the partner. Then courts ಅವಾಗ ಅಲ್ಲಿ ಮೊದಲು ತಾಯಿ ಅತ್ತ ಬಂದು ಹೇಳಿದ್ರು ಬೇಡಪ್ಪ ನಿನಗೆ ಕೆಲಸ ಇಲ್ಲ ನಾನು ನೋಡ್ಕೊಳ್ತಾ ಇರೋ ನನ್ನ ಜೊತೆಲಿ ಬಾ ಅಂತ ಹೇಳಿ ಈ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಮಾಡೋಣ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿ ಅವಳೇ ಹೇಳಿದ್ರು ನಾನು ಈ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಸೇರ್ಕೊಡ್ತೀನಿ ಅಂತ. ಈ 2010 ಅಲ್ಲಿ ಇಂಡಕ್ಟೆಡ್ as a ಪಾರ್ಟ್ನರ್, ಇವನು ಅರ್ಲಿ ಪಾರ್ಟ್ನರ್ ಅಲ್ಲ, ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಇರ್ಲಿ, ಇವನು ಪಾರ್ಟ್ನರ್ ಇರ್ಲೇ ಇಲ್ಲ. ಇಂಡಕ್ಟ್ ಪಾರ್ಟ್ನರ್ ಮಾಡ್ಕೊಂಡು ನೀನು ಮ್ಯಾನೇಜ್ ಮಾಡಿ ನೋಡಿ ಆಫೀಸ್ಗಳಿಗೆ ಹೋಗೋದನ್ನ ನೋಡ್ತಾ ನಾನು
ನೀವು ಹೇಳ್ತಾ ಇರೋದು if you go by, if you ignore 14/8/2010, the original partnership will revive. To which you have not applied.
ಈ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಬಂದಿಲ್ಲ ಅಷ್ಟರಲ್ಲಿ.
The 14/8/2010 partnership deed goes. The original partnership revives.
Not a partner at all.
All right.
No, I'm sorry. Kindly, on facts, my lord, 1 minute. One minute. No.
Same order. ಇಬ್ಬರು ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದ್ರಿಂದ ಇನ್ನೂ ಸಪರೇಟ್ ಲೈಸೆನ್ಸ್ ಇರೋದ್ರಿಂದ ಸಪರೇಟ್ ಕೊಡ್ತೀನಿ, ಇಬ್ಬರು ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಕೊಡ್ತೀನಿ. ಕಮಿಷನ್ ಸೇಮ್ ಆರ್ಡರ್.
My lord may see 19, page 19 is the 2000 partnership deed. He's lying through his, I'm sorry to say this, through his teeth. Kindly see the partners on the partnership deed. Kindly see the partners on the partnership deed at page 19. Page 19.
Yes.
Page 19. 1 minute, sir. 1 minute.
Yes.
This is the 2000 partnership deed, and both brother and sister are the partners. So that, this is what is reflected in the Form B which my lord saw. And this is what is referred to in the affidavit for renewal filed after the, in 16th August. So therefore, my lord, let him take instructions.
Annexed my lord. Annexed one, for a moment, page page number 37, annexed reconstituted partnership deed. Sagar, MS Sagar, incoming partner. He was not a worker, he was not a partner at all. He is incoming partner, and Srimati Shailaja is the continuing partner. Venkata he removed. On placing retiring partner.
Reserve.
And more, in one more submission, my lord. This matter is already challenged in the upcoming KT. And KT ಎಲ್ಲ here record ಕಲ್ಕೊಂಡು final argument ಹಾಕಿದ್ದಾರೆ. It is pending in the KT.
So,
Grateful.
Number 46.
Petitioner. Both the petitioner and respondent number 2 is getting settled, madam.
what is the offense?
The offense is under 504, 506, my lord.
First complaint yardo?
First complaint has been raised by the respondent number 2.
Yes, sir.
Soumya. Counter complaint has been raised by the petitioner.
No petitioning. Where is the counter complaint? This petition is in relation to frame 399/2017.
Please, my lord.
Which is your counter complaint? With the NR.
Madam. CC number 4343 of 2019. FIR is at document number 8.
This is a complaint by one Ramesh. Either complaint. ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
Please, madam.
ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 8ಗೂ ಈ ಕ್ರೈಮ್ಗೂ ಏನ್ ಸಂಬಂಧ?
My lord, here, my lord, an FIR has been lodged against the said persons against under section 420, my lord.
By whom?
They all the persons were working under in the same company, my lord.
Who is the accused there?
Lord, sir. Accused is both, my lord, the petitioner and the second respondent, my lord, the accused number 2 and accused number 4, my lord.
You are also an accused there.
Please,
But this petitioner was not an accused there.
When the
Petitioner was not an accused.
even the petitioner was also an accused.
ಎಲ್ಲಿ ಬರೀ 4 ಜನ ಇದಾರೆ.
Petitioner was not an accused in that. The second respondent was an accused, my lord.
You have a copy of that complaint in CC number, in crime number 6/2018?
I have not yet produced that. I have not produced that.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ? Yeah.
No,
What is the complaint about? The counter complaint that was lodged, but this is in 2017 and the 2018.
My lord, counter complaint was lodged against the said person, my lord. That is for the reason that, my lord, she is harassing unnecessarily, my lord.
ನೀವು ನೋಡಿದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ನೋಡಿದ್ರಲ್ಲ ಹಂಗೆ ಹೇಳ್ತಿದ್ದೀರಾ?
No, my lord, she has demanded the amount with the petitioner, my lord. The respondent number 2 has demanded the amount with the petitioner, and she was harassing by filing unnecessary complaint against the petitioner, my lord. For that reason, my lord, the petitioner has raised a counter complaint against the respondent number 2, my lord.
You produce that complaint, let us see.
Please, my lord.
Because if you do not compound the offense there, she'll be nowhere. You compound the offense, then come back here.
Please, my lord.
Realist. Or file a criminal petition challenging those proceedings. You ask him to file a criminal petition, let both of them club together and then it will be disposed of.
Please, my lord, we'll submit it.
Number 47.
Petitioner.
My lord, there are 3 petitions, my lord.
Here on behalf of the respondent, 2 minutes.
Yes.
My lord, these petitions are
There is some
filed.
inconvenience today.
Lord,
Yesterday ಇವತ್ತು ಹಾಕೊಂಡೇನ್ರಿ?
please, my lord, this matter has been listed for the past 3 occasions, 4 occasions before, my lord.
What is the complaint?
My lord, this complaint, I mean, this is a classic case where a civil dispute has been given a criminal cloak, my lord. My lord, the 3 petitions, my lord, all the 3 petitions emanate out of the same FIR and the complaint, my lord. The first petition, my lord, 790, was filed when the FIR was registered, my lord.
790.
Please, my lord. My lord, then 2197 was filed when the charge sheet was filed, my lord. And 4337 has been filed because summons has been issued against the petitioner, my lord.
All arising out of the same.
Arising out of the same complaint and FIR. My lord, as I said, my lord, these are all arising out of certain civil disputes. For ease of reference, may I just pass on one list of dates which would detail out all the list cases, my lord?
May I submit, my lord?
Yes.
My lord, senior is unable to be present before the court, my lord. Senior's wife is undergoing.
My lord, the list of dates which I have just produced, my lord, it would show, my lord, the disputes start from 2010. What has happened is, my lord, the respondent number 2 purchased a property from the petitioner's company, a company from where the petitioner is chairman. And my lord, there was an easementary rights agreement for access to the main property. So, my lord, a easementary rights agreement is entered into between the petitioner and the respondent number 2 company, my lord. My lord, I have also produced the list of set of documents which would.
Where are the allegations in the complaint?
Please, my lord. My lords may kindly turn to the complaint, my lord, which is produced at Annexure A, my lord, at page 17. My lords have it, my lord.
Yes.
My lord may kindly turn to page 20, my lord, wherein the civil disputes have been named, my lord, and it has been mentioned. My lords may kindly turn to page 20, man, of the complaint. My lords have it, my lord.
Yes.
My lord may see paragraph 11. It says, my lord, it is submitted that the complainant company has purchased 51 acres, 31 guntas from Sammy's Dreamland, of which the accused is the chairman, through 3 registered sale deeds for a total. So, my lord, it all emanates from this, my lord. The property is purchased from me. Thereafter, my lord, please turn to paragraph 12, my lord, at page 22. My lords have it. Paragraph 12 at page 22, my lord.
Yes.
My lords may kindly see, my lord, the fourth line. Since the lands of the complainant had no access to the main road, being national highway, the company of the accused along with other landowners, namely so and so, had transferred the easementary rights above the said agreement over a 50 feet connecting road of the complainant up to NH7 for ingress and egress of the complainant and any other person claiming through it for all kinds of traffic, including pedestrian traffic. My lord, the complainant, with the consent and approval of the accused and other grantors in the agreement, has put up a concrete arch. It all starts from there, my lord, in order to display its ongoing project. My lords will see it at the bottom of that paragraph. For the location and proper identification of the entrance, my lord. Then, my lord, may kindly turn over leaf, page 23, paragraph 13, my lord.
Yes.
My lords will see at the last 5 lines, the complainant was then inevitable and compelled to approach the Honorable Court seeking a relief of injunction in OS number. This court, by an order dated, is pleased to direct the parties therein to maintain status quo till further orders with regard to the signboard, Embassy Boulevard over the arch. It all starts from that, my lord. A signboard was put up and there was some dispute arising out of that signboard put up, my lord. My lord may kindly turn to kindly look at paragraph 14. It is respectfully submitted that the persons of the accused company had been inspired making frequent and hectic efforts to disturb and encroach upon the signage of the complainant over the arch. The complainant was therefore once again constrained to approach this honorable court.
The suits.
My lord.
What happened to the suits?
My lord, there are the first suit was filed by the respondent number 2, my lord. In that, there is a status quo order with regard to the signage, my lord.
Then what about this OS 632/17?
Please, my lord.
There's one more suit referred.
Please, my lord. First suit is OS 327 filed by embassy against the petitioner herein. There is a status quo, my lord, in that. Thereafter, embassy files another suit against Sammy's Dreamland, my lord. In that, there is no order as such because again they challenge the the relief sought by them is to permanent injunction restraining me from removing the unipole and the hoardings put by them. My lord, I've just passed on a list of documents with the suits, my lord. Then, my lord, another suit is filed by me, wherein I seek for an order restraining the defendants from preventing the plaintiff from putting up signage because they were preventing me from putting my signage in front of my property. There is an interim order granted in that particular suit, my lord, wherein the court restrained the respondent number 2 herein from preventing me.
This fight is about mentioning of the word court cases there. That is the only complaint.
That is the allegation. They say that there is court cases because of which their customers were turned away, and that has led to them filing this complaint. Is what the allegation is, my lord. No other. There is no ingredients made out for cheating or any other offences, my lord, as detailed. They say cheating and mischief, etc., my lord. No offences, no ingredients at all made out. there are about 3 suits, 1 miscellaneous appeal and a writ petition, my lord. These are all the litigations pending between the parties.
You obtained an injunction in OS 632/17.
Please, my, in OS 632, I have an interim order, my lord, in my favor, which was challenged by them in a miscellaneous appeal, wherein the court orders the status quo, my lord. From there, a writ was filed by me, challenging the order. In the writ, the court says, both of you put up votes independent of each other. So these are the allegations, my lord. It's
Yes.
clearly a civil dispute.
Yes,
My lords, we have engaged the senior counsel.
yes.
May I pray for a week's time, my lords.
You want a senior counsel for this?
My lords, we have been given instructions from the company, from the
May I also place a list, my lord, of authorities which would so demonstrate that civil dispute
Friday for the consideration.
May this pass this on. I'm so grateful.
grateful.
My lord, there's an interim order operating, my lord.
Passed over matters.
Lord, so sorry.
Seven.
ಬೆಳಿಗ್ಗೆ ಅದು ಹಾಜರ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಕಳ್ಸಿದ್ರಿ. It has been done, my lords. I have 2 submissions to make, my lord.
ಅಲ್ಲಿ ಇದೆಯೋ ಇಲ್ವೋ?
ಇದೆ ಖಾಲಿ ಇದೆ, ಅದು ಬರ್ದಿದ್ದಾರೆ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ.
I think I would impose costs on him.
My lords, I want to make one submission. ಅವ್ರು ಕೊಟ್ಟಿರೋ photographs ಅಲ್ಲಿ ಬೆಳಿಗ್ಗೆ ಮೇಲ್ಗಡೆ 29/6/2024, ಕೆಳಗಡೆ ಇರೋದು 26/7/2024. ಕೆಳಗಡೆದಕ್ಕೆ ಡೇಟು ಟೈಮು ಎಲ್ಲ ಇದೆ, ಮೇಲ್ಗಡೆದಕ್ಕೆ ಯಾವುದೂ ಇಲ್ಲ. My lords, ಆಮೇಲೆ ಮೇಡಮ್ 1 ನಿಮಿಷ, ಲೆಟ್ ಮಿ ಮೇಕ್ ಮೈ ಸಬ್ಮಿಷನ್. ಆಮೇಲೆ ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ಈ ಹಿಂದೆ ಮಳಿಗೆ ಹೋಟೆಲ್ ಗ್ರ್ಯಾಂಡ್ ತಾಜ್ ಇದ್ದು, ಪ್ರಸ್ತುತ ಮಳಿಗೆ ಖಾಲಿ ಇರುತ್ತದೆ.
ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರಾ?
ಆಲ್ಸೋ ಮೇಲೆ 1 ಸಬ್ಮಿಷನ್. ಈ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಆ ಮೆಜರ್ಮೆಂಟ್ ನ 14/25 ಇರೋದು 13/7 and 24/10 ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಅಲ್ಲೇ ಹೇಳಿದ್ವಿ, ಇಲ್ಲ ಸೈನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ವಿ.
I'll have it next Friday for further consideration. See that the license is granted to him by next Friday. Release down. Ask him, this is not the way to push people to court. If I make one statement about his conduct, what will happen?
Like there be a direction, my lords, by that time.
What ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ. Next Friday. By next Friday it should be renewed.
Shifting on.
By next Friday, you should grant him permission. Or else they'll proceed to pass orders on merits and making strictures against him. By next Friday. Business ಇರಲ್ಲ 15 ದಿನ ಅಲ್ವಾ ಅವ್ನಿಗೆ? Can you continue the same shop now, existing shop?
ಬೇರೆ ಜಾಗದಲ್ಲಿ ಇದ್ದಾರೆ, ಇಲ್ಲಿಗೆ ಶಿಫ್ಟ್ ಆಗಬೇಕು. Because I've been permitted, my lord. That is annexure B.
Can he continue in the earlier shop till 15 days?
My lord, kindly, my lord, 6. Annexure B, my lord. Annexure A, ಒಂದೇ ಒಂದು ನಿಮಿಷ. Annexure A.
ಏನ್ ಬೇಕು ಅವ್ರು ರಿನಿವಲ್ ಮಾಡ್ತಲ್ಲ ಬಿಡಿ.
Shifting, my lord.
Number 15.
Date
9.
But I give to the respondent. They have accepted the DD.
Accepted DD.
But
Along with memo, I am filing the acknowledgement.
Last paragraph ತೆಗೆದ್ಬಿಟ್ರಿ. Last paragraph ತೆಗೆದ್ಬಿಟ್ರಿ. Last paragraph ಬೇಡ. Subsequently, the matter was ordered to be relisted at 4:30 to ensure that BDA receives the demand draft. The counsel for the petitioner has filed a memo acknowledging the letter by which the demand draft dated 29/4/2024 has been handed over to the Secretary BDA.
Deputy Secretary.
Secretary BDA. The mortgage surety also acknowledges that the demand draft has been received and the same would be encashed.
This would be without prejudice to our right of filing an appeal.
Needless to, I've already said that, isn't it? And its encashment would be subject to the result of the writ appeal.
Please, oblige.
The application according disposed of.
Bill number 51.
Circular minutes has been prepared, which they will just.
Solve ಆಯ್ತು ಆಗ್ಲಿಲ್ವಾ?
ಸಾಕು ಈ ತರ ಇದು ನಮ್ಗೆ NEFT.
Along with the screenshots, Malots, it is there.
We'll record this, close this. Draft ಅಂದ್ರೆ ಯಾವಾಗ ಕೊಡ್ತಾರೆ circular, regular circular?
Malots, they will do it, Malots. Malots, it will have to be, Malots, the place before the Honorable Chief Justice, and then they will do it.
Here in this petition is for issuance of amendments to respondents to frame appropriate rules regarding deposit of amounts, including the award amount, to be paid as per the awards of the tribunal. And prayer is also made to make it mandatory for all the claimants to produce Aadhaar card and details of bank. ಅದ್ರ ಮೇಲೆ ಹೇಳಿದಿರಾ ನೀವು?
ಅವೆಲ್ಲ ಬೇಡ. Those things may not be required. Now it is made mandatory that.
Council for. The one of the main prayers in this petition is for issuance of direction to frame appropriate rules regarding deposit of the amounts payable under the awards made by the MACTs, which are challenged before this court. It was a grievance of the petitioner that there is no provision under the existing system to enter the details of the case in respect of which the deposit was being made. The Rajendra appearing for the High Court has today placed on record a draft circular in which the provision is made for entering the details of the person depositing the amount. And this would enable an online payment of online deposit of the amounts payable under the awards of the court, which are required to be made statutorily before filing an appeal. See, in Krishna and Council appealing for the petitioner submits that with the issuance of this draft circular, the grievance of the petitioner stands satisfied. So recording the said submission and directing the High Court, directing the respondents to issue regular circular in terms of the draft circular which is now issued, the writ petition is disposed of.
Much.
Okay, time frame ಬೇಕಲ್ಲ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಮಾಡ್ತಾರೆ.
Complaint, Lordship's order is come.
In case ಬಂದ್ರೆ ಗಾಬರಿ ಆಗುತ್ತೆ.
ಇಲ್ಲ, I'm so sorry, my lord. My learned friend prevailed upon. He did all the
Before he
efforts.
starts arguing, do something or else he's not going to stop.
So sorry.
We
if I
tried our
failed.
best. In fact, RLDC
Grateful
had
that
made.
Lordships directed it. in time.
48.
ಯಾರು ನಿಮ್ಮ opponent ಯಾರು?
48 final hearing first matter. Short matter, my lord, involves only 2 points.
5 ಗಂಟೆ ಆಯ್ತು.
Short matter.
If
Short matter.
everybody agrees it's a short matter which can disposed of, I'll take it up.
Please.
ಆಗುತ್ತಾ?
Actually, short point, ಒಂದೇ point.
ಒಂದೇ point
That is
ಅಷ್ಟೇ.
the multiple sanction order ಅಂತ.
Whether it is maintainable or not, ಅಷ್ಟೇ.
Take a lot.
Twice, my lord, sanction rejected. A third time, my lord, they have given sanction on the same percentage of disproportionate.
ಜಾಧವ್ ಅವ್ರು ಮಾಡಿದ್ದಾನೆ. Remains in your case.
Your lordship, if your lordship permit, I wanted to make a small mention in serial number 40. The other side advocate is also logged in. Your lordship ordered DC to calculate compensation by considering it as non-agricultural land. Your lordship, in the prayer, we sought the fact that they have to consider the compensation as per the rates prevalent today, because they're giving the compensation today. If that aspect can be clarified, your lordship, otherwise again, it will lead to ambiguity before the DC.
I admit that correction.
Yes, grateful.
My lords, short synopsis, my lords.
In this case.
Hold on. Lord, a case came to be registered. Lord, under section 13(1) read with 13(2) of the Prevention of Corruption Act, alleging that Lord, the petitioner who was working as inspector at the relevant point of time was possessing 154% disproportionate assets to the known source of income. Lord, the investigation was conducted and charge sheet came to be filed on 21/6/2016, and alleging that Lord, he is possessing 144.88% disproportionate. Thereafter, an application was filed for grant of prosecution that came to be rejected. Second application filed that is also rejected. But thereafter, Lord, second charge sheet, additional charge sheet came to be filed on 2/1/19, alleging that disproportionate assets to the tune of 149.5%. But the only contention, Lord, that is raised in the present petition is that, Lord, when the disproportionate asset was 144.88, it was rejected, sanction was rejected. When it became 149, Lord, sanction came to be rejected. That apart, Lord, state has no power to review its earlier order of rejecting sanction. But that is covered by Lord, 3 decisions.
Where is the order of sanction? The first order rejecting sanction.
But rejected order, not on page, first order, that is on page 159, please note.
159.
159. For the first, second paragraph, ultimately, they have referred to facts. 159. ಈ ಬಗ್ಗೆ ನೋಡಿ your lordship will find relevant is 160. ಈ ಬಗ್ಗೆ ಸದರಿ PI ಅವರು ಉಲ್ಲೇಖ 3ರಲ್ಲಿಯ ಮನವಿಯಲ್ಲಿನ ವಾದವಾಂಶಗಳನ್ನು ಹಾಗೂ ತನಿಖಾಧಿಕಾರಿಗಳ ವರದಿಯನ್ನು ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಿದ್ದು, ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರದ ಅಧಿಕೃತ ಜ್ಞಾಪನದ ಕ್ರಮ ಸಂಖ್ಯೆ ನಂಬರ್ 4ರ ಪ್ರಕಾರ ಅಭಿಯೋಜನಾ ಮಂಜೂರಾತಿ ನೀಡುವ ಬಗ್ಗೆ ನನಗೆ ಸಾಕಷ್ಟು ಆಧಾರಗಳು ಇವೆ ಎಂದು ಮನದಟ್ಟು ಆಗಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದರಿ ಇವರ ವಿರುದ್ಧ ಅಭಿಯೋಜನಾ ಮಂಜೂರಾತಿ ಆದೇಶ.
This was after the charge sheet was filed on 21/6.
Yes, no, yes, 21/6/16, but charge sheet was filed on the basis final report. On the basis of that, no sanction was sought, and that came to be rejected by order dated 159.
Then despite this, they filed a second charge sheet?
No additional charge sheet was filed subsequently. No. In spite of not there being an order of rejection.
No, the second application was also in consonance with the
That
first.
is also rejected, second application.
Second application is 2017.
But first sanction rejected, second sanction rejected.
The second sanction was before the second charge sheet.
Yes.
So the reasoning of the first order, second order are more or less the same.
Yes.
After an additional charge sheet is filed, they have found different reasons to grant permission.
Yes.
Where is that order?
That is third application, that is page 157. Relevant is not 157. It starts from 153, not relevant is ultimately, but Adesha. ಆರೋಪಿತ ಅಧಿಕಾರಿಯಾದ ಸೋಮ್ಲಾ ನಾಯಕ್.
Is there any reference to the first refusal?
No.
No reference.
No reference. Look, 26/16. Look at the road ಕಾಯ್ದೆ ಇದೇನಲ್ಲ. No reference to Lord order of rejection.
Now, my lord, coming to my lord, the third order, granting sanction, page 157.
The difference is only 4%.
There's no reference to the rejection of the first request
No,
That senior complaint is there.
in the order.
But it is there in the subsequent order. The second order which senior is reading page 164, it is not a rejection. The that officer says that I am not the competent.
No, not the second order, the 10/11/2018 order. 10/11/2018 order, page 157. This is the order granting sanction now. On the third application. First two applications you rejected.
oh,
Not rejected. The person says that I am not the competent person. DGP East says I am not the competent.
page 164. ಈ
ಅಭಿಯೋಜನ-
ಕಚೇರಿಯಿಂದ ಈಗಾಗಲೇ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ
Page
ಅಭಿಯೋಜನ
number 159, ಅಭಿಯೋಜನ ಮಂಜೂರಾತಿ ಕುರಿತು. Page number 159. When the first request was rejected, it was a grant of prosecution only, grant of sanction to prosecute.
Yes, ma'am. But here he says that this sanction order, there are two other defects. I will come to the
No, I'm asking you as a matter of fact. The request for grant of sanction to prosecute was rejected on 2012-2016, the first one.
Yes.
At which point of time only the first charge sheet had been filed.
ಹೌದು
Subsequently, the second charge sheet was filed on 2/1/2019.
ಹೌದು
In the meantime, a second application was also filed on 9/8/2017.
and that was also rejected.
Second application.
2017, but it is not a rejection. This officer says I am not the competent.
No, we will ignore the second order, but the first order was a refusal to grant sanction.
Yes,
Now the order that is passed on 10/11/2018, granting sanction to prosecute. In that, is there a reference to the first order by which the
The rejection.
sanction to prosecute was rejected
Is there?
on
It is there.
2012-2016? ತೋರ್ಸಿ ಅದ್ರಲ್ಲಿ
Page 153, but reference item number 3.
page.
153. That's where it starts, reference item number 3.
How has it been dealt with?
But this is addition, this is based on additional material.
No. Yes, as the rejection been considered,
Not,
while granting, let's assume that you have the power to grant sanction for the second time when a request is made. You should first get over the refusal to grant permission, isn't it?
That case not goes, I do not see immediately, not answer to this question. But I do not see immediate reference, not except that the order is referred in the reference. But he would refer to additional materials provided at page 155. And
No, the entire investigation material was perused. And it was found it was not a fit case of prosecution.
the earlier stage,
2016.
yes,
We will assume that you found additional materials. The question is whether you could go investigate further after this rejection was made, that is another aspect.
yeah, it is perfect, yes.
Second time, when you sought for sanction, if the earlier rejection is not even noticed, would this,
Please notice the reference.
in the reasoning, reference ನೀವು ಹಾಕೊಳ್ತೀರಾ? In the order,
Second unnumbered paragraph, not in the same page 153. ತನಿಖಾಧಿಕಾರಿಗಳ ಉಲ್ಲೇಖ ಎರಡರಂತೆ ಅರ್ಜಿಯ ತನಿಖಾ ವರದಿಯನ್ನು ಅಭಿಯೋಜನಾ ಮಂಜೂರಾತಿ ನೀಡುವ ಬಗ್ಗೆ ಸಾಕಷ್ಟು ಆಧಾರಗಳು ಇವೆ ಎಂದು ಮನದಟ್ಟಾಗಿವೆ ಎಂದು ಇರುವುದರಿಂದ ಅಭಿಯೋಜನಾ ಮಂಜೂರಾತಿಯನ್ನು ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ನಿರಾಕರಿಸಲಾಗುತ್ತದೆ.
now how does deal with the second request after the rejecting? Where is the reasoning for him to say that notwithstanding my early rejection, I have now secured more material is placed before me, we justify sanction?
Nobody wants to, but it says
Just reiterating the factual aspects will not, until he gives a reason, would it be valid order of sanction?
With respect to it could be valid, but the reason not under section 19 sanctioning authority. But there are judgments to say that the sanction order itself need not be reasoned at all. But he will give the reasons in the witness box. But that is how not the law has developed for freedom or
PCA.
judgments. Or
I want to read section 19 first.
over various judgments, that is how law has developed. That if the sanction order does not speak about generally not questions are doing, you did not apply your mind, you are not the sanctioning authority, all the matters are not placed before you. But so that to that extent, Lord, this order, order at page 153, my submission it is in accordance with law. Even though Lord, what my Lord said, that phrase regarding Lord, why the earlier sanction is rejected, how this sanction is better than the other, that reasoning is not found Lord, in this order. But that has to be not in my respective submission, subject matter.
Right from 1979 Supreme Court. Now the Honorable Supreme Court as well as not this Honorable Court have repeatedly, consistently ruled that the sanctioning authority must apply its mind and it should not be mechanical, and non-consideration of material law would amount to injustice. So many series of decisions. And now my learned friend makes a statement saying that he can cross-examine, he can be cross-examined at the stage of trial. Why should we not undergo this ordeal of trial? Not even assuming not that the first charge sheet, second charge sheet, difference is only 5%.
What are the rulings that you rely upon? What are the rulings that you rely upon?
Yes, but I have filed along with the memo. Just now furnished. But page 3, para 9. In the instant case, it is to be noticed that the initial stage, the competent authority, after perusal of the material placed before it, had refused to accord sanction in view of the facts and circumstances of the case, as observed in the order dated so and so. But however, the sanction order dated reveals that the order, after forwarding of the material by the Additional Director General of Police, the sanction came to be accorded. Such a view was not permissible in view of the law laid down by so and so.
What is the second decision?
Second decision that your lordships will find, but page 6, para 9, page 9, page 8, page 9, para 6. Although the state in the matter of grant or refusal of grant sanction exercise statutory jurisdiction, the same, however, would not mean that the power one exercise cannot be exercised once again. For exercising its jurisdiction at a subsequent stage, express power of review in the state may not be necessary, as even such a power is administrative in character. It is, however, beyond any cavil that while passing an order for grant of sanction, serious application of mind on the part of the authority concerned is imperative. The legality and order of validity of the order granting sanction would be subject to review by the criminal courts. An order refusing to grant sanction may attract judicial review, so and so.
According to Supreme Court, they can review the order for granting sanction to prosecute.
Only if not the number one is not, it should apply its mind. As my learned friend said, the application is not necessary, you can cross-examine. Some and substance.
What is the third order?
Third one is not your lordships will find. Page 19, para 13. In our opinion, a change of opinion per se on the same material cannot be a ground for reviewing or reconsidering the earlier order refusing to grant sanction. However, in a case where fresh materials have been collected by the investigating agency subsequent to the earlier order and placed before the sanctioning authority, and on that basis the matter is reconsidered by the sanctioning authority, and in the light of fresh materials, an opinion is formed that sanction to prosecute the public servant may be granted, there may not be any impediment to adopt such course. In so far as the present case is concerned, it is not even the case of the applicant that the fresh materials were collected by the
They say that they collected fresh materials.
Pardon?
Do they say that?
No, they say that there
Yes,
is
yes.
fresh material, but that is not correct. In fact, Lord, those materials were already the subject matter of the
Investigation.
first charge sheet.
Permission taken for further investigation after the filing of the charge sheet?
But that is not available, and my instructions are, they are not taken ಹೇಳ್ರಿ ಹೇಳ್ರಿ ಹೇಳ್ರಿ
Information is not.
Not there.
Whether permission was taken or not.
No.
Not my
At
mistake.
the stage not before this 2019, but generally permissions were not taken. But let me be not clear on that part. Generally permissions were not taken, but subsequently by again not by virtue of the federal judgment, we have started taking permission whenever we are doing. In all charge sheets, I can say with certainty, but this also I look at and I will submit. In all charge sheets, there is a general disclaimer, preemptive disclaimer saying we will do further investigation. ಅದು ಎಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಇದರಲ್ಲಿ PC Act ಅಲ್ಲಿ ಅಷ್ಟೇ ಅಲ್ಲ, all other crime IPC charges. So even after conviction you can still go ahead and make a further investigation. That 173 after an acquittal also you can go to open 173(8) ಅಲ್ಲಿ that is available.
ಒಂದು ವೆಪನ್ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ, ವೆಪನ್ ಫಾರ್ ಹರಾಸಿಂಗ್ ದಿ
Document as a shortage. All that cannot be not CPC. It cannot be submitted. It has to be by way of additional. So your investigation can go on endlessly. Theoretically, if I accept this argument. But 173. It's called a final report under the CRPC only because there must be some finality attached to it. Yes, yes. Therefore, the courts have evolved the principle that if you want to make a further investigation, you have to satisfy the court that there is something, some overwhelming circumstances. That is generally granted, yes. So if you have not obtained permission. That information. If you
I have information, it is
investigation. If you don't have material to show that you made an application on the basis of additional materials that you had secured. And keep in mind that the request was not made despite the refusal to grant you sanction. I will check that. Once there was a refusal to sanction, how can you go even for a further investigation? But whether further investigation you have sought permission or not, I place that. If you have not taken further permission, the matter goes.
not my instruction.
Not for the reason, but it could also not, even otherwise minus that not contention, even that. But this order itself, on its own standalone, section 19(3). But petitioner will have to demonstrate that there is failure of justice. By Supreme Court, I'll go by Supreme Court, it says if you, until there are fresh materials produced. Yes. To justify review of an earlier order, there is no question of granting a sanction after it has been rejected. Yes. For getting fresh materials, for making a further investigation, the law now requires that you will have to obtain permission. If you have not obtained permission, even if you have collected material, it would be of no consequence. I will have to get that.
That's exactly, my instructions are, but they did not seek any order of the court.
Even that is accepted by percentage. Even that is accepted.
But even assuming for a moment, the difference, when 144% was there, but they rejected. But subsequently, I'm sorry, subsequently 149% was there, but they granted. Difference is only 5%. It makes no difference actually. It is ultimately.
At length, it is noticed that the request for grant of sanction to prosecute after the charge sheet was initially filed on 21/6/2016 was rejected by the competent authority on 20/12/2016. It is argued that despite the refusal to grant sanction to prosecute, nevertheless, a second application for grant of sanction to prosecute was made, and that was also rejected on 9/8/2017. It is thereafter submitted that a third application for grant of sanction to prosecute was made on 10/11/2018. And though the first order of rejection dated 20/12/2016 is referred to, no reasons are forthcoming as to why the earlier order was liable to be reviewed. It is also not forthcoming as to whether after the refusal to grant sanction to prosecute, whether permission to make a further investigation was sought for and obtained by the prosecuting agency. So in that view of the matter, the counsel appearing for the respondent Lokayukta is directed to state as to whether any application for making a further investigation as contemplated under section 173 of clause 8 was made by the Lokayukta to the Sessions Court after the sanction to prosecute request was rejected on 2012-2016? If so, the said order shall also be produced, released on so and so for further consideration. Next, Fred. No, I want you to first tell me as to.
That question I'll answer. Second point, 9/8/2017. Page 160.
I'll say that it is, where is his contention? I will say it is his contention.
It is not a rejection.
No, I only want you to state as to whether you obtained. I said that this is contention. And I want to know as to whether you did obtain sanction for permission for making further investigation. I have not said anything else. Whatever he has said, I recorded. I want it for my satisfaction.
I'm very sorry, not for the.
Also, other aspects I'll make submission. Whether there is
Nanage, you satisfy me on this first before I
whether
permit you.
permission is taken or not. Even if it is not taken, but what is the effect on the investigation?
That I'll consider afterwards.
And also not only to reference and not like passing a judicial order, not overcoming the earlier order, whether he could have passed this sanction order or not, that also I'll satisfy.
So according to on the administrative side, I can pass any number of orders that I want without reference to the earlier orders that I have passed. I don't even have to refer.
But I am aware of my lord section 17 or where my lords have distinguished what is how much application of mind is required not on the administrative.
No, that is for
I will
approval.
answer from that perspective.
That is for approval to investigate. Here, after investigation.
Higher standard is required, but I am aware of that. That not perspective, I will convince my lord.
Objections.
Ninth August. ಆಗುತ್ತೆ. Announcement. Announcement, ಅದೇ dismiss ಆಯ್ತು. ಸರಿ, ಕೆಳಗಡೆ ಆಫ್ ಮಾಡೋದ ಇದು ಕಂಪ್ಯೂಟರ್ ಅದೆಲ್ಲ ಆಫ್ ಮಾಡೋದು ಇದೆ ಹುಚ್ಚಿಲ್ಲ ಅದಕ್ಕೆ ಅದೇ ನಾವೆಲ್ಲ ಆನ್ ಮಾಡ್ತೀವಲ್ಲ ಸಾಹೇಬ್ರು ನೋಡ್ತಾರ ಕಡೆ ಇದೆಯಲ್ಲ ಆಟೋಗ್ರಾಫ್ಸ್ ಅಲ್ಲಿ ಆಟೋಗ್ರಾಫ್ಸ್ ಹಳೆಯದು ರಿಕ್ವಿಡಿಷನ್ಸ್ ಅದು ನೋಡ್ತಾರ ಸಾಹೇಬ್ರು ನೋಡ್ತಾರ ಅಂದ್ರೆ ಅದು ಮತ್ತೆ ಅವ್ರ ಬ್ರಾಂಚ್ ಅವ್ರು ಕೊಟ್ಬಿಡ್ಬೇಕಾದ್ರೆ ಯಾವ್ದಾನ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಕೇಳಿ ಆಯ್ತು ನಾಳೆ ಗೊತ್ತಾಗತ್ತಲ್ವಾ ಬೇಕಾ ಬೇಡ ನಾಳೆ ಬೇಡ ಅಂದ್ರೆ ನನಗೆ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಅದೆರಡು ಮಾತ್ರ ಕೆಳಗಡೆ ಅದು ಯಾವ್ದಾರ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಕೇಳ್ಬಿಟ್ರೆ ಹಳೆಯದು ಅದು ಇದಲ್ಲೇ ಇರುತ್ತೆ
ಮೋಸ್ಟ್ಲಿ ಇರ್ತಾರೆ ಅಲ್ಲ ಇವತ್ತು ಈಗ ಹೋದ್ರು ಜಸ್ಟ್ 2 minutes.